Yes. For inclusion, please mention next week. You have taken many matters yesterday. Please mention next week.
90 and 91 for application.
What is the urgency?
Lordship petition is illegal manufactured property. Vehicle cannot be registered, Lordship. As a result of it, Lordship, entire manufacturing, distribution, and
We cannot upgrade matters now. Call on the list.
One mandamus appeal is very urgent, my lord. Kindly, my lord. One mandamus appeal is very urgent, my lord. Kindly, my lord.
Accordingly, Accordingly, FMAT 488 of 2025 is allowed on contest, thereby modifying the impugned order dated December 1st, 2025, such and such, to the effect that the respondents and other men, agents, and representatives shall remain restrained by an order of injunction from illegally trespassing into the suit property and/or from unlawfully obstructing the entry or access of the plaintiff appellant thereto, and/or from wrongfully interfering with the lawful possession occupation of the plaintiff appellant in respect to the suit property in any manner whatsoever till disposal of the temporary injunction application by the trial court. The respondents are directed to file their respective written objections, if not already filed, to the temporary injunction application in the trial court within 3 weeks from date. It is expected that the learned trial judge shall decide the temporary injunction application as expeditiously as possible, preferably within 8 weeks from the date of communication of this order, subject to the filing of the written objections by the defendant's respondents within the aforementioned period. Further clarified that the above observations are tentative in nature, shall not unduly influence the learned trial judge while deciding the temporary injunction application of the suit. Can also dispose of, no address to cause urgency. So that.
May I pray for stay of this order, my lord?
After the above judgment is passed, you are for which respondent?
Respondent number 1 to 3, my lord.
The respondent numbers 1 to 3, learned counsel for the respondent numbers 1 to 3 seeks stay of the operation of the said order. However, since the nature of the order is prohibitory, such prayer is refused.
Grateful lordship.
এখন সই করলাম না, একসঙ্গে লেটার ঢুকিয়ে করব, তাই তো? লেটারটা ঢুকিয়ে এখন সেই করতেই হবে পারে না।
Lord, I appear on behalf of the appellant, my lord. On last occasion, your lordship directed for written notes.
Yes. So you are for the appellants, right? We are closing arguments. We have already filed. Yes. The written notes of arguments filed by the appellants in all the appeals be kept on record.
2, 3, 4 your lordships have heard. 5 is, my lord, appearing separately. That, my lord, your lordship will have to fix a date for hearing.
5টা আলাদা করে দাও। 5টা আলাদা। ও আচ্ছা। In the cause title, আচ্ছা তাহলে in all the matters কথা লেখা দরকার। File today be kept on record. Process of hearing is concluded and the matters are reserved for judgment. 5 was not heard.
No.
একটা লাইন অ্যাড করে দিন। Let FMAT 297 of 2024 be detagged and listed for hearing. Listed for hearing. Will appear as soon as possible. 5টা আলাদা করে দেবেন, এটা শুধু 1 to 4, এই 2 to 4.
My appeal, your lordship, also for
one second. এই অনিন্দিতা আপনি না একটু লিখে দেবেন, 2 to 4 এর মধ্যে কিছু লিখে দেবেন, তাহলে যখন জাজমেন্ট আলটিমেটলি ছাপা হবে তখন আপনার সবকটার নাম ছেড়ে ওটা একটা দিয়ে পল্লবকে বলে দেবেন। সরি,
my appeal, although for withdrawal, I'd just like to indicate one point, your lordship.
Yes.
The memo of appeal is valued at rupees 60,100. The report is saying that it's not maintainable here. But I would request your lordship to kindly take the stay application once. Take the stay application once. Page 17 is my plaint, my lord.
Yes.
At page 18, the valuation is rupees 60 lakhs. So, my lord, there is a clear typographical error in the memorandum of appeal, which I find, your lordship. My lord, I found it yesterday night, your lordship, subsequent to mentioning. Otherwise, I would not have
Although the matter was mentioned for withdrawal of the appeal under the presumption that this court does not have pecuniary jurisdiction to take up the appeal, learned counsel for the appellant submits that upon perusal of the records, it transpires that the actual valuation of the suit is rupees 60 lakh, whereas the same was erroneously mentioned in the memorandum of appeal as rupees 60,100. Next para. Thus, learned counsel for the appellant seeks leave to rectify the memorandum of appeal and submits that the appeal is maintainable before this court only. Upon a perusal of the plaint annexed to the stay application, comma, we find substance in the submission of the appellants. Accordingly, the learned advocate on record for the appellants is granted liberty to rectify the memorandum of appeal insofar as the valuation statement is concerned, comma, to bring the same in consonance with the valuation given in the plaint of the suit from which the present appeal arises. Such correction shall be carried out during the course of the day.
Course of the day.
During the course of the day, this has not yet been admitted.
No, my lord.
Let the appeal be listed on August 4, 2026, under the heading Order for Rule 11.
I'm so grateful. my
Thank you, sir.
Well, 7, my lord, I appear for the appellant. Mrs. Chakraborty is appearing for the appellant.
In view of a relative of one of us, bracket আমার full name, appearing for one of the parties, comma, let the matter stand released from our list with liberty to the parties to seek assignment before a different bench from the Honorable the Acting Chief Justice.
My lord, I'm for the respondents number 1 and 2. My written notes is ready.
My lord, 10 minutes pass over, my lord. It has been prepared, my lord. Just
So we'll
15
grant you leave to file during the course of the day?
Yes,
File
please.
You are for the respondent.
I'm for the respondents 1 and 2, the plaintiffs in the suit.
Right. The written notes of arguments filed by the plaintiffs stroke respondent numbers 1 and 2 be kept on record, full stop. On the prayer of learned counsel for the appellant, comma, leave is granted to the appellant to file its her written notes of arguments during the course of the day. Full stop. Hearing is concluded and the matter is reserved for judgment.
Okay.
উনি ফাইল করলে তারপর Yes. First time none appears for the parties at the time of call. Let the matter stand adjourned till August 4th, 2026. সবকটাই একটাই ডেকে যান আমি একই অর্ডার দিচ্ছি সেম অর্ডার সেম অর্ডার same order, same order.
Lordship, I am appearing on behalf of the opposite party, Lordship.
Yes.
In this matter, the application before your Lordship is filed by the applicant for recalling of your Lordship's earlier order. What has happened in this matter? The probate proceeding was initially
The matter was dismissed for default.
It was dismissed for default by your Lordship. What they are doing is they are securing an interim order by your Lordship, and then they're going disappear. Till that, they have not filed any affidavit in reply also.
So what is CAN 7?
CAN 7 is for recalling of your Lordship's last order.
So basically for restoration.
Lordship. 7th of January order, they are seeking restoration. Today also they are not appearing.
None appears for the petitioner at the time of call. Full stop. As rightly pointed out by learned counsel for the respondents, comma, it was recorded in our order dated January 7, 2026 that on a previous occasion as well, comma, none had appeared for the appellant stroke petitioner, although the respondents were represented by counsel. Full stop. Due to non-appearance of the appellant, comma, the ad interim order granted initially had earlier been vacated and thereafter was reimposed. Full stop. However, comma, despite the same, comma, the appellant chose not to appear again. Full stop. Thus, comma, by the order dated January 7, 2026, comma, CAN 4 of 2025 as well as CAN 5 of 2025 were dismissed for default. Full stop. Next para. Even today, the appellant stroke petitioner chooses not to appear to move CAN 7 of 2026, which is an application for recalling the order dated January 7, 2026 and for restoration of CAN 4 of 2025 and CAN 5 of 2025. Full stop. In view of the habitual defaults of the appellant stroke petitioner, comma, we are of the opinion that no further lenience ought to be shown to the petitioner Full stop. Accordingly, can 7 of 2026 is dismissed or default without any orders to. Great. Deeply occurs. কি আগের দিনে ফার্স্ট করে 5 ওভার করে 28 পর্যন্ত অ্যাপ্লিকেশন গুলো ডেকে আবার ডাকবেন এটা 5 ওভার না থাকলে ফার্স্ট কলে 5 ওভার 28 পর্যন্ত তারপর আবার 5 ওভার ডাকবেন জাস্ট 5 ওভার
That's item 18. This is my appeal. If Milords may kindly have the last order first, Milords.
illness of advocate respond.
Milords, the last order reflects that the respondent number 1 to 3 have been served. However, Milords, what it transpires is that the respondent number 3 before the learned trial court was the predecessor of interest.
This was substantially effective.
Milords, in fact, it has to be from 1 to 7, just because, Milords, if I may explain, respondent number 3 before the learned trial court was the predecessor of interest of respondent number 3 to 7 in the present appeal.
Oh.
They had been substituted before the learned trial court, and the written statement was filed by.
So the previous order should read as respondent numbers 1 to 7.
Yes. And yesterday it was mentioned, Milord, for rectification.
Oh.
And service has been completed till 7. It has been completed.
Learned counsel for the appellants points out that in the order dated July 20, 2026, it was recorded that the respondent numbers 1 to 3 had been served, comma, whereas respondent numbers 1 to 7 have been served, comma, respondent numbers 3 to 7 being the heirs and legal representatives of the original respondent number 3. Full stop, next para. Thus, comma, the order dated July 20, 2026 be deemed to stand corrected to the effect that in the third line of the first paragraph thereof, comma, the expression double inverted 3 shall be read, the figure double inverted 3 shall be read as double inverted 7. Full stop, next para. You are ready with the application?
Yes, Milord.
Since we have already recorded that service has been effected substantially on the respondents, comma, but none chooses to appear for the respondent numbers 1 and 2. And as we find from the order dated July 20, 2026, that on the said occasion as well, comma, an adjournment was sought on behalf of the respondent numbers 1 and 2, comma, we take up the applications for hearing ex parte. Yes. What is scan 1 and what is scan 2?
Milord, scan 1 is my section 5, condonation of delay.
What is the delay?
Delay is of 161 days, Milords.
Reason?
The reason being the certified copy was applied, the impugn order is dated 24th of April 25. It was applied on 30th of April, and then it was received on 19th of June 2025. And thereafter, Milords, the pleadings as well as there are several deeds of conveyance and gift deeds that were in Bengali. So some substantial time was consumed to translate those copies into English. And thereafter, Milords, there was a settlement of this appeal and stay application, and we filed this
The
appeal.
translated copies have been annexed to the stay application.
Yes, Milords.
Otherwise, your ground would go.
It has been annexed.
Very. We find from the explanation furnished in Can 1 of 2026 that the filing of the appeal was delayed in view of some time being spent in obtaining the certified copy of the certified copies of the impugned judgment and degree, as well as in getting the vernacular documents, comma, which form the lion's share of the annexures to the connected stay application, comma, translating বললাম কি? being translated to English. Full stop, next para. Thus, comma, we are satisfied that sufficient explanation has been furnished for the delay in preferring the appeal, Accordingly, can 1 of 2026 is allowed, comma, thereby condoning the delay in preferring FAT 59 of 2026, full stop. The said appeal be deemed to stand registered and admitted. What is can 2? What is the appeal against? Can
This
2
is
is stay.
stay application.
What is the appeal against?
This appeal arises out of a decree where my suit for partition has been dismissed on the grounds of maintainability and determining the preliminary issue order 14 rule 2. That's what the learned trial court has held is that the suit property is a part of the work of estate, so civil court is having no jurisdiction. However, Milos, there are certain deeds of conveyances annexed to this instant application, which shows that my property that I'm claiming a partition of was never a part of the work of estate at all.
How do we know that you are in possession? You have asked for possession injunction.
Milos, what has happened now is that they are the respondents are encroaching.
Now, is there any finding anywhere that you are in possession? So how can you know? How do you know that who is in possession?
Milos, it is an old ancestral property. Milos, may kindly have the genealogical table once.
So that's your statement. But in the trial court, was there any finding while dismissing? No, there was no occasion.
No, there was no finding as such.
Were you enjoying an injunction in the trial court at any
No,
point
no.
of time? Have you annexed anything to show that you are in possession?
Milos, we can bring certain photographs to this, Milos.
Photographs.
Milos, in fact, what has happened is, Milos, may kindly see, Milos, may kindly have the genealogical table once, Milos, that is annexed at page number 25.
Yes, 25.
Milos, this land originally belonged to Sheikh Hamuj.
Ah.
Upon his demise, Milos, it was divided between Sheikh Abbas and Sheikh Abdul.
See, this will not help you. We don't get to know still who is in possession. This is your case. Very well. We have not directed affidavits regarding the stay application. So we are directing affidavits. In the meantime, we'll grant status quo regarding possession and will restrain them from also status quo regarding the property as a whole. None of you can deal with the property till disposal of this stay application. It's in effect an injunction application actually.
Very well. Plus, and one thing, also there had to be a determination. I'm carrying a judgment of the Honorable Supreme Court whether the Waqf property is under the list of Waqf.
So that will decide at the time of final hearing of the stay application.
Very
We are
well.
not going into the merits at this stage. That will be prejudging the issues. Since a prima facie arguable case has been made out in the appeal, comma, which arises from the dismissal of a suit for partition
Yes.
filed by the plaintiff's appellants, comma, the parties shall maintain status quo with regard to possession and creation of third-party interest, as well as the nature and character of the suit property, till disposal of Can 2 of 2026. Full stop. Affidavits in opposition, affidavit within bracket S, in opposition to Can 2 of 2026 shall be filed within 3 weeks from date. Full stop. Reply thereto, comma, if any, shall be filed. Reply within bracket replies thereto, comma, if any, shall be filed within a week thereafter. Full stop. The application shall be listed in the monthly list of September 2026 for hearing.
Great.
I will direct you in the meantime to put in the requisites and all.
Very well.
The appellants shall put in
Lord, 18, my lord.
postal costs and requisites for service of notice of the. You are appealing for whom?
Malay 1 and 2.
After the above order is passed, comma, learned counsel for the respondent numbers 1 and 2 appears. Full stop. Next para. Since we have already passed the order, comma, directing affidavits to be filed, comma, all questions to be raised by the parties are kept open for being decided at the final hearing of the injunction application. Full stop. In view of the appearance of respondent number 1 and 2, comma, service of notice of the appeal on the said respondents is dispensed with. Full stop. The appellant shall put in postal costs and requisite for service of notice of the appeal on the other respondents within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants.
My lord, 16, my lord, 161, my lord, have been delays, my lord, in this matter.
Next.
Grateful, Milord.
One minute, item number 16 was called on Milord.
Yes. 19, who is appearing?
19, I have got the amount of response. Milord, I have been instructed to take a short passover, my lord.
Passover. Applications after, we'll have a second call after 28.
My lord, I am for the appellant petitioner before your lordship. My lord, the pursuant to lordship's direction, I have served my
Use the microphone.
my lord. Affidavit of service, my lord. All the postal articles returned unserved, my lord.
Answer.
With the postal report, my lord, refused, my lord.
Then move the matter. What is the
Refused.
application?
My lord, this is the partition suit, my lord. My lord,
You have challenged the what? Preliminary degree or
no, my lord, suit is, my lord, dismissed.
dismissed?
Dismissed, my lord. My
You
lord,
have
holding
already granted that granted injunction.
injunction, my lord. My lord, maybe the
Can
injunction.
2 and 3 what are they?
My lord, the can 1 is the, my lord,
No, can
application
1
for,
we know. Can 2 and 3 were asking.
my lord, 2 is the, my lord, application for, because of my
Oh,
lord,
they'll be hard along with them. You already directed.
last, my lord, can 4, it
Can
has
4
been
is also
appeared
there.
first time, my lord.
What is
It
that?
has not been served by, my lord, the amendment of the plaint, my lord. One property left out, my
So
lord.
can 2 and 3 were already there.
My lord, this is, my lord, can 2 leave to file the amendment, my lord. Can 2 is file, leave petition for filing the amendment application, my lord.
You have indicated the amendments there. You have
But,
indicated the amendments for which you seek leave in can 2.
But all those documents are not annexed here, but only to, my lord, file the application for the leave to file the
Can
amendment.
4 of 2026 is an application seeking to introduce certain further amendments
Right.
along with can 2 of 2026. Full stop. Accordingly, the two applications shall be heard together at the time of hearing of the appeal. Full stop. Affidavit in opposition to can 4 of 2026 shall be filed within 3 weeks from date. Full stop. Reply, if any, shall be filed within a fortnight thereafter. Full stop. Next para. From the affidavit of service filed today and along with the envelopes, comma, we find that the envelopes, the postal articles have returned with the endorsement refused, comma, which tantamounts to good service, full stop. Accordingly, can 1 of 2026 is being taken up for disposal, full stop. We find from the order dated May 18, 2026 that upon a consideration of the prima facie case made out by the appellants, comma, we had granted injunction for a limited period, full stop. In the absence of any change of circumstances, comma, there is no reason as to why the said order should not be made absolute. Full stop. Accordingly, can 1 of 2026 is disposed of by uh, uh, restraining the respondents and or their men and agents by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in favor of third parties in any manner, and stroke or from changing the nature and character of the said property till disposal of the appeal. Full stop. No orders to cost. Did you direct it to put in postal cost and all? No.
No.
The appellants shall put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to mention the appeal along with can 2 of 2026, comma, can 3 of 2026 and can 4 of 2026 for enlistment as and when the appeal is ready for hearing.
Grateful, my.
No, 21, my lord, AP for the appellants, my lord. Mr. Mukherjee is leading this matter was substantially heard, my lord. He's in court number 38.
We can pass over, we are passing over. Today we adopted a different policy. Applications up to 28 will call and then we'll have a second call. Second call you have to do it.
Number 22.
22 lawsuit, I am happy of the appellant lawsuit.
Yes.
Lawsuit was directed.
I am for the respondent number 1, 2, and 3.
1, 2, and 3. There are other respondents. 4 is
Lawsuit, every service.
4 was a co-defendant with you, Mr. Das. What, you are not ready with the papers?
Yes.
4 is a co-defendant with you. You are asking a basic question, you are not prepared.
Yes.
Come to move the matter.
4 yes. Lawsuit.
So we need not serve on 4.
No.
Your friend is appearing, you are appearing for the plaintiff. What is the matter?
Lawsuit. Lawsuit, impugned order is the injunction of suit for partition lawsuit.
Your suit.
No, I am the defendant number one.
Injunction has been granted.
Injunction was granted. That was the impugned order lordship. First I placed the impugned order, the lordship.
You are disputing it's a joint property. You said you purchased
Yes,
a
I am.
particular portion
Yes.
and that you are making construction over that.
Yes.
I am disputing that that was not a joint
What
property.
is the stage of your construction?
Roof level.
Roof level of the first floor.
First.
Let us see the order.
Lordship, I placed the impugned order, lordship.
Yes.
First, lordship.
These were not adverted to by the trial court.
That was no. Regarding construction, nothing was considered, and also the factual aspect. It was admitted that I purchased the property.
Mr. Das, was there any partition by meets and bounds? Otherwise, you are purchasing a portion of the property.
Entire property, 10 decibel, I am purchased as a minor at that point of time.
The entire property you purchased.
Yes.
You are an outsider to the defendant's family. Defendants are co-sharers. Sorry, plaintiffs are co-sharers.
Yes, plaintiff are my brother.
Brother, mother.
Who is the mother? You are the mother and the two brothers.
Brother and sister.
Mother, sister,
and one brother.
One brother. And you are another brother.
Yes.
Loss.
You purchased from whom?
Loss, I stated that. Originally, the property was Torani Dolui, Rajendranath Dolui, Horipada Dolui. In the year of 1967, they are transferred the said land Gaurhori Jana. Gaurhori Jana also transferred the said land 1969 to Narendranath Jana. And Narendranath Jana also transferred the said land in the year of 1970 to my client Mrityunjay Jana. At the time of the client, at the time of point of time, my client was a minor. Represented by my father Gaurhori Jana. Gaurhori Jana again transferred this property in the year of 1971 in the individual capacity. I am not transferred. Thereafter, Gaurhori Jana transfer 71 to Narendranath Jana. Narendranath Jana again transferred to the Gaurhori Jana.
So you are challenging virtually that Gaurhori Jana sold it, which he effected in your favor. I mean, on your behalf.
Yes.
You said it was not in your interest, therefore.
No, not in interest. I
filed any counterclaim challenging that deed.
No. I am filed a written statement, and all.
So thus, if there is no counterclaim,
counterclaim.
You can understand
Necessary is the counterclaim loss.
At least there, yes, either a suit or a counterclaim.
Yes.
Either challenging the deed or seeking a declaration that that deed is not binding on
yes,
you.
Yes,
You know what to do.
To that
that had to be done within a period after attaining majority. You have not done that.
Yes.
So therefore, Mr. Das, he has a prima facie case.
No, the record of right in entire land in my name. I possess the entire land.
Is a nowadays it's a
no. I know the
document of right.
I lost
the law has changed.
At the on the basis of the deed in the year of 1970 in favor of my client.
Mr. Das, your client, we cannot permit at this stage your client to make a construction on your chosen portion of the property. It's a joint property prima facie because of any absence of challenge to that deed.
Yes.
No, see
can't grant. We can't.
Loss, kindly see the impugned order. Loss. Nothing was considered regarding my.
We are considering. We are supplying the reasons.
But at the point that I only constructing the 663 square feet. If it is a joint property, I am entitled to 2.5.
Annex to the photograph of the construction.
No.
You have stated anywhere.
Yes. In the
objection,
objection I stated.
Is the entire.
No, for the timing, keep it with you. We cannot look into it because it was not before the trial court. It is his duty first to prove.
Yes.
Mr. Das, you have to show us from the written objection that.
Yes. My written objection, lordship.
Yes, we found your written objection, page 32. Try to find out that paragraph.
Yes. Paragraph number 20, relevant page 38. My application. That while the defendant Manoranjan Jana used to exercise his right, title, interest, and possession over the same, and the defendant had decided to construct his dwelling house over his purchased land, and for that reason, the defendant had sanctioned building plan for his construction from the authority concerned on such and such, and thereafter the defendant took permission from the local panchayat about his construction measuring 626.63 square feet, and thereafter the plaintiff started construction of his dwelling house. The house is already constructed up to roof level, and wooden centering of the roof has already completed of the new house, but the plaintiff wanted to follow the defendant have monetary loss, file this suit against
What
the
is your
defendant.
plan, the sanction plan, up to which level? How many floors?
Ground floor, Lordship.
Only one floor you want to,
Yes.
you want to complete that floor.
That floor.
Have you annexed any sanction plan here?
Sanction plan, Lordship, permission also annex, Lordship.
Where is that?
Sanction plan, Lordship, page 65. Page 65, Lordship. No, to two-story, Lordship. Ground floor 626 and first floor.
So then it is at the initial stage, Mr.
But maybe first floor may be constructed. Otherwise, my dwelling house, this is the only dwelling house.
Can it be a dwelling house? You purchased it. You are already residing somewhere.
No,
You purchased
in the year of 1970. Lordship,
Where have you been dwelling since then?
on that property. After
Now, where are you residing?
triple set of this construction, within this construction by over a triple set.
You're residing in that construction.
Yes.
You have stated anywhere that
No.
there is
To
alternative.
the extent, no. I have no another dwelling house.
You have not stated anywhere that.
I have already specifically said that is my dwelling house.
Where? Where have you stated?
Lordship, already paragraph 12, that is my dwelling house.
Paragraph 12. You have stated in para 20
Yes.
that you have decided to construct your dwelling house over
Dwelling house.
purchase land. So you are constructing your dwelling house there.
Yes.
So that could not have been your original dwelling house. You have started the construction when the sanction was obtained in 2023.
Yes.
So during
Prior than mud build temporary.
same property.
Yes.
Well, let us go to them. What about their permitting? I mean, they have already constructed up to roof level. So what if we permit them to construct with the usual undertaking that they'll demolish if we...
Well, one thing I am point out from the impugn order of the court below, which was under challenge.
Yes.
My lord, I am reading, there is several times of transfer. I am reading from the paragraph during hearing.
Yes.
In this paragraph, after 11 line.
Yes.
However, on 8/4/71, due to some urgency, it was again resold to Narendranath Jana by registered deed of sale being number such and such 71. Later, Narendranath Jana sold the same to Gohurari Jana by execution of deed of sale number such and such dated such and such. And the present defendant number 1, that is the appellant, do not admit with regard to the execution of the previous 3 sale deed.
Do admit.
Sale deed, which took place in the year 67, 69 and 70, but did not admit the execution. I am saying, but did not admit the execution of the latter 2 sale deed executed in the year 1971-73. Today,
therefore,
my lord, next paragraph is important.
Yes.
Today, during open hearing, the learned advocate of the plaintiff has produced the certified copy of 2 sale deeds executed in the year 1971-72 and prayed for passing of temporary injunction with regard to the schedule suit property, as he is apprehending that without a proper order of injunction, the nature and character of the said land, the objection to such submission made by the advocate of the plaintiff, the advocate of the defendant has submitted that already a schedule property is recorded in the name of the defendant Mrityunjoy Jana, and here he has no knowledge or given any permission to his father to sell the property in favor of the Narendra Jana after the year 1971. The deed which was he did not admit But after submission of the certified of the copy of the said two deeds, learned judge of the court below satisfied that this is the genuine deed. They, on the basis of that, that is the 71 and 73 deed, and on the basis, realizing the two deed of 71, 73, learned judge passed the order. And he is not admitting, but the considering the said two deeds, my lord, learned judge of the court below satisfied that this is the genuine. On the basis,
Narendranath Jana was all of your predecessor.
yes,
Narendranath Jana was a predecessor of all of you. Who is not?
Gaurhari Jana.
Gaurhari is the father.
No. Later, Narendranath Jana sold the same to Gaurhari Jana by execution.
Gaurhari Jana is a common predecessor.
Two deeds he did not admit, but the learned court below satisfied after considering the certified copy of the said two deeds that this is the genuine, that should be considered.
No, that we understand. But only one thing, he has already constructed up to the roof level of the first floor. And he says that it is his dwelling house. So now today, as the property stands, that construction, half-made construction is there. So we can permit him to finish only the first floor, the ground floor, and that will be subject to the rider that he will undertake, that this will be demolished if any order is passed by the court without claiming any equity in the partition as well as at his own cost. We will permit only the ground floor to be completed because he has already completed up to the roof level. So we will permit him to complete that subject to the outcome of the suit and with the rider as we put in that, and no further than the ground floor. Yes. Because he has already completed it apart from the roof.
My lord, one thing, he made the false statement that he is constructing.
Yes.
600 something square feet. This is the false statement. He is covering the all 10 decimals of the land.
What is the total
10 decimals.
10 decimals of the land.
As per plan,
626 square feet is only a.
My lord, this is the picture where
only
that you won't understand the entire extent of the land. He says 626 square feet. That is only a small part of 10 decimals.
1.5 decimal.
So what is his share according to you?
1/4 share.
1/4 of 10 means say
4 share, two brother, mother and sister.
So 4 decimals.
So he
2.5 decimals.
Sorry, 2.5 decimals.
Construction of only 1.5 decimals.
6 is within that.
Yes.
Within
we'll permit him to complete the first ground floor only.
Only as regards the square feet such and such.
Only this. Only
yes.
this.
Not more than that.
We'll put it in an order as per the statement made in para 20 of the written objection filed in the trial, so that he cannot go beyond that. And with the other riders at least.
Yes.
We'll only modify the order to that extent. We will disposing of the appeal itself. What is the use of keeping it pending? Both of you will suffer.
Yes.
On consent of parties, the appeal along with the application is taken up for hearing. So next para, the present challenge has been preferred against an order whereby in a partition suit filed by the plaintiff stroke respondent numbers 1 to 3, status quo has been directed to be maintained by the plaintiff and defendant number 1 in respect of possession and nature and character of the scheduled property. So next para, learned counsel appearing for the defendant number 1 stroke appellant argues that in the written objection filed to the temporary injunction application before the trial court, it was specifically pointed out in paragraph number 20 that upon obtaining sanction plan from the local panchayat, the appellant is making construction of his dwelling house over an area of 626.63 square feet. Next para, learned counsel further contends that in the chain of title deeds, at one point of time, the father of the parties, Gaurhari, had purchased the entire suit property in the name of the appellant. However, by subsequent transfer deeds, the same was sold back to the vendor and repurchased by Gaurhari in his own name. Next para, learned counsel contends that the initial transfer by Gaurhari was against the interest of the appellant, who was a minor at that point of time, and no consent was obtained from the minor, nor was it for the interest of the minor, stroke appellant.
My lord, can I
Yes.
Pointed one thing, my lord. Initially, it was purchased in the name of minor by the father, Gaurhari Jana, in the year 1970. Thereafter, by an exchange,
And again got back and again.
by an exchange deed in the same valuation property given to the Mitunjoy Jana, and thereafter by a deed of 1985 in the year 1970, and thereafter in the same date by another deed that property was sold out to Narendranath Jana. Thereafter, in the year of 1973, that property purchased by again by Gaurhari Jana from Narendranath Jana. And also, and on the basis of that, the same has been recorded. Your Lordship, kindly.
No exchange. There was an exchange and one property was given to him.
Yes,
No.
What are you saying?
And also in the
No,
2000,
we cannot look into it.
2005, same property was recorded in the name of Gaurhari Jana.
Who's the next para? Thus, furthermore, it is submitted that the appellant, at present, is residing in the partially completed ground floor of the new construction, in view of there being no alternative accommodation for the appellant, as it is the dwelling house of the appellant which is being built on the suit property. First up, it is pointed out that the area of the construction comes within the admitted share of the appellant in the partition suit as well. First up, next para, learned counsel for the plaintiff stroke respondent numbers 1 to 3 opposes the contentions of the appellant and submits that there was an exchange in the line of transfers leading to the present ownership, whereby commensurate property was also given to the appellant by way of exchange. To the next para, learned counsel further submits that the appellant is trying to make construction over the best portion of the property to the detriment of the interest of the other parties. To the next para, that apart, learned counsel points out that the learned trial judge took into consideration the certified copies of two sale deeds of 1971 and 1973, which were opposed, which were disputed by the appellant in the trial court. First up, being satisfied of the veracity of the said two deeds, the trial court granted the injunction order. First up, next para, thus, it is submitted that the learned trial judge rightly passed the order of status quo. First up, next para, upon considering the balance of convenience between the parties, we find that there is some doubt as to whether a strong prima facie objection has been raised by the appellant to the case made out by the plaintiff stroke respondent numbers 1 to 3 that the suit property is a joint one. Full stop, next para. Transfer deeds executed as long back as in the year 1970, 71 and 73 were never challenged by the appellant after the stipulated moratorium statutorily provide for such challenge, from the date of attaining majority. Full stop. Moreover, no counterclaim to that effect has also been filed, nor has any independent suit been filed by the appellant challenging the deeds in question. Full stop. Be that as it may, at this stage, it would be premature to decide such questions conclusively. Full stop. Fact remains that the appellant has already partially constructed up to the roof level of the ground floor.
Square feet should be. Square feet should be.
Yes, yes.
Lossy, only one thing, Lossy.
On 626.63 square feet of the suit property. Full stop. Thus, we are of the opinion that unless the appellant is permitted to complete at least the ground floor, which in any event is unusable at present by the other parties due to partial construction being raised thereon, the appellant might be without a dwelling house. Full stop. Hence, the balance of convenience and inconvenience is favor of permitting the appellant to construct at least the ground floor of the said property. Full stop. However, comma, so far as further construction of floors is concerned, comma, we are not uh, inclined to grant such permission to the appellant. Full stop. Next para. Accordingly, comma, FMA 601 of 2026 is partially allowed, comma, thereby modifying the impugned order bearing order number 21 dated March 24, 2026, passed by the learned civil judge, bracket senior division, third court at Poschim Medinipur in title suit number 107, 2024, to the effect that the appellant shall be entitled to complete the construction only of the ground floor of the construction being made by the appellant over 626.60 square feet of the suit property, comma, subject to there being a valid sanction plan to that effect and adhering to such sanction plan. Full stop. Next para. Such construction shall be completed by the appellant at the appellant's own cost without claiming any special equity for such construction, and the construction shall be subject to the outcome of the partition suit. Full stop. In the event any such order is passed or the final decree incorporates such a direction, comma, the appellant undertakes to demolish the said construction at his own cost. Full stop. Next para. We make it abundantly clear that for the time being, comma, the appellant shall not be entitled to raise the construction over the ground floor, comma, irrespective of whether any sanction plan is available to the appellant in that regard or not. Full stop. We further clarify that apart from the above modification, comma, the status quo granted by the trial court in respect of the possession and nature and character of the suit property shall be maintained by the plaintiffs and the defendant number 1, comma, being respectively the respondent numbers 1 to 3 and the appellant herein. Full stop. Can 1 of 2026 is accordingly disposed of as well. No orders to cause such as.
Lordship, only one thing regarding Lordship, only one thing regarding the exchange deed that was not pleaded in the plaint.
It's his submission we have recorded. We have not. That's not a finding.
Beyond pleading, Lordship.
You have also not pleaded many things which you have put in our order as your submission. We don't find that it is your only dwelling house.
It is a dwelling house, but for the sake of
We don't know whether he has anything. He has not stated a single sentence that there is no other dwelling house. But we have glossed over
for the
that.
sake of argument, I am not.
Yes.
I'm appealing for the appellant. I'm led by Mr. Shaunak Mukhopadhyay.
Well, my lord, may I have my lord's leave to appear virtually, my lord?
11 and led by Mr. Parthu Chakraborty.
Yes.
My lord, there are 3 applications on board, my lord. Can 2 and can 3, my lord, I want to bother, my lord, with first. Can 3 is for substitution of deceased respondents, my lord, which we learnt of only in July 2026. We've been intimated by the respondents of the passing of respondent numbers 1, 4, and 6 only on 24 July 2026. And therefore, we've taken out this application, my lord. Perhaps that has to be heard first. My lord, we'll kindly take paragraph 11, which provides the details of the legal heirs of the deceased respondents. Respondent number 1 and 4, my lord, no other substitution is required because the legal heirs are already on record. I've stated that in paragraph 11, my lord. Only insofar as this respondent number 6 is concerned, my lord, there is required to be substitution of 3 individuals. 3 individuals, my lord, will kindly find at page 10 of my application. Well, these 3 respondents have to be substituted in place instead of the respondent number 6.
Yes.
I've made that prayer, my lord, if my lord will kindly grant that. Because we were unaware of the death of these respondents. We only came to learn on 22nd June 2026 when the postal article, my lord, sending copies of the CAN applications came back as with the endorsement.
They have not stated that they are major and sui juris. Could have been. Any, what is CAN 2 then?
CAN 2 is, my lord, really an application for clarification. My lord had passed an interim order in my favor on 21st May 2026. My lord will kindly have.
Let us first dispose of 3 and then we'll proceed to 2. 3 is substitution we are allowing and then we'll hear 2.
So far, my lord, the respondent number 6 And my lord, the respondent number 1 is concerned, well, abatement has been already taken place. Because well, 90
So-
days from date, my lord, has been, my lord, expired, my lord.
They came to
I-
know in July only.
My lord, in that event, my lord, setting acid of abatement
We'll incorporate that in our order.
as your lordships.
I've stated that my knowledge, my lord, paragraph 7 onwards, I've stated my knowledge.
No, Mr. Chakravarti is right in saying that the date starts from the death, but that's a good
My
ground.
lord,
You have not asked for substitution after setting aside.
my lord, I filed the suit being unaware of the death of these respondents, my lord. In the suit,
over there, you have not paid for setting aside.
I understand. I understand. I understand. I
Let it be allowed, my lord. Let it be.
Yes, Mr. Chakravarti, you never oppose. I mean, we have, you know, we know your practice and you know our practice. I mean, we have been doing this. Can 3 of 2026 is an application for substitution of the heirs and legal representatives of the deceased respondent number 6 and for expunging the names of the deceased respondent numbers 1 and 4, comma, whose heirs are already on record. For sub next para, learned counsel for the petitioner, appellant stroke petitioner submits that the appellant stroke petitioner came to know of the aforesaid deaths only in the month of July 2026 and as such, comma, the application could not be filed earlier. For sub next para, learned counsel appearing for the respondents points out that the that in the application, comma, no prayer for setting aside abatement and or condonation of delay has been made, although the application has been made after the stipulated limitation period for filing substitution applications. For sub next para, however, comma, for the ends of justice, we deem the prayer for substitution as made in Can 3 of 2026 to incorporate implicitly the prayers for setting aside abatement and condonation of delay as well, comma, since substitution can only be the end result of condonation of the delay and the setting aside of the abatement, and thus encompasses such ancillary prayers as well. Full stop. In any event, comma, from the averments made in the application, we are satisfied that since the appellant only acquired knowledge of the said demises in July 2026 and filed the application in July 2026.
Yes, my lord. We learned on 22nd July, 24th July is their communication letter.
And filed the application in the same month, comma, sufficient explanation for the delay has been made out. Full stop. Hence, Can 3 of 2026 is allowed, comma, thereby setting aside abatement, thereby directing substitution of the heirs and legal representatives of the deceased respondent number 6 as respondents in place and stead of the said deceased, comma, upon setting aside abatement on condonation of delay in filing the said application. Full stop. Next para, the office shall carry out the necessary corrections to the memorandum of the appeal accordingly. Full stop. In view of the respondent numbers 1 and 4, comma, also deceased, comma, sorry, in view of the heirs of the deceased respondent numbers 1 and 4 being already on record, comma, the names of the said deceased respondents may merely be expunged from the memorandum of appeal, comma, which shall also be effected by the office. Full stop. No address to cost. Can 2 now. What is the amendment? And then we will.
My lord, first, there's no amendment in Can 2, my lord. Can 1 and 2, my lord, have directed them to file affidavits in opposition on 29 June 2026. We received an affidavit in opposition so far as Can 1 is concerned on 20th July 2026. My lord, I'll be praying for some time to find my reply. It's being affirmed today by, I'm sure, my lord, within 2 days, my lord, it will be on record. It can be filed. As to Can 2, my lord, we've not received any affidavit in opposition, my lord. If they don't wish to file, my lord, I'll press it.
Not required, my lord.
Not required. My
Not
lord,
required.
Yes, yes. Malad, Can 2 is a simple application. Malad, really, for my own fault, Malad, I have to take this out. Malad, will kindly take paragraph 3 of the application. Malad, there was an inadvertent submission that I had made, Malad. as to the suit khatia numbers being correctly described in the body of the plaint and injunction petition. That is not correct, Mullah. That was an incorrect submission due to inadvertence. I've made that. 3 and 4, Mullah, I've tried to explain. The documents annexed with the stay application clearly show the correct khatia numbers. Here, Mullah, there was a dispute as to the suit khatia numbers. The learned trial court had refused my injunction only on that ground that the schedule of the plaint did not disclose the correct khatia number as compared to the agreement for sale of which I seek specific performance of. So, my lord, I'm only seeking clarification out of abundant caution. I've taken this application out because it's an incorrect submission on my part, my lord. If my lord will kindly excuse me, I tender my apology in that regard as well.
But there's a scope of modification of the order because this
clarification. Yes, I'm sorry.
No, does that clarification has the potential to for our order to be changed?
No, my lord.
If
No.
that is so, then we'll hear Mr. Chakraborty on that also.
My lord.
Let us just.
I don't. I'm sorry.
Mukhopadhyay, give us half a minute. We'll just check that paragraph.
Yes, sir. Yes, sir. Page 11, my lord, will find Manoj's order.
Yes, yes, yes. So as well as from the pleadings in the body of the plaint and injunction application, that will not be there. That is not
Yes.
correct.
Yes, sir. Yes.
Yes, Mr. Chakraborty, that does not substantially change the thing because agreement and other documents are there.
Let it be hard on merit, my lord, because I am suffering injunction, my lord. My opposition is ready.
No, injunction application should be hard on merit.
My lord. That is the, my lord, only, my lord.
We will dispose of this can 2. We'll say no modification is required to take note of the fair submission made by Mr. Mukhopadhyay. Yes. Very well. Can 2 of 2026.
1 minute, my lord.
Yes.
May I file the deputy?
No, we'll come to that. This is in respect of can 1.
No. Can injunction application can
1.
Can 1. Yes.
Can 1. Yes. Sorry.
We are telling you what is the number of this. Can 2 of 2026 is an application for modification of the order dated May 21, 2026 to the effect that it was recorded in paragraph number 2 thereof that learned counsel for the appellant had argued that inter alia, the correct description of the suit khatiyan number appears also in the body of the plaint and the injunction application. Full stop. Learned counsel for the appellant submits that it was an inadvertent error, since the correct description of the suit khatiyan does not appear in the body of the plaint and the injunction application, but, as otherwise correctly recorded in the said order, in the agreement and other documents which are produced before the learned trial judge. Full stop. Next para. We appreciate the fair submission made by learned counsel for the appellant. Full stop. However, there is no scope of modification of the order, since it records only what was submitted on the said date. Full stop. Even otherwise, we find from a perusal of the order dated May 21, 2026 that the aforesaid error does not substantially necessitate a variation in the order, since even otherwise, on the basis of the correct description of the suit khatiyan number in the agreements and other documents, a prima facie case was made out on the said date for passing of the injunction order. Full stop. Next para. Accordingly, can 2 of 2026 is disposed of in the light of the above observations without any orders to cost. Full stop. Next para. We make it clear, however, that the above observations shall not affect the outcome of the injunction application. Full stop. The affidavit in opposition to the injunction application filed by you are for which of the respondents?
389.
Oh, she said yes.
9 and 11.
Order
38911.
Filed by on behalf of respondent numbers 389 and 11 today be kept on record. Full stop. On the prayer of learned counsel for the appellant, the time for filing reply thereto is extended for 1 week. Mr. Mukhopadhyay.
Mullah, it's ready. It's I believe it's arrived right now as we speak. Mullah, that can be filed, taken on record.
Is extended till today. Full stop. The same is filed today and kept on record. A copy thereof is handed over to learned counsel for the appearing respondents here and now. Full stop. So you are getting the copy right now. So we'll put it on Monday.
Malad, possibly not, Malad. The substituted respondents have to be served with this application as well, Malad. If they want to file opposition, Malad, that time has to be granted.
Right. Very well. The time to extend column for time for filing reply is extended till today and kept on record. Sorry. Next, copies of can 1 of 2026 shall be served on the substituted respondents at the earliest, and an affidavit of service to that effect shall be filed on the returnable date, full stop. Affidavits in opposition, if any, shall be filed by the substituted respondents within a fortnight from date, full stop. Reply thereto, if any, shall be filed within a week thereafter. Full stop. Next para, can 1 of 2026 shall next be listed on August 17, 2026 for hearing.
Can it be one week, my lord? Because same on
No, no, they'll serve, they'll file their opposition.
They are
and-
also my family members, same matters of record. No other documents, no other pleadings would be there.
Sir, I don't know if my learned friend is appearing for them today as on date.
You will appear for them also.
Maybe, my lord, I don't know, but
Or you have someone appear for them.
as
2 weeks is reasonable. Please serve immediately.
I'm suffering injunction, that's
No, no, only 2 weeks.
I'm deeply honored.
They can appear through some of your other juniors and adopt your office. No difficulty.
Obliged.
We are too candid for comfort. Yes.
I'm deeply honored.
Thank you. Thank you. 24.
My lord, item number 24, Mr. Gopal Chand Ghosh is appearing for the former respondents. My lord. He is under some difficulty. He mentioned the matter yesterday before granting of the court.
Yes, yes.
Kindly, my
Mentioned
lord,
it yesterday.
they
What
are
is the-
enjoying injunction. Will not be prejudiced.
Have you filed your opposition?
Yes, my lord. That has been filed on the last occasion, my lord.
We'll put it when? Next week?
Next week, my lord, any day next week.
Affidavit in reply filed today by the appellants be kept on record, full stop. On the prayer made on the ground of inconvenience of learned senior counsel appearing for the respondents, the matter is adjourned and shall next be listed on August 4, 2026, next Tuesday.
Also, reply may be kept.
First sentence of our order. That is a copy of the reply.
Yeah,
Your name only.
appearance.
Please don't give the name of Mr. Gopal Ghosh by mistake. It's a matter of habit. Sometimes it happens. Yes.
Item number 25. Lordship, item number 25, I'm praying for a short Passover.
Passover.
Normally, I don't oppose the Passover.
No, abnormally also we are granting a Passover.
Well,
Up
there
to
is-
28, we'll call up to 28 and we
Well,
are
I will
giving
be
a,
in some difficulty after I have to go to the.
then you will definitely pass over. We want you to be in difficulty. This will be a long matter if you appear.
No,
you don't
no,
appear,
I
it will be a short
I
matter.
get very less opportunity. They are moving before the London. They are filing
So they are
application for
asking,
contempt
she'll
against
be
them.
embarrassed. Mr. Sharma will call up to 28 and then we'll be calling
I
the.
will not be there by then, my lord.
Why?
I have to leave, my lord, for some.
Leave court
Yes, go to the airport, my lord.
for greener pastures.
No, no. I have to. I was not aware that it will be passed over my
The
life.
color may be wrong, not greener nowadays. What is the
I
matter
can-
about?
Lord, this
We'll-
is
we'll record an order.
the lordship order at past lordship has appointed.
You are
joint
appearing.
special officers.
You're with.
They are joint special.
What?
No.
I may be allowed to file my report along with all the documents that were.
They are moving.
Have you been paid?
We have paid our part. We have paid our part.
Both parts.
Yeah. My lord, here, my lord, lordship, remember this was the association.
Who is appearing? On whose ground are you asking for Passover?
Mr. Subir Banerjee.
Where is he?
Lordship, he's engaged in another court.
Mr. Sharma, what?
The matter is fixed before the London court below on 3rd August. And they
No,
have
but
filed an
take-
application under Order 13 and Rule 2A. Lordship has said Lordship will not stay the order. Lordship has asked both the parties agreed to hold a meeting for the
That election.
That matter. They gave that they didn't
Sharma,
participate.
Mr. Banerjee is there. We'll try to call as fast as possible. We're just passing it over. Please, ma'am, please keep it with you for that. You have already handed over. No, no. As long as possible, try to keep it with you because of the condition here.
In
Pass
that,
over.
in that case, Lordship keeps it on 31st, my lord.
We can keep it on first. Seriously.
First, we are open.
Yes, we are open.
Yes.
Because of Shah Prasad Mukherjee.
Yes, but then there will be a resolution from the bar.
Resolution, so what?
Not to pass
How many
adverse order.
resolutions do you? Please.
Lordship will follow that
Resolution is not binding in the sense that you are not resisted from appearing.
No,
Resolutions say that if both parties are not present,
They will not present because matter is fixed on the learned
both
court
of you will be present.
I
On
will be
their
present.
prayer, I am passing over. I'll record that if they don't appear, we'll pass
Yes,
expert
then-
order.
then pass.
Present.
Yes.
An adjournment is sought on behalf. Yes, then ma'am will really.
Yes, 1st August we will do.
An adjournment is sought on behalf of the respondents at the time of call. Full stop. Let the matter Let the matter be listed on August 1, 2026 for hearing. Full stop. Next part, it is made clear that in the event either of the parties remain absent, the matter may be taken up ex parte in their absence.
Okay.
Full stop. The report. This is the report. The the report filed by the learned special officer along with all relevant documents filed today be kept on record.
It should be joint special officer.
Acha, joint special officers. Joint special officers. Acha, have you circulated copies? Did you
Yes,
ask?
yes. There was an order of advance.
We are craving leave to file exception to the
Very
report.
well. Copies, we are informed that copies thereof has been circulated to the learned advocates for the parties. Full stop. On the prayer of the respondents, the respondents are permitted to file their exception,
1 day prior to the date fixed, so that we can also go.
Their exception, if any, to the said report on the returnable date, with prior copy to the learned advocate for the appellant, as well as to the joint special officers.
Yes. Great.
Please be present on that date if necessary.
Yeah, that will be a very easy day, man, very convenient day. And very less pressure.
But don't take the entire day. We have several CV matters. So we'll be asking for adjournment.
No, kindly.
Not that because you have the time.
Kindly give us some time on that day, man.
To start drafting right now in your chamber.
They
won't
had
be able to
this
give a
report
copy to
long
them.
time back. This report is there for last 1 month.
Then they will complete
I
it
think
by
by
tomorrow
this
and
time
give them a copy.
Grateful.
Next.
Number 20.
26. You are appearing?
I am appearing, Manoj.
Both sides appearing.
And if it could be taken up on Monday, Manoj, I have two leaders, both of them
Name them. Who are they?
Mr. Bhattacharya and Mr.
Which Mr. Bhattacharya?
Rudravan Bhattacharya. Manoj, he was supposed to join virtually, but Manoj, we don't want to
He
do
comes
that.
occasionally to Calcutta, Mr. Bhattacharya. So,
May I audible, Your Lordship?
I am vehemently opposing this prayer, my lord. Of Mr.
I am for the appeal and I'm leading Mr. Dasgupta.
vehemently turning down your opposition, Mr. Charit.
My leader is there, my lord. Mr. Kaur is there. He will.
Mr. Kaur has never vehemently opposed anything.
I am doing it on his behalf.
Unlike you. Yes.
I am doing it on his behalf, on his instructions.
The word vehemence is not in my system.
No, it's not. Entirely out of not in a system. So we'll adjourn it till Monday.
Yes, sir.
On the prayer of the appellant, the matter is adjourned till August 3, 2026.
Grateful.
Item number 27.
Lordship, item 27, I beg to appear for the respondent.
Yes.
virtually, my lord.
Yes, absolutely.
Can I peruse the order of your Lordship?
My lord's last order speaks for itself.
We'll
Lordship.
just look into that.
Justice Bhattacharya, Supreme Court has the copy.
We have ensured that both judges have copies of the orders nowadays.
Yeah, nowadays, yes. Previously,
Obviously,
one copy.
you know Mr. Basu more than us. But now it's ensured.
It's good.
Oh, that.
That matter, very short.
Yes, let us dispose of the appeal.
Yes, my lord. My lord. I have
Thank you.
no.
Fair enough. This is the fair approach we want from our council. Not only fair, but intelligent approach also, because otherwise there will be no use of these things. So we'll set aside the order. We'll direct the substitution application, or we can allow the substitution application from
Kindly
here.
allows the substitution application.
Also, yes.
Yes, my lord.
And the interim order.
Extend the interim order till dispose of the injunction. Have you filed your written objection there?
Yes, my lord. All pleadings are complete in the
Basu will request the trial court to finish it within a.
Lordship, I also have a 39 Rule 4 application in which affidavits are complete.
That will be decided along with the 39 one.
Lordship kindly passes directions.
Yes,
That's all I
17
pray for.
application also for amendment. That also can be heard.
Amendment of your plaint.
My lord, my point in the 39(4) is that if the 617 is allowed, it will change the nature and character also. So, which is why I was before the learned trial court praying
So
that
let it be taken up with Sinha along with that, and let it be rejected first, and then the injunction application.
my
If it is
lord.
rejected, then you're. Well,
I am much obliged, my lord.
on consent of the party of learned counsel for the parties, the appeal and the application are taken up together for hearing. Full stop. The ambit of the appeal is very short. Full stop. By the impugned order, the learned trial judge refused to extend an order of ad interim order of injunction granted earlier by the said court on the sole ground that an application for substitute that the original plaintiff was dead, and an application for substitution of his heirs, comma, which was pending before the said court, had not yet been disposed of. Full stop. Next para. Learned counsel, learned senior counsel for the appellant and learned counsel for the respondents point out that apart from the injunction application being complete as regards pleadings, comma, two other applications are also pending in the trial court, comma, one being an application under Order 39 Rule 4 of the Code of Civil Procedure for vacating the ad interim order, and comma, filed at the behest of the defendant stroke respondents, and the other an application under Order 6 Rule 17 of the Code for amendment of the plaint filed by the appellants, plaintiff stroke appellants. Full stop. We are apprised that the said applications are also complete as regards pleadings. Full stop. Next para. Upon a perusal of the impugned order and on hearing learned counsel, comma, we find that the approach taken by the learned trial judge was hyper-technical and opposed and contrary to law. Full stop. As per the governing law as envisaged in Order 22 of the Code of Civil Procedure, comma, an application, the duty of the plaintiff is discharged upon filing an application for substitution on the case of demise of a party within statutory limitation period, comma, upon which the obligation shifts to the concerned court to decide such application. Full stop. In the present case, comma, an application was for substitution was filed duly within the limitation period, but was kept pending by the trial court itself. Full stop. Surprisingly, comma, the learned trial judge, comma, despite being in season of the said application on the date of the impugned order, comma, instead of just allowing the same and taking up the extension prayer, comma, chose a hyper-technical path by refusing to extend the interim order on the ground that the substitution was still pending. Full stop. Next para. In such view of the matter, comma, the impugned order suffers from patent illegality. Accordingly, FMA 812 of 2026 is allowed on contest, comma, thereby setting aside the impugned order number 87 dated June 12, 2026, passed by the learned judge, comma, 4th bench, comma, City Civil Court at Calcutta in title suit number 433 of 2019, and allowing the substitution application filed by the plaintiff in the trial court. Full stop. We also extend the interim order granted by the trial court initially till disposal of the temporary injunction application. Full stop. Next para. The learned trial judge shall dispose of the injunction application, comma, the vacating application under Order 13 and Rule 4 of the Code, as well as the amendment application under Order 6 Rule 17 of the Code, comma, all of which are pending, comma, by taking up those together, comma, preferably within 6 weeks from the date of communication of this order to the learned trial judge. Full stop. Next para. We make it clear that the merits of the injunction, the merits of any of such applications have not been gone into by this court, and it will be open to the learned trial judge to decide all of those on their own merits in accordance with law and without being influenced by any of the above observations. Full stop. Can 1 of 2026 is consequentially disposed of as well, in order to cause urgent certificate. Thank you.
I am much obliged.
Thanks.
Item number 28.
Yes.
Item number 28.
Here for the appellant in this
So
matter.
Mr. Mukherjee begins, Milord. I am for the respondent number 3. I am also equally aggrieved by the order, Milord. So we have, Milord, prepared 2 memorandum of appeals. I am not making an application for stay. It's already
Are you
there.
enjoying an interim order?
No, Lord, I am challenging an interim order, Lord, by which an injunction was
Lord,
granted.
I have a problem here, Lord. I am appearing on behalf of the answering respondent. Lord,
Yes.
today kindly excuses me any day, even on the first Lord, I'm agreeable.
No, you oppose the earlier prayer of Mr. In the earlier
Vehemently,
matter,
Lord.
Mr.
Now I'm
Rupert,
vehemently praying.
No. In this time refused.
My Lord, I'm in,
Why, Mr. Chatterjee? You were there.
in Jalpaiguri, my Lord, without, I'm not in a situation, my Lord. If your Lordship kindly, my Lord, keeps it even on the first, I'll be there.
That in that event, kindly grant him leave Miller to prefer an appeal because he's also agreed by the order.
If you postpone it, then he may do that.
My lord can keep it anytime after the 5th. We'll serve and come back, my lord. It's only the memorandum that we need to file. There's already an application for appropriate orders on.
But he has to approve of this.
No, Lord. In fact, Lord, the injunction order, Lord, affects him.
It affects me most. So out of court consultation is already done.
The very first day your lordship
across the board.
Yes, we'll do that, my lord.
So no leave is required to file it today. We'll record his submission.
No, my lord, the certified copy is not there. The delay. There's no delay. I don't have the certified copy, my lord.
You have a copy?
Yes, I have.
Cannot file it here. We'll grant to leave here.
Yes, just the leave, my lord.
Yes,
just the leave.
Right.
To endorse code.
Mr. Chatterjee is appearing for which of the 1 and 2?
I am the answering respondent.
Who are the answering respondents? You don't know. Say that.
One and Wait, your
You
lordship
understand these
has
things.
from
Mr. Chatterjee, we
yesterday-
also use the
from-
same jargon when you didn't know.
From yesterday, beloved, it's been, beloved, your lordship's presuming that I don't know anything.
No, presuming, no. You don't know, not you don't know anything. You know don't know the relevant things, which we completely understand because during practice, I also suffered from the same malady. So when I was not sure, I am for the answering respondent.
Answering
and all.
respondent,
You
yes,
know,
sure.
all of us know this.
My lord, but it's 1 and 2.
At the outset, an adjournment is sought by learned senior counsel appearing for the plaintiffs to respondent numbers 1 and 2. Full stop. Learned counsel for the respondent number 3 submits that the said respondent is equally aggrieved as the appellants with the impugned order and seeks leave of the court to file an appeal against the same without certified copy. Push up in view of the certified copy of the impugned order being already annexed to the memorandum of FMAT 219 of 2026, we grant such leave. Full stop. The respondent number 3 shall circulate copies of the memorandum of the said appeal. Only memorandum.
Yes.
No application.
No, I'm not filing it.
A memorandum of the said appeal to the learned advocates on record for the appellants and the respondent numbers 1 and 2 by August 3, 2026. Full stop. Next para. The present appeal, liberty is granted to the respondent number 3, after filing the said appeal, to give the number thereof to the officer of this court. Full stop. The said proposed appeal shall be tagged along with the present appeal. Full stop. The matter shall next be listed together. Next be listed together on August 6th. No, then August 10th. 10th August. That is the available Monday after that.
One further indulgence, my lord. 22nd May is the impugned order. 21st May is the order by which, my lord, the injunction was revived. And 22nd it was heard, the impugned order was passed. I have also challenged, my lord, the order by which the injunction order was revived. That is 21st.
Let us complete this.
I need the
on August 10, 2026. Push up. On the pair of respondent number 3, a further leave is granted to the said respondent to challenge. No, you cannot challenge 2 orders in a single.
No, they're 2 separate memorandums which I have taken up. Yes. I'm not challenging under the same. Means I have filed 2 separate.
For that you could not obtain certificate copy.
No, my lord. The certified copy is not.
What is the date of that? The other one.
105 এটাতেই SL করে দিতিস anyway
21/05/2026.
On the prayer of learned counsel for the respondent number 3, leave is also granted to the said respondent to file an appeal against a connected order dated May 21, 2026 without the certified copy thereof. Full stop. The memorandum of the same shall also be circulated among the learned advocates on record for the other parties within the stipulated time.
Lord,
you give both the numbers to our officer.
Yes.
When you file it.
Yes.
File it today. Thank you. আপনি না আচ্ছা অ্যাফিডেভিটের সাইজ ফাইল টু বি কেপ্ট অন রেকর্ড একটা উনি ওনার কেউ যখন এই দুটো নাম্বার দিয়ে যাবে give the number along with this present appeal along with the number of the present appeal so that she'll be able to identify এটার সঙ্গে 10 তারিখে দিয়ে দেবে ওই দুটো অ্যাপিলের নাম্বার ওটা দিয়ে
Great for me.
Thank you, Mr.
Yes.
Much obliged.
Passport.
Lord, I am for the appellant in this
Yes.
matter.
Yes,
Learned
Mr.
friend has not filed opposition till today, but she is praying for some time.
I'm not praying for something.
Not playing first.
Your Honor, I'm for responding to Parul Sen. She is an ailing lady. From early hours, I was downstairs in the office filing my submission. It is taking a few more minutes. If your lordship could allow
What?
me
To file what?
filing the reply of the copy that have been served by the appellant.
Opposition.
Opposition.
Opposition, yes.
In that case, my lord, we'll have to file our reply.
Yeah.
Let there be direction.
You're for respondent 2.
Yes, my lord. Respond number 2.
For Parul Sen. If your lordship could allow me few more minutes, then
A few more minutes won't help you because you'll have to give copies to them also. Learned counsel for the respondent. Learned counsel for the respondent number 2 seeks an extension of the time for filing affidavit in opposition. Full stop. Such time is extended till today. Full stop. A copy of the affidavit in opposition shall be handed over to the learned advocates for the appellant as well as the respondent number 1 by July 31, 2026. Full stop. The reply, if any, shall be filed within August 7, 2026. Full stop. The matter shall next be listed. The application shall next be listed for hearing on August 10, 2026.
I'm good.
Thank you.
Yes, sir.
I am for the appellant petition. Filing the affidavit submission. Service is affected to all the rest.
Saluddin is appearing for some of the respondents.
Yes.
1 to 6.
They are the main respondents.
Yes, they are the plaintiff respondent.
Yeah.
All the
What is the matter, Mr. Kundu?
matter with addition suit was decreed in preliminary form my lord, against that.
This is a stay application, the usual order. So we are making this order absolute and directing paper books and all.
Yes.
Any other respondent is left
Respondent, they
out?
are the defendants.
Only 2 points. According to my reading, the objection of my learned clients.
Yes.
That one is Raghunath Tati, the land of the Raghunath Tati,
Yes.
and non-joinder of Raghunath Tati. Only 2 points, but elaborately the learned court below discussed about the same. Because of it, there is no nexus in the property in question of the respondents.
We'll hear when you take up the
Yes,
appeal. We are
without
not
hearing
passing any
cannot be-
order on merits now. No, but you have to serve the others also because this is a
Yes, I
petition
can.
put in the postal cause.
Yes.
Heard learned counsel for the parties. Full stop. The present appeal arises out of a preliminary decree of partition. Full stop. Affidavit of service filed in court to be kept on record, from which it appears that all the respondents have been served. Full stop. Since the plaintiffs' respondent numbers 1 to 6 are represented by the learned counsel, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. The appellant shall put in postal costs and requisites for service of notice of the appeal on the defendants stroke respond numbers 7 to 16 within a fortnight from date. For sub next para, can 1 of 2026 is disposed of by directing the learned trial judge to continue with the final degree proceedings, semicolon. However, comma, the learned trial judge shall not draw up any final degree without the prior leave of this court, comma, during pendency of the appeal. Full stop, no address to cost. Full stop, next para. The trial court records shall be brought by special messenger at the cost of the appellants, comma, to be deposited within a fortnight from date. Full stop. The trial court shall be at liberty to retain skeletal records for the purpose of continuing with the final degree proceedings. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you, Mr. Chairman.
If you lordship fix the date.
Date of appeal. Let it be ready first.
Grateful lordship.
Thank you. Next.
I'm for the appellant. Your lordships heard this matter yesterday, my lord.
Oh. Yes, yes. Mr. Mukherjee, please remind us
Lord,
the main point. Just
in a suit for a declaration about Lord, one give deed and two sale deed on the ground that Lord, the executant did not properly execute the deed of gift and consequently the sale deeds. Lord, I filed a suit seeking Lord a declaration to that effect that those deeds are Lord null and void and consequentially for partition. In such a suit, Lord, the injunction was refused on the ground that there is a Lord a registered deed and Lord that I could not show anything that I am in possession. To which my answer was, Lord, that in paragraph 11, I have some material to show that why I contend that the deed of gift primarily was, Lord, to be assailed of, and I say that it was not a conscious execution of the donor. And Lord, so far as the possession is concerned, Lord, I have annexed at page 111 and 112 a document to show that one of the plaintiff's name is still there in the record of rights. So, Lord, the learned judge is finding that I could not prima facie show, Lord, that I am in possession. That is, Lord, belied from that particular document, which is also filed before the learned judge. So,
what injunction has been granted?
Injunction was refused. The ad interim ex parte injunction was refused.
What is the injunction you asked for?
Lord, not to transfer alienate, which your lordship passed, Lord, at the time of admission of the appeal. But I pray for continuance of that same and not for decision of on merits, the injunction.
Also for possession?
No.
Not
No.
possession
Your
is
lordship,
disputed.
not the order was in respect of change in the nature and character and third party interest. That is paragraph 7 of my lord's order.
Yes.
5th of May.
Yes, right.
5th of May order.
Yes,
yes, my lord. Yesterday, my lord, I showed to your lordship, my lord, the two paragraphs of the plaintiff. If your lordship would kind enough to, my lord, come to, my lord, page 28, para 22.
Yes.
Kindly see, my lord, the date firstly arose on 4th of July 2017. Yesterday, my lord,
that limitation.
Exactly, limitation point. My lord, even for their predecessors, my lord, when he was alive, my lord, at that point of time also, this, my lord, the first, my lord, 3 prayers of the plaint, my lord, are, my lord, completely
So the
time.
subsequent sale deeds are dependent on that gift deed.
Exactly. One. Number 2, my lord, kindly comes to, my lord, because this is ex parte ad interim, my documents are not filed before the court. My lord, if your lordship 97. My lord, kindly see 97. Lord, they are not entitled to any injunction. Kindly see, beloved, Kreta, who is Kreta? Joydeep Das, who is Bikreta? Ritik Agarwal. What is he selling, Milord? Kindly see, Milord, at page 101, Chauhoddi, 100, 100. Kindly see, Milord, the Topshil or Chauhoddi, Jela Sachansat, Chachol, Mouja Paharpur, jail number 149, LR Khotiar number 33881, Haldag number 528. 528, Milord, kindly see the schedule of the plaint. 528 is the Milord schedule property. And Milord, kindly see second, third, next page, Milord, all Milord, their shares, Milord, they have already sold before filing of the suit. Now, Milord, kindly
Das is one of the plaintiffs and appellants before us.
Exactly. Kindly see page 19 now. Kindly see page 19.
Everything they have sold, so the other plaintiffs cannot maintain the suit. You are saying that.
Milord, they sell, Milord, they before Milord selling, Milord, kindly see, Milord, page 19.
19.
Kindly see, Milord, the plaintiff number 3 is Ritik Agarwal.
Yes.
And Milord, kindly see, Milord, turns over the page, Milord, page 20.
5 is Joydeep.
Joydeep. Milord, they sell undivided.
We were wondering while going back that how did Joydeep get into these Agarwals?
Milord, they sell undivided property, Milord, then Milord, there is nothing. But where they are Milord, asking injunction on us that we cannot, Milord, we should be injuncted. But before filing of the suit, they have, Milord, sold, Milord, portions of the, Milord, undivided property according to their own pleading, according to their own annexures, Milord, to third parties. Milord, whether this entitles them to, Milord,
the entire suit property was sold by virtue of that.
No, portions.
Otherwise, the suit won't be made.
Won't lie. But Ritik is a plaintiff.
So you mean to say that they themselves sell out?
Exactly. I don't say, Milord, the partition suit is maintainable, not maintainable. I am saying whether injunction can be granted, Milord, ex parte admission on this conduct. They sell, then there is no problem.
No, you say partition suit is not maintainable on the other ground.
Suit is maintainable, but injunction. expertise ad inter.
So you are relinquishing your limitation point.
No, limitation. No, limitation is there. Limitation is definitely there.
Then partition should
No,
be
first
maintained.
three, Millard, kindly see, Millard, the page 29, prayers of the plaint. First 1, 2, 3, 4. These four prayers are completely
There
time
cannot
barred.
be any partition. They
Dependent
don't have any
upon-
right if that prayer is not granted. You have become the owners of the entire property.
No, portions, Millard, co-sharers.
Oh, no, even
I
without
am not Joydeep Das.
even without 2 and 3, those declarations regarding the deeds,
yes,
even without those partitions should is maintainable, they remain co-sharers. Oh, the partition should be otherwise maintainable. Then why shouldn't injunction be granted?
No, there are other properties also. Millard, I am on the conduct. They sell, Millard, there
Think
is
over
no
that.
problem.
We'll think over that and come back and answer your queries after we come back. We were thinking otherwise that the entire right is lost if that challenge
No,
fails.
Millard, kindly, very well. Let's see, comes back, Millard.
That is going to matter.
Mr. Bhattacharya, you have anything to add?
Yes, my lord, otherwise the suit is not maintainable. Well, let us see the plaint.
Yes.
Kindly see, my lord, the page 21. And kindly see para 2. The total quantum of the suit property, the total quantum of suit property is 1 acre 61 decimal of land of plot number 528, which comes under Moja 149.
What is the point, Mr. Bhattacharya? Why?
Yes.
Tell
I
us,
tell-
then we'll look into the.
Yes, kindly see in paragraph 4, my lord, we are today admittedly, my lord, both the plaintiffs and the defendants, my lord, are from the two branches of Jagdish Prasad Agarwal.
All right.
Admitted fact. Now, my lord, kindly see paragraph 4. What my lord is the my lord language pleading when while Jagdish Prasad was absolutely seized and possessed and or well sufficiently entitled to all the piece and parcel of land measuring about 34 decimal be the same 34 decimal be same or little or more lying in the said precinct such and such and within the jurisdiction the two with together with a single storied structure standing on a portion or thereof more fully described in schedule herein after referred to as the suit property. Now, my lord, 161, my lord, is now, my lord, kindly see, my lord, the schedule of the plaint, which is at page 32. Now, my lord, kindly see, my lord, schedule co is 161 decimal entirety 528. And my lord, kho is my lord 34, my lord 34, which according to the pleading, Jagdish was the owner.
Jagdish was your predecessor.
Everybody's predecessor.
Except Joydeep.
Yes. Now, my lord, kindly see, my lord, page 31.
Yes.
6. Paragraph 6. Decree for partition in preliminary form in respect of suit property. They don't say ko and kho. If they say ko, then, my lord, other co-sharers are left out. There are other co-sharers in the plot of land. They are left out. If they specified it to kho, then, my lord, we only the Jagdish heirs are the, my lord, should are parties. Kindly see 6, prayer 6.
Yes.
Then, my lord, all co-sharers, my lord, are not parties.
This was at the ex parte ad
interim stage.
Can you point out these things? How do we know now? The court. How does the court know
My lord,
now that it's bad?
I'm from their pleadings only, my lord. This is I'm not.
How do you know that there are other heirs of Jagdish?
There are other Jagdish says, my lord, there are no other heirs.
So why is it bad? We don't understand.
Because the other in that the plot of land, there may be other co-sharers. Because
maybe. How do you know that there are? There may not be.
Then, my lord, 161 because they are not clear in their schedule and the, my lord, prayer from where, my lord, they are praying for partition. Either if it is in my lord entire 161, then there must be, my lord, other.
How do you know that?
That is.
How can you be so sure?
Because paragraph 4 say only 34.
The area.
Area. Jagdish is only 34.
So nothing mentioned about the other parts of 161. No, the other parts may be covered by the deeds.
Paragraph 2 is our other parts called.
Yes, quantum. It says quantum. 1.61 is total 528. 520 is the only, my lord, dag.
161 decimal.
Yes, the said properties mentioned cost schedule of the plan is usually possessed by the plaintiff and dependent. They're saying it's ejmali possessed.
Ejmali possessed, but paragraph 4 says while Jagdish was absolutely seized and possessed and or well sufficiently entitled to all that piece and parcel of land measuring about 34 decimal.
No, from paragraph 4 they have culled out from co.
It's all about the gift deed. The
No.
gift deed is 34 decimal.
Yes, we have
That is co. And out of that 161, 2 decimal was not sold to Joydeep by my client, one of the plaintiffs. So 2 decimal out of 161 and 34 out of 161 makes 125. That is not the subject matter of partition, which still remains even if I give a go by to the give deed challenge.
But in para 3, Mr. Mukherjee, you say one Jagdish Agarwal, who is the predecessor, have 61 decimal of land in the suit plot.
161.
One is not there.
No, it's 61.
No, that is
It is there in the gift deed.
Paragraph 2.
61 milad. If
Paragraph 3 at page 22.
1 acre 61. তাই জন্য 161 decimal.
that is
It's
also
only
incorrect.
61 decimal. Para 3,
Para 3 is
22.
yes.
1 acre has
That,
been
that is
missed.
that is a mistake. That's a mistake. The cost schedule is all about the gift deed.
We understood that, but
yes, no, that is a mistake. It is not the paragraph
And
2
prayer milad
and
where
not
they
the
are praying
plain
for
schedule
partition.
4 is 161 decimal. Out
but
of
there is
that
no
160
pleading that Jagdish was owner of the entire thing.
But we have at paragraph 2 said that not the Jagdish, the plaintiff and not the pro forma defendants, they are all
Possession.
occupying, are in possession.
Not co-sharer.
I know not that deficiency in the pleadings.
The plaintiff and the said cost schedule, we understand that it's a mistake, but property is mentioned cost schedule and the said cost schedule property.
Lord, whether I survive on the basis of not the case that I made out or not, Lord, that is for the trial court not to see. As
Mr.
of now,
Bhattacharya
Lord,
says
what
that
is,
you have not made out a prime facie case of title over the entire property.
but as of today, Lord, he is not taking.
You are trying to find out
based
something.
upon 34 decimal. The 34 decimal comes out of not the 1 acre 61 decimal. That is part of Jagdish's property. Now, Lord, of which the balance portion, what that remained, Lord, I take it, Lord, has been devolved upon me by intestate succession, 2 decimals sold to Lord Joydeep, who becomes the co-sharer of the property, and Lord, he is the plaintiff. So, Lord, 34 is the subject matter of give deed, where my learned friend's client is the
That we understand. Only
and
this,
Joydeep is Lord from
there is
the
no
balance.
assertion of your title of Jagdish in respect of the entire property. That's the difficulty because of this mistake in para 3. It's obviously a mistake.
Lord, it is there, but Lord, it is a rectifiable mistake, no doubt about
In
it.
one of my dictations, forefather, the spelling was wrongly. Thank God I checked it. Just imagine, Mr. Mukherjee, that would be the first ground of setting aside. That would set a precedent, landmark judgment. Anyway, but at least in your plain that mistake is
Milord, page 67, Milord. This is my last, Milord.
one more point to point out, Mr. Bhattacharya. I will impose cost on you for taking installments in pointing out. Yes. Submit at one go.
This
Six-
is
67 word.
Milord, give deed, Danpatra. Milord, kindly see, Milord. This is Jagdish's give deed. Kindly see, Milord, page 69. Recitals. Kindly see, Kosho Shubho Danpatra Midong Karjanchage Ami.
Don't read the entire gift.
The fourth line. Kindly see, Milord. Dibno Topshil Bornito, something registry. This one.
21.5
Exactly. উক্ত সম্পত্তির 21.5 সম্পত্তি কিছুদিন পূর্বেই অন্য ব্যক্তিকে বিক্রয় করিয়াছি। Therefore, Milord, there must be a co-sharer.
Joydeep?
Pro formas are there.
Look, then Milord, there must be co-sharers.
Pro formas are there?
That is also not clear to whom he has.
No, you are very universal in respect of the transfers. They were there. The predecessor was very universal. If you come to say, we find after 9, then 10, then 11, 12.
Yes.
So it's very, very
Yes,
secular and
everybody,
universal.
Everybody.
So it reflects the
13
it's
again,
like our country.
13 again within the clan.
So they cannot be 11 and 12 cannot be family members. Must be one of those.
Outsiders.
Has to be outside. You take your points in your written objection.
Milord, these are there, Milord.
We are disposing of the appellates. Mr. Bhattacharya, we are granting that we are making that whatever order we passed absolutely disposal of the temporary injunction. How soon can you file a written outside? You are ready with that?
Almost. Under preparation, Milord, almost.
Here. On consent of the parties, the appeal is taken up for hearing along with the application, since the questions involved are brief. Full next para. By the impugned order, in a suit for partition and declaration challenging certain transfer deeds filed by the appellants, comma, the appellant's prayer for ad interim injunction was refused. Full stop. Next para, learned senior counsel appearing for the appellants argues that although the learned trial judge observed that prima facie it appears that admittedly there are some registered deeds of transfers in favor of defendant numbers 1 and 3 which carry some presumptive value, comma, the learned trial judge went on to hold that the plaintiffs stroke appellants have challenged the deeds to be void, and without holding trial, comma, no inference can be drawn up regarding the legality of the impugned registered deeds of transfer. Full stop. Next para. Furthermore, comma, the learned trial judge observed that there is no scrap of paper on record from which it can be found that the plaintiffs are in prima facie possession at the suit property. Full stop. Next para. Learned senior counsel points out that from the documents furnished in the trial court by the plaintiff stroke appellants, comma, it would be evident that at least the names of one of the plaintiff stroke appellants, being plaintiff number 5 Joydeep Das, comma, finds place in the records of rights. Full stop. Next para. Thus, comma, the finding as to the appellants not being in possession of the suit property was perverse. Full stop. Next para. That apart, comma, learned senior counsel takes the court through the averments made in the plaint to argue that sufficient prima facie case for challenging the gift deed dated July 4, 2017, comma, allegedly executed by Jagadish Agarwala, comma, the predecessor interests of the appellant numbers 1 to 4 and some of the respondents, comma, as well as the consequential sale deeds, comma, has been made out. Full stop. Next para. Moreover, comma, it is pointed out that the suit being one for partition, comma, the endeavor of the court ought to have been to maintain the property, to preserve the property till disposal of the suit, in order to ensure that the final outcome of the suit is not rendered infructuous at an early stage. Full stop. Next para. Learned counsel appearing for the defendants.
Only one respondent number 1.
Acha, which one? One. Defendant stroke respondent number 1
Sham
argues that from the averment made in paragraph number 22 of the plaint, it would be evident that the suit is palpably time barred, comma, since it has been mentioned therein that the cause of action of the suit arose firstly on July 4, 2017, comma, the date of execution of the deed of gift, comma, whereas the suit has been filed only in the year 2025. Push up. Next para. Even otherwise, comma, learned counsel argues that from the materials before the court, comma, it would be evident that the appellant numbers 1 to 4, comma, members of the same family as the defendant stroke respondent numbers 1 to 4, comma, transferred a portion of the suit property to plaintiff stroke appellant number 5 Joydeep Das, comma, who is a stranger to the family. Full stop. After having so transferred themselves, comma, equity demands that the plaintiff's appellants ought not to be permitted to seek an injunction restraining the defendant stroke respondents from effecting similar transfers. Full stop. Next para. Learned counsel also takes the court through paragraph number 2 of the plaint and points out that the entire property mentioned in Schedule Q of the plaint has been mentioned to be only in joint possession of the plaintiffs and the defendants and pro forma defendants, whereas the statements in paragraph number 4 clearly enumerate that Jagadish Agarwala, comma, the the original patriarch of the family, comma, was only the owner of 34 decimals of property. Full stop. Thus, comma, the total property enumerated in Schedule Q does not tally with that belonging to Agarwala as mentioned in paragraph number 4. Full stop. Next para. Accordingly, comma, it is argued that the suit itself being not maintainable, comma, the learned trial judge was justified in refusing to grant ad interim injunction. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that the learned trial judge, comma, while observing that no scrap of paper has been produced by the plaintiffs stroke appellants in respect of their position, comma, the learned trial judge overlooked the extracts of the records of rights from which it transpires that at least the name of plaintiff stroke appellant number 5 has been recorded in respect of a part of the suit property. Full stop. Thus, comma, it cannot be ruled out that the plaintiffs are in possession of the property. Full stop. From the facts narrated in the plaint, comma, it would be evident that the appellant numbers 1 to 4 have transferred a portion of the property belonging to their share to the plaintiff stroke appellant number 5. Full stop. Next para. Insofar as the argument of limitation is concerned, comma, the contesting respondent number 1 has made out a strongly arguable case, comma, inasmuch as a question arises as to whether the suit is time barred insofar as the challenge to the parent gift deed dated July 4, 2017 is concerned, comma, having been instituted only in the year 2025. Full stop. It is to be noted that Jagadish Agarwala, comma, the donor and the predecessor in interest of the plaintiff numbers 1 to 4 and the defendants, comma, never challenged the said gift deed during his lifetime. Full stop. Thus, comma, it is thus, comma, there is some thus, comma, it is contentious as to whether the suit is or is not barred by limitation insofar as the challenge to the deeds in question is concerned. Full stop. Next para. Be that as it may, comma, even if it were to be assumed, comma, without observing, comma, that the suit were to be barred by limitation insofar as the said declaration is concerned, comma, fact remains that the partition suit encompasses other properties than those transferred by the said deeds and, comma, as such, comma, would be otherwise maintainable. Full stop. Next para. From paragraph number 1 of the plaint, comma, 2 of the plaint, comma, 2 of the plaint, comma, we find that the cost schedule property has been narrated to be in within double inverted Ezmali, EZMALI, double inverted close, possession of all the parties. Full stop. Although the title of the plaintiffs has not categorically been asserted in the said paragraph, comma, the connotation of double inverted Ezmali, comma, although literally meaning joint, comma, is extended generally to joint possession of co-sharers. Full stop. As such, comma, it cannot be altogether ruled out that the plaintiffs have asserted title in respect of the entire cost schedule property, comma, that too at the ad interim ex parte ad interim stage. Full stop. Next para. Moreover, comma, in paragraph number 3, comma, it has been stated that Jagadish Agarwala, comma, the predecessor of the plaintiff numbers 1 to 4 as well as defendant number 1 had 61 decimal of land in the suit plot, whereas the total property mentioned in cost schedule property is 1 acre 61 decimals of land, comma, which gives rise to a doubt as to whether the same is an error on the part of the plaintiffs. Full stop. Next para, even otherwise, comma, from a conjoint reading of the entire pleadings of the plaintiff, comma, it is evident that the plaintiffs assert right in respect of the entire custodial property. Full stop. Insofar as paragraph number 4 is concerned, comma, learned senior counsel for the plaintiff stroke appellants has rightly pointed out that the restriction of the pleadings to 34 decimals out of the suit property in the said paragraph pertains to the subject property covered by the gift deed which has been assailed in the suit as well, and does not speak about the entire suit property. Full stop. Such contention is also corroborated by the fact that the suit property has been delineated under two schedules, comma, being cost schedule within bracket total plot bracket closed and the cost schedule, comma, thereby demarcating the portions of the properties in portions of the entire suit property, comma, into the total property and the property covered by the transfer deeds. Full stop. Hence, comma, the averments in paragraph number 4 do not circumscribe the overall assertion of title to the entire custodial property by the plaintiffs, comma, at least ex facie on a plain reading of the plaint. Full stop. Next para. From the above discussions, comma, we find that sufficiently triable issues to go for trial has been made out for the purpose of grant of injunction. Full stop. Even otherwise, comma, in a partition suit, comma, it is the effort of the court to preserve the property till disposal of the suit. Since, comma, otherwise, comma, the suit runs the risk of being rendered infructuous. Full stop. Next para. Even otherwise, comma, the challenge to the deeds in question can only be conclusively decided upon trial on evidence, and it would be premature at the inception of the suit to hold either way. Full stop. Next para. In view of the above, comma, the impugned order cannot be sustained. Full stop. Accordingly, the FMA 364 of 2026 is allowed on contest against the respondent number 1 and ex parte against the others, comma, thereby setting aside the impugned order bearing order number 5 dated February 9, 2026, passed by the learned civil judge senior division at Chanchol, district Malda in partition suit number 83 of 2025, and directing both parties to directing both parties to maintain both the plaintiff stroke appellants and the defendant stroke respondent numbers 1 to 4 to maintain status quo in respect of the suit property insofar as selling, transferring, alienating, and or creating any third party interest and or changing the nature and character of this and changing them and or the nature and character of the same is concerned, comma, till disposal of the temporary injunction application in the trial court. Full stop. Subject to the defendants respondents filing their written objection to the temporary injunction application in the trial court within a fortnight from date, comma, the learned trial judge is requested to dispose of the injunction application itself as expeditiously as possible, comma, preferably within 6 weeks from the date of communication of this order to the learned trial judge. Full stop. Next para. We make it clear that the merits of the case have not been entered into by this court, and it will be open to the learned trial judge to decide the injunction application and the suit independently without being influenced in any manner by any of the observations made herein above or in the impugned order. Full stop. Can 1 of 2026 is consequentially disposed of as well, no rest cost are
Great.
For you.
ও আচ্ছা তাহলে তো এসে গেছে তাহলে স্যার
Party against the
তাহলে
Respondent numbers
1 and 3 appears.
contest against respondent numbers 1
and 3 and
1 and
party
3.
against.
1 and 3 expert against the others. আর প্রথমে একটা affidavit of service filed to be kept.
Affidavits of service.
Plural clause. Affidavits of service filed by Mr. Arijit Bardhan be kept on. Yes.
Much obliged. Grateful.
Please, I would like to make some.
Not in the middle of a matter. Yes. Call on the list.
করতে এসছি। না না, ফাইলটা মনে হচ্ছে অ্যাফর্ম করা। You are trying to file that affidavit in opposition? No, our filing means affirming. You file it on the next day, no difficulty.
You extended the time for today, so I have.
Next. Call on.
Plus 10.
We are not a information box, ma'am. Call on the next matter, please. Yes.
29, my lord, I'm appearing for the appellant. My lord, there are two appeal. This is 35, another one is 36. My lord, there are two suits between two brothers. I'm the plaintiff, another one I'm the defendant. My lord, one suit is for cancellation of the deed. My suit was cancellation of the deed, and his suit is for declaration and declaration
Both the
of
appeals are,
possession. My lord,
appearing before us.
My lord, that should have to appear conjointly. My lord, this was
Whatever you mentioned is appearing.
My lord, both I have mentioned. My lord, this sleeve has been sent to SS section, my lord, second application, but file is lying in RD section. My lord, that's why the file does not come.
So you should have indicated in the mentioning slip where it is lying.
My lord, along with that, an application is pending for restoration application. That matter was dismissed for default. My lord, that
Whatever is before us, please move it, Mr.
My lord, both the my lord,
No,
unless-
restoration application is pending means it's already dismissed for default.
My lord, unless the
We dismiss this and that will govern the other suit, other appeal? Yes.
My
What is the matter?
My lord, unless
In any event, we'll dismiss this if you don't argue right now.
my lord, unless my the suit for declare
Your other appeal has been dismissed for default. We are not bothered with that, Mr. Banerjee. We have an appeal before us, please move it. And this will govern the other appeal.
My lord, this appeal in my previous appeal is for cancellation of his deed. Unless that has been
That has been dismissed for default, we are dismissing this also.
My
That is not there in the eye of law. We are dismissing this. We are taking note of your
both of them
submission.
should have been heard
No question of hearing analogously. One is dismissed for default. No
My lord,
question
I
of
have filed the restoration within
that doesn't
8
give you a right to get that application allowed, Mr. Banerjee. Restoration is pending means it's no longer there in the eye of law. Learned counsel for the appellant submits that another connected appeal was dismissed for default, for which an application for restoration is pending. Full stop. It is submitted that both ought to be heard together. Full stop. Let this matter go out of the list with liberty to the appellant to mention the restoration application. But ওটা যখন রেজিস্ট্রেশনটা অ্যালাউ করব, যদি রেজিস্ট্রেশনটা অ্যালাউ করি তখন রেজিস্ট্রেশন অফ সার্ভড আ কপি
My lord,
we directly to serve copy.
no, even then I
That service ওটা সার্ভিস করবে করবে যখন আসবে একসঙ্গে রেজিস্ট্রেশন যদি অ্যালাউ করি তখন দুটো ডাইরেক্ট করবে এখন আউট অফ লিস্ট ইয়েস নেক্সট
Item number 30.
My lord, I am led by Mr. Parthampati Mukherjee.
Where is he?
Due to ill health, he has not come today, my lord.
Due to
Ill health, my lord.
what sort of ill health? I will take details from you.
My lord, he's instructed me because he was not medically.
No.
The
You move the matter. Otherwise, it goes out of the list. Every morning we are being flooded with mentionings. We are having to say no to everybody individually. And when the matters are called on time, sorry, we refuse to grant adjournment. You are the advocate on record?
No, my lord.
Then you don't have any locus standi to pray for time. We are dismissing for default.
My lord,
An adjournment is sought on behalf of the appellant. Let the matter stand adjourned for the day. Next. After line adjournment is sought on behalf of the appellant on the ground of illness of learned counsel for the appellant. Matter is adjourned for the day. Next.
Number 31.
My lord, learned senior advocate Gopal Chandra Ghosh is appearing on behalf of appellant.
Same. Illness ta na kore on the personal ground of learned senior counsel for the appellant. Next. Give your appearance, ma'am.
I prefer the appellant, my lord.
Yes, sir.
Defendant in a suit for declaration is the appellant before your lordship, my lord.
Declaration of title.
Declaration of title regarding co-scheduled property and injunction, permanent injunction that the defendant cannot disturb plaintiff's possession or enjoyment of the co-scheduled property.
Co itself. What is co then?
Co is not
part of
adjoining blood part where now I am residing. It's not dispute blood of two adjoining properties. We have purchased blood from the same common owner.
Achha.
Now
Co has been purchased by them.
co has been, but they claim my defense case is that what they are portraying as co in the schedule of the plan.
Their case is that co purchased by them, co belongs to you.
Co belongs to me. I am encroaching upon co schedule. Co. My specific defense case was in the written statement that the description of co schedule is mistaken. It is a sweet shop which I was possessing and enjoying upon being upon the property being devolved upon me by my predecessor, who has purchased from the same owner. Now,
your predecessor purchased prior to them?
Prior to them, 86, 87, and they have purchased in 2006.
But you have not challenged their
deed has not been challenged. But my lord, the identity of the property of the schedule has been challenged. Now, my lord, trial court dismissed the suit, holding that the property is undemarcated. All the parties are co-sharers.
Undemarcated between co and co.
Between the plaintiff and the defendant.
Co and co have not been partitioned.
Not been
partitioned. There is no demarcation of co
no
and
demarcation. Yes, that is the finding of the trial court, my lord, in my favor, which was challenged, my lord, by the plaintiff in appeal. The appeal court, after going through the deeds, came to the finding that the deeds have demarcated schedule. So it is not a case of purchasing undemarcated share only. Demarcated shares.
Just hear this song and then we'll go. Yes. No, it's over now. Yes.
Demarcated shares have been transferred to the parties, so there's no question of the parties being co-sharers.
So you say in the absence of any partition by meets and bounds, this was wrong. That is the ground.
That is the finding of the trial court, that there's no partition. But I am not. I'm not on that.
Also. Oh, you're not.
That is that I am not pressing that ground. But I find that the purchase deed of the plaintiff is not having a demarcated share. I am not pressing that point. My point is, my lord, none of the courts have considered my prime contention that description of co-schedule property is erroneous. It is actually my property, which they are portraying as a co-schedule property and asking for a declaration. If that be so, that adjoining contiguous properties and description of the schedule is disputed, in that case, he will have to prove that by way of local investigation.
Mr. Banerjee, two things. One is that, did you produce your predecessor's title deed?
Yes, I produced. I produced 2 deeds.
And was it an issue in the trial court regarding boundary dispute?
Lord, I have not specifically pleaded in
trial court also did not deal with that.
No, none of the courts, the trial court didn't deal with
that. The issue was framed on that. I mean, how do you know that?
None of the courts dealt with this point. Trial court dismissed only on the ground that it is a co-sharer property. So you are co-sharers, you cannot ask for a declaration regarding a particular portion of a property. Appeal court only
show us your written statement or something.
My lord, W statement. No copy there. No copy there. First, you will find that paragraph 6 at the first page.
Yes, 6.
I specifically will dispute the rough sketch map of the schedule, paragraph 6, and also paragraph 6, page 6. Also, page 6.
We'll keep these copies.
My lord.
This will keep on record.
Yes, yes.
Either way, if you lose it.
Either way. And lord, page 6, my lord, where again I have, my lord, taken the same point. Rough sketch map. So it Sangyukta sketch map Sadrishya 9. So this specific point was taken in the written statement. Now, my lord,
sketch map or Dolile's Sangyukta sketch map. No, you have pointed out a difference between the deed and the
schedule of the plaintiff. So I am saying what the plaintiff is seeking for declaration that he is owner of the co-schedule, that is not at all purchased property of the plaintiff. It is falling within my property. That is my defense case.
Can we get a copy of the plaint, Mr. Banerjee?
Plaint copy there?
Rough sketch map is like a child's drawing.
Absolutely. And my lord,
nothing.
Description has been given, which I specifically say that he is actually, there's a shop room, sweet shop. My specific defense case is that I was enjoying that.
Mr. Banerjee, if the title deeds are seen by the court and the court comes to a finding that A has been given to you, them and...
No, court has not gone, court has not carried out that endeavor. Court has not decided that at all. The point...
The deeds were before the court.
Deeds are before the court, but court has only gone into the issue whether it is a partition property or not. And appeal court, by holding that no, it is a partition property as per the schedules, so it is not the trial court is incorrect, and he has established his title. No title over, my lord, the schedule. Can, my lord, in my humble submission?
Deeds were before the court. From the deed, it will be, if you see the deeds, the schedule of their deed, you say that will differ from the custodial property.
That is my case, specifically.
That is not exactly your case. That is the difficulty. See, in page 6 of your written statement, Mr. Banerjee, you say মাননীয় বিচারপতি বাদীর নালিশি আর্জি ইনজাংশন প্রার্থনার দরখাস্তের সহিত প্রদত্ত রাফ স্কেচ ম্যাপ ও দলিলের সহিত সংযুক্ত স্কেচ ম্যাপের সাদৃশ্য নাই। So you refer to the sketch map only. আচ্ছা, you say তথাকথিত and then you say তথাকথিত ক তপশিল বর্ণিত
সম্পত্তি বাদী কোনোদিন দখল করেন নাই।
Don't deny his title regarding the custodial property.
I have disputed, not paragraph 6, first page. নালিশি আর্জির তফসিল বর্ণিত সম্পত্তিতে বাদীর কোনরূপ সত্য দখল অধিকার না থাকায় অধিকন্তু নালিশি আর্জির সহিত প্রদত্ত রাফ স্কেচ ম্যাপ নালিশি সম্পত্তির প্রকৃত তথ্যের পরিচয় না।
In conjunction you have stated.
Yes. Paragraph 6 and page 6. So this point was taken. None of the courts have not decided. I humbly submit that in case of a boundary dispute, disputed identity of two contiguous properties.
But if it was your case, you should have sought for the injunction. In the absence of an
plaintiff is seeking for the declaration.
You did not file a cross objection. You did not raise this point before the appellate court. Why should in the second appeal for the first time? Why should
the courts none of the courts have decided this point at all.
Mr. Banerjee, we appreciate, but yes, you took it in your written statement. But there are several points we can party can relinquish any of the grounds taken in the written statement of the plaintiff. You never argued this before the trial court, nor before the first appellate court. You never took out any cross objection or never argued this. If there's no reflection in the first appellate court, why should you permit you for the first time? Because this is a mixed question of fact and law.
This was the crux of the written statement, and it was argued before that.
See, Mr. Banerjee, part of written statement, yes, we find from the written statement. But before the first appellate court, you could have taken this point.
Now, my lord, in my defendant's case, my lord,
even before the trial court, you should have asked for a formulation of an issue on this before the trial began. Let us see the issues once. Two additional issues are there; those are different. Entitled to greater deed, that's general. Any other relief. Where are the original issues? Let us just check up.
If your lordship will kindly see the finding of the trial court.
Your predecessor's deed was exhibited, you said?
Yes, yes. My predecessor's deed as well as the plaintiff's deed. All were exhibited.
No, there is no exhibit A series.
Lord, my deeds
yes,
exhibit
my
A and B. A and B.
Page 8.
My lord.
So Shambhunath Kole in favor of Ramka Nemal is your
my lord.
All right.
I'm not then. Issue number 4 will not cover this point. Whether plaintiff has any right, title, interest over the custodial property or not. That is specific issue framed.
Yes.
On which the court has given a finding that he doesn't have a absolute ownership over the property.
Where is that finding?
Issue number 4, my lord, is dealt with from my lord.
Yes, page 11.
Page 11 onwards. 4 and 5.
Let's just check.
After recording the findings, kindly come to page 13. Last paragraph onwards. This is the factual finding that it's an undemarcated property. So if the court comes to the finding of undemarcated, then the question of boundary dispute doesn't
page
come.
13 of the trial court on perusal of exhibit A and B.
On perusal of the exhibit A and exhibit B, it appears to this court that the defendant had purchased 3.5 decimal and 0.5 decimal of land by virtue of the deed of purchase being number so and so, respectively executed by Shambhunath Kole in favor of Ramka Nemal. On further perusal of the exhibit C, D, E, and names of the defendant number 1, 2, and 3 is recorded in the LR record of right in respect of their respective shares in plot number 950. Exhibit F and exhibit G reflects that food license is issued by the Office of the Licensing Authority and CMOH, Chandanagar, Government of West Bengal, in the name of Ramka Nemal, which was later issued in favor of Rupali Mal. On the other hand, on perusal of exhibit 1 and 2, it transpires that plaintiff purchased 1.09 decimals of land from Shambhunath Kole, and the same was recorded in LRRO.
But Mr. Banerjee, you should have then asked for a local investigation. You did not ask for it. The specific issue was framed. You did not prove your pleading. Only the pleading won't do. You have to prove that.
But in
it's your case.
The first onus is on the plaintiff to show when
it's your positive case that there is a discrepancy. Plaintiff produced the deeds of whatever deeds are there. Both of you produced your deeds. Court proceeded on that premise. It's your case that there is a discrepancy. But then it was your onus and
But my court has not considered the issue at all. If a lordship
court
sees
frames an issue and court decides it.
frames the issue, but not the point of disputed identity of the property has not been touched by the either of the courts. Because trial court goes by saying that it's unpartitioned, then the question of any schedule doesn't arise.
Raise it at the time of hearing, Mr. Banerjee. Taking any point in the written statement won't do. There are so many points in the written statement. Parties may not press it. We don't find anything on that. But yes, you are right. Issue 4 may broadly cover it.
Issue 4 will cover it. So the point
that
now kindly come.
That is a different issue. That is on their plane. They claim title over constituted property. That has been framed as an issue.
If the moment
dispute is
the moment the trial court comes to the finding that it is an unpartitioned property, it will not go into whether it's a schedule is correct or not.
Taking that point in a cross objection or at least arguing that point in the appellate court.
In my humble submission, once the court comes to the finding that it is unpartitioned, then the question of taking this point by me doesn't arise, because if the court finds that the properties are distinct, then only the question of two contiguous property comes in. Now the court comes to the finding that the properties, there's no contiguous property, everybody is owner of every property. Now in the appeal, my lord, when the appellate court topples this finding that no, these are two separate properties, then my lord, it's the duty of the court to decide whether at all this cost schedule is correct or not. Because otherwise I need not prove that by preferring a separate cross appeal, because the finding is that all the same, all the parties are not co-owners of the entire property, entire dag. If that finding is there, at the same time the court cannot go into the issue of identity of the property, because everybody is owner of everything. So nobody is owner of cost schedule or cost schedule. Every person has share in every inch of the property. That is the finding of the trial court.
When the matter went up in appeal, appeal court was in season of the entire matter.
Yes.
This appeal remained open for you to be taken.
Now in appeal, when the court toppled this finding, this I'll have to find from the argument.
No, because your point still remained unresolved by the trial court. So you should have approached the appellate court and said that resolve this issue as well.
The argument of the appeal court.
There was always a risk of the appeal court toppling it.
But may I just...
Yes, whether there is an argument.
Yes, my lord. It was argued. Kindly see, my lord, kindly come to page 5, bottom. On the other hand, learned advocate for the respondents argued that the suit property originally and previously belonged to Shambhunath Kole, who executed a deed of gift being number 1490 of 86 in favor of predecessor in interest of the defendants, namely Ramkanai Mal of land so and so, put him into possession. After the said transfer, Ramkanai Mal constructed dwelling house over 3.5 decimals of land, started to live with his family. Thereafter, again, by purchase deed number so and so, Ramkanai Mal purchased 0.5 decimal of land from Shambhunath Kole. It is mentioned in the deed of 87 that there is a portion of sweet shop of Ramkanai Mal situated on the western side wall of the shop room is a common wall with the eastern side wall of his residential unit. Now, after demise of Ramkanai Mal, the sweet shop closed down and appellant is trying to grab the same forcibly. It is further argued that appellant fraudulently purchased 1.09 shatak of property from Shambhunath Kole by keeping the respondent in dark, and there is no similarity between the plaint and the rough sketch map. So this point was argued, Miller.
Let us see if it was dealt with page 9 of the appeal court. Page 9, second paragraph, is it this issue?
The appeal court goes on only on whether section 14 has been satisfied.
Please come to page 9 of the appeal court.
So last paragraph, second paragraph. Now, one of the contention of the learned advocate for the respondent is that Shambhunath Kole did not have 1.09 shatak of property in the suit plot after the previous transfers, and if the previous deeds executed by Shambhunath Kole is considered, total property.
It has been dealt with. Because see, if you see page 5 and 6, that culminates in it is further argued that appellate fraudulently purchased 1.09. Sweet shop specifically, but the title deeds were before the court.
Title deeds are there.
Title deeds, if the title deeds tally with the scheduled property, the sketch map says nothing. Sketch map is just written there. But the scheduled properties, if the schedules of the deeds respectively tallied with the schedules
Oh, that endeavor was not carried on by the court also. If your lordship sees me after this, my lord, court only goes on that by holding that no, there was partition because not partition, separate property was.
Let's come to point number 3 and 4 of the appeal court, Mr. Banerjee. Page 8 of the appeal court. Plaintiff has filed this suit for declaration of title for
injunction
1.09.
My lord.
In LR plot number, in order to prove case,
plaintiff has filed original
as exhibit 1, pertinent to mention, purchase portion is shown in annex deed plan, marked with red border. Also filed record of rights, filed original government receipt. From these documents, it is proved that the plaintiff has got title over the suit property and possession of the same.
No, it is proved that he is owner of 1.09 Shatok and his name is recorded in respect of 1.09 Shatok. Now, whether, my lord, the co-schedule property which he is giving in a sketch map, that is, my lord, within this 1.09, this.
But Mr. Banerjee, it was your burden and initial onus to ask for a local investigation. You never pressed this point. You argued, but never.
Point was in the appeal, it was argued. Because
yes, argued, but you did not ask for a local
the court
investigation.
Didn't go into this issue at all, my lord. Court should have gone into the issue and decided. Now, court goes on after this, my lord, that he has proved his ownership. It's demarcated, so there is no question of share.
Section 100, Mr. Banerjee, you know, on account of a mere irregularity, it cannot be passed. If we can say, you could have said this is a major issue if you had brought in evidence on record to substantiate this question. Before neither of the courts, you even asked for any local investigation, did not prove your point.
So that application was not filed, my lord, but I humbly submit that when the plaintiff wants to prove that he is owner of a particular schedule, my lord, and that is disputed by filing written statement issue being framed. Also, some onus is on him to establish his case by showing the schedule, proving the schedule.
Which ground in your memo, Mr.
Ground number 1, my lord. Judgment of the
and you raised this issue. The dispute was raised by you. You should have proved it. You should have proved it.
No, disputed identity, my lord. If not, I set up. I raised the issue by way of, my lord, my pleading. And the issue is framed whether he is owner. Then, my lord, primarily his duty, my lord, to show that he is the owner. And the court doesn't go into venture into the aspect whether at all from the deed it is proved that cost schedule matches with.
Yeah, very well. We are admitting. This second appeal will be heard on the following substantial question of law: whether the first appellate court substantially erred in law in reversing the judgment of the learned trial judge without resolving the specific issue raised by the defendant stroke appellants as to the identity of the two contiguous properties belonging respectively to the plaintiff and the defendants, as well as without adjudicating whether the title deed of the plaintiff tallied with schedule core of the suit, the schedule core property of the suit, comma, in respect of which the plaintiff stroke respondent claims title. This much. Any interim order?
I filed a stay application, my lord, that there's every possibility that they might now change the nature and character of the cost schedule property. This can 1. Can 1, paragraph 7, I have pleaded. No execution started.
No, what is the decree ultimately then?
Decree is not declaration that he is the owner and I cannot disturb his ownership, his enjoyment of the property over cost schedule. If he changes the nature and character, my lord.
Just let us see the appeal court decree. But injunction, we cannot stay injunction. Peaceful possession in cost schedule.
That has been granted unless we allow the appeal.
Granted, although says part in part, my lord, declaration is also given, and last, my lord, not to cause hindrance. So indirectly injunction is also given, my lord.
Yes, injunction is given. Permanent injunction decree is there. Unless we allow the appeal, that will be upsetting that by way of an interlocutory order here.
But status quo will be maintained. I say, my lord, I am in
Who will
possession.
give you liberty to file? Have you made any averment in the application? We can mold the prayer, but
My averment is, my lord, that he might disturb my possession or make construction.
no, Mr. Banerjee will give you liberty to specifically give you liberty to file it. We'll dismiss this.
Fine.
Can 1 of 2024 is an application for stay of operation of the impugned judgment and decree of the first appellate court. Full stop, next para. By the said decree, comma, however, comma, the title of the plaintiff stroke respondent was declared. Full stop, over and above, comma, permanent injunction has been granted in favor of the plaintiff stroke respondent, comma, restraining the defendant stroke present appellants from causing any hindrance in the peaceful possession of the plaintiff in respect of the cause scheduled property. Full stop, staying the operation of the same at this stage would tantamount to reversing the permanent injunction as well, and might have the effect of allowing the appeal before the same is decided finally. Full stop, as such, comma, we are not inclined to grant such stay. Full stop, hence, can 1 of 2024 is dismissed without any orders to cause. Full stop, however, comma, since the appellants also allege that the respondent, plaintiff stroke respondent, is seeking to change the status quo in respect of the property, comma, leave is granted to the appellants to file an appropriate application for injunction. Full stop, if such an application is filed, comma, the same will be decided without being influenced by the dismissal of the present application. Full stop, next para. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment before the appropriate learned single judge having determination as and when the same is ready for hearing.
Obliged.
My lord, on behalf of I am for the petitioner, kindly not today. I am saying for kindly not today. My
No, have you rectified the defects? We directed you to remove the effects. That was long back on 14th of July. Today we are on 27th of July, 28th of July. 2 weeks back. Let us see whether we have removed the defects.
My lord, my senior did not come. He is very ill. I am.
From when? From when is he ill?
Next.
He was appearing on the last occasion.
My lord, I am not aware case of the facts.
1 minute. An adjournment is sought on the ground of illness of the learned counsel, on the ground of illness of learned counsel for the appellant. Let the matter stand adjourned for the day. Yes.
34 Lordship, I beg to appear on behalf of the appellant.
What defect has not been removed?
Lordship, there were two defects. One is
You are
that,
given 2 weeks time to do it.
yes, we have taken out an application, Lordship. That application is CAN 3. That is a leave to file appeal. Leave to file this appeal, Lordship, because the
rest of the defects have been cured.
And Lordship, one other defect was there, that is with regard to the name of the learned judge. Lordship, this is of 2017. Lordship, my client inquired in the court below but could not find
The appeal is not in form. There should be some noting somewhere. 2017.
Yes, we are coming up pursuant to a leave granted by the Honorable Supreme Court because there was an order, Lordship.
Nowhere from the records you could find the name of the judge. It went up to the Supreme Court, then there must have been some other memorandum where it has been mentioned. Ask for the papers from your client.
Lordship, the Supreme Court is there. Lordship, the order is annexed. Lordship, but
Supreme Court order won't contain the name of the learned trial judge. In the memorandum filed before this court,
Yes.
which went up to the Supreme Court, you would have found the name of the trial judge.
It was against a revisional
Different order.
Revisional order, Lordship, not this order.
Not this order.
Not this order.
These are the two defects.
Yes.
Why leave?
Leave because, Lordship, if my lord takes up the memorandum of
You're
appeal.
not parties.
No. The
condonation application also there.
condonation application is there.
Appearing for the first time.
Appearing.
Yes, serve all and come back. Learned. No, we are extending the time. Please try to find out the name of the.
I will.
You can ask for, you use your resources and inquire from the department of the concerned court.
I will.
Which court?
This is the civil judge senior.
South Central Propaganda is your domain. So you inquire from the office, have someone inquire to some experienced clerk there. On the prayer of learned counsel for the appellant, the time for curing the defect in the preamble of the memorandum of appeal insofar as the name of the learned trial judge is missing, is extended for 4 weeks from date. For sub next para, the appellant shall serve copies of Can 1 of 2025, Can 2 of 2025 and Can 3 of 2026 on the respondent, indicating that the matter shall be listed under the same heading in the monthly list of September 2026. When an affidavit of service to that effect shall be filed by the appellant.
I'm grateful.
Appearing at my instance, 35 is a previous appeal.
Board dekhao, Dipankar.
Appeal that was filed from a ad interim order in a suit where I was not a party. I had filed an application for addition of party in that. That was rejected. Thereafter, we prefer an appeal, a leave to appeal, and a condonation of delay. The leave to appeal was allowed by your lordships here. The condonation of delay application was getting contested when they came and said that the ad interim order has now been confirmed and a final order has been passed. That final order, again, we were assailed by this appeal, which is appearing as item number 37.
Which is the appeal against the parent order, first order.
35.
Look into that because the rest are extensions of that.
The final order, my lord. No.
Final order, the injunction application has been disposed.
That's
yes,
right.
yes.
So
Everything has
now
merged.
merged with this. So my
which one is that one? Last one.
last one is 37.
36.
36.
The new one is 36.
New one is 36.
36 is the against the final order.
Against the final order disposing of the injunction application. This has merged with that.
Everything else has merged in that.
Yes. Now, only thing is, 36, naturally, again, I had to file a leave to appeal. So, to have that leave to appeal, I will rely on your lordship last order.
36.
36.
All the annexures are there in the 36 paper.
Yes,
also.
Yes, thanks to our last time contestation, this time the pleadings, if your lordship will,
is much better.
10 pages more.
10 pages more.
More of pleadings.
86. See, last time he had taken the point that it was cryptic. This time we looked at it and made it as verbose as we could have. But anyways, this time it was covered by
36. 36 Dipong help karo.
31.
26.
This one, no?
Yes. So, leave application first.
Leave application first.
How are you affected?
Can 1 is the leave application.
You are opposing the leave application.
Again.
Yes, yes. So confident, everything will.
Lordship, because now the sheet anchor of theirs that they had a debt, that itself has been questioned and has been. So I will come to that.
Very good. Lord, I'll just indicate briefly. In fact, not required. From the last, if your lordship looks at Can 1.
Kindly have a look at page 86.
Oh, your addition of party application was dismissed.
My addition of party application was rejected. But the suit pertains. But may I just show your lordship's previous order?
One of the
86?
prints of Mr. Sinha's arguments to
Maybe
contest the
last
leave
time,
application
but
also.
this time it's over because same party, not even as a precedential value. This time it's binding on him because between the same parties challenging the ad interim order we've come up, leave was granted. Now that order has merged into a final and the injunction application has been disposed of. He can't today, without having assailed that first order.
You have annexed that order.
I've annexed that order,
page
page 86. And my lord, that order very succinctly records the scope of the suit and my affectation of right also. 86, if your lordship has a look at, I'll place this order, my lord.
If the leave application took 11 pages, we'll go through this order and come back on Monday and then decide.
Last time you had given 4 paragraphs. Mr. Sinha vociferously argued that I have not made the relevant pleadings. So this time I sat on Sunday and added whatever he said I didn't have.
But this time he may come up with something else.
No, this time I know what he'll come up with. So we've covered that too.
He has not covered it here. He has covered it in Can 3.
Very well.
Page 200. That's how we also got to know. Thankfully, that's how we also got to know that this entire transaction, they themselves apparently have gone into.
You don't hijack his arguments. Let him argue.
No, I thought he was coming back on Monday. So that's why.
No, I don't need to come. This order is there.
Yes, actually, this longish order. What is the crux of this order?
The crux of this order is.
No, Mr. Sinha will take it.
The crux of this order is the suit pertains to, my lord, the plaintiff files a suit against the defendant saying that the plaintiff has lent X amount of money to the defendant.
Mr. Sinha is for the plaintiff or the.
Mr. Sinha, he's for the plaintiff in the suit.
And who is for the defendant? Not represented.
They're more or less the same. So,
Your Lordship, the thing is, they are together.
so anyways, that's a record that's going on in every court. So, even in the arbitration, he plays that record. He's not there, they. So the suit is that plaintiff has lent money to the defendant. The defendant, by a letter of comfort, has given its shares, and these shares should not be dealt with. And there is an ad interim injunction which is passed that this defendant will not deal with its shares, that is given in favor of the plaintiff by way of a letter of comfort without taking leave of the court. It's finally now disposed of, saying that you will not deal with the shares at all. Now, in this arrangement in the suit, what is suppressed is the appellant before your lordship had, by a prior agreement, lent a sum of in excess of what, 100 odd crores?
96 crores.
96 crores, where the entire shareholding of Kitply that Platinum held was charged in favor of this appellant.
Including all these shares which are.
Including all these shares. Now, I have invoked that pledge and an arbitration is going on. My section 9, I have an injunction already. Now, because of this order that is passed in the suit.
What injunction do you have in the section 9?
That they will not deal with or with the assets. And the arbitration is going on. In that arbitration, 17 order is passed confirming the 9. That final 17 application is pending.
Basically, this injunction also restrains them from dealing with the.
But it affects my right. And so far as leave to appeal is concerned, I have 2 issues, my lord. First, just by drawing strength from your lordship's last order, A, they have no right of audience now. Because at order 41 admission stage, if they don't have a right of audience, at leave to appeal stage, they don't get a greater right. That's my first point. Secondly, in this suit from that order, this honorable court, I'm not on the strength of or the composition of the bench. It's different than it was the same, but then
composition is not exactly the same.
Then this
different.
court, the division bench has held that such an order, my right is affected because of the nature of transaction that I have had with this defendant. Whether the injunction will go or not is when I at least have a foot in the door. For leave to appeal, and instead of not relying on the English that I speak, your lordship will just look at some of the paragraphs from this order at page 86.
That is not in English.
No, that is in English, but better English. Not.
And so you also rely on the principle of res judicata.
Yes,
but if they did not have a right of audience, Mr.
Your lordship has given them the right of audience. holding in this order that he doesn't have a right, but for the sake of justice and completeness,
That may be an alternative argument also, because if they, anyway.
that anyways is covered here.
We'll continue with this after.
Yes, Milord, we'll come back at 2 o'clock.
Can we come back next week? 2
Where is
o'clock
so surreptitious and
No, 2 o'clock. I may have to be engaged in
Mr.
somewhere.
Sinha is saying something in a conspiratorial.
2 o'clock, I may be engaged in another place. Your Lordship. That matter may be taken up. That's why I'm saying it can be kept at 3 o'clock. I can come back at 3.
No,
Otherwise,
we'll come back tomorrow.
Tomorrow. No
Come back
problem.
to
We'll come back tomorrow.
come back tomorrow.
We'll come back.
Better.
Tomorrow second half.
After commencement of the hearing, comma, the recess intervenes and learned counsel appearing for the respondent one apprises the court that he will be in some difficulty after recess. Whosoever accordingly let the matter stand adjourned for the day. Yes.
Item number 38.
Yes,
Please.
please. Yes.
I'm for the respondent number 1 and 2.
You are on caveat?
Yes,
Caveat. Yes, sir.
1 and 2 are the main parties, main contestants?
Are the main parties, my lord. Yes. The
Good.
main parties.
Good. What is the matter?
My lord, I have come up before your lordship challenging the order passed by the learned trial court, whereby my application, two applications, one application for harvesting the paddy cultivated by me was rejected, and the application for injunction upon contested hearing was rejected, was dismissed. Though there was earlier, there was injunction and there was police help also. My prayer for police help was also allowed by the learned trial court, my lord. My humble submission that if your lordship kindly comes to order number 20 dated 11th November 2025, which is the order impugned, is a very cryptic order. So far, the rights and rights of the parties are has been discussed here. But the learned trial court has been pleased to discuss the case laws and several case laws and the law, the sections and all these things, but has not in a solitary paragraph, has only discussed and found no point in my favor and was rejected.
Suit is for what?
Suit is for partition, my lord. Partition mainly of the agricultural lands, my lord. And it is not disputed that the properties are joined, but they have said that it was earlier during the lifetime of my mother, of our mother, the property was partitioned, was amicably partitioned. There was no legal partition as per law, as per section 14, but there was amicable partition and parties are enjoying different plots. So there was no partition. And as because I am serving in a disciplined force, in a CRPF, I cannot take any steps, bold steps, that will prejudice my service also, my lord. And police complaint has been made against me, and by the God grace, my lord, it was found to be a false allegation against me. Now, if your lordship kindly sees, the entire burden has been given upon me. I could not prove that they are threatening to alienate the property. They have been prohibiting me from harvesting my property. Only that, on their score, my application has been rejected. If your lordship kindly comes to solemn order dated 20th, order number 20, 11th November 2025. My second, heard the narratives for the respective parties considered. By filing the instant petition, the petition have contended that the paddy harvested, it should be cultivated, my lord, by the plaintiffs on the suit property has ripened. The defendant number 1 is trying to cut the paddy. So the plaintiffs have filed the instant petition praying for permission to cut the already harvested, or not, it is not already harvested paddy, my lord. Because the application I can show before your lordship that plain case of me that I have cultivated the paddy and now it has ripened and I want to harvest it with the police help.
Probably harvested was confused with cultivated.
My lord.
It appears from the sentence, next sentence.
Yes, my lord.
Next paragraph.
Next paragraph. The defendant has filed written objection in
You have read that. Yes. The plaintiffs have contended that paddy harvested by plaintiffs have ripened. Must
Has
be
ripened.
cultivated, yes. So very well. But court says that
that they have specifically mentioned
a single scrap of paper filed by you to show that they are trying to cut, and you
My
have
lord.
specifically mentioned which plots you are cultivating.
My lord, if your lordship kindly comes, their admission is this,
yes,
in their objection, that they are that parties are enjoying separate properties, and I will show to your lordship something.
Very well.
Moreover, the plaintiffs have not specifically mentioned the respect of cultivation and respect of the
One is not amenable to appeal.
appeal, my lord. The next portion, next part is
relevant,
next
yes.
part.
Yes.
In view of the aforesaid decision, court is not inclined to allow the prayer of the plaintiffs. Thus, the petition dated such and such, the plaintiffs under section 151 of the CPC, be the same is rejected.
So you ask for injunction from disturbing your possession and transferring the property.
Transferring the property. And now, my lord, now the record is taken up for hearing in the injunction petition. All learned advocates for the respective
Up to page 5 you can ignore.
But up to page
Up to
5,
page 6 first paragraph even, because those are all judgments and
all judgments, all everything.
only the
Only
second paragraph in
my lord,
page 8.
if my lord kindly, my lord, at this stage, my lord, page 5, last paragraph.
Yes.
At the stage of deciding the application of temporary instance, court is not required to go into
No,
the
that
merits
is
of
also the three tests have
in
been.
that test statement.
Come to the next paragraph.
Next paragraph. In the instance where admittedly the plaintiffs and the defendants are co-sharers in respect of the suit property, so at this stage the preservation of the suit property is of prime importance. But from none of the documents submitted on behalf of the plaintiffs, including the police report, it appears that the defendant number 1 is trying to transfer, my lords has repeatedly observed that the apprehension in a partition suit.
No, court says from none of the documents it
Documents,
appears
how
that
if they are brokers, if they are bringing brokers to the field, how can I place a document to that effect?
Yes, you have seen the order. Let us hear the other. No, there is no scope of. You have to admit. We can dispose of the appeal itself. What sort of order is this?
Only one point is there, my lord.
We are enlightened on the law and the judgments, but
Suppress, my lord, this
how can a police report indicate that you are trying to transfer?
Nothing is there, my lord. We have no intention to transfer. Even if my lord, for the sake of argument.
No, it's a partition suit. You have to be restrained from transferring the property.
I have no objection, my lord. Let there be.
You have no objection, then you are granting that.
Yes, my lord. But I am not going to transfer the same under no circumstances.
What about the cultivation?
Yes, that is the main point.
You have no objection.
Yes.
No, we'll just hear them and come back to it.
I bow down to your
We are trying to cut short them.
I bow down to
In
your
your written objection, if you have stated that you are in occupation of different portions, so for the admitted portion which they are cultivating, there should have been injunction.
I bow down to your
We have never said that we have done the position of this of that plots which is mentioned in this application.
But your defense, they say, your friend says that there was an amicable partition. You were
amicable partition, but these portions given to us. We have stated
the entire property is given to you.
No, some portions, some portions.
Which portion? Let us see.
And
the rest of the portion we can grant injunction.
That is
Let us see your written objection. Please come there. Page 54.
My lord, page 54.
Yes.
My lord, kindly paragraph 25.
Page 54.
Page 65, my lord.
And written objection, my lord.
65 is a copy of the same.
Pardon, my lord.
No.
My lord, page 65, paragraph 25.
No, it's a different document.
My lord, objection, my lord.
His
objection. One's objection.
Page 50 is my written statement.
Page 54 is a written, yes. Page 54.
You are relying on 65, page 65.
WS.
Which paragraph?
Page 65, my lord, paragraph 25 is a written statement.
Page 65, paragraph
written statement, my lord. I will come to the objection also, my lord.
Please take a seat. We'll just hear him, complete him, and then come. So we are clear on the transfer part. Regarding the transfer part, we have no objection. But take a seat. We'll just hear the cultivation. Yes.
এই বিবাদী আরো নিবেদন করেন যে বাদী হুজুর আদালতে সত্য গোপন করিয়া নারীশীল আগ্রহী ইতিপূর্বে তাহার মাতা কনকমাল তাহার জীবদশায় আজি তফসিল বন্ধিত সম্পত্তি সম্বন্ধে আইন দ্বারা পৃথকীকরণ ও চিহ্নিত নির্দিষ্ট করিয়া লয়েন তাহাদের পূর্বতন আপোষে চিহ্নিত আইন দ্বারা পৃথকীকরণ বিভাগ বন্টন মোতাবেক প্রাপ্ত হওয়া সত্ত্বেও এই বিবাদীর উক্ত আপোষ বিভাগ বন্টনে প্রাপ্ত সম্পত্তি হইতে উচ্ছেদ ও চাষাবাদে বিঘ্ন ও বাধা সৃষ্টি করিবার কুমলদেব মকদ্দমাটি আনয়ন করিয়েছেন মানে দি প্রপার্টিজ আর 16 others properties. The entire property has been not been partitioned in accordance with as per section 14 of the Land Reforms Act. There is neither a
there is no admission as to which portion they are in occupation.
They are in occupation. They are not saying, but they are
admission. There is no admission on their
yes,
part.
My lord. Yes, my lord.
To which portion?
I bowed down to your lordship.
And also from your application, there is no specific enumeration as to which portion you are occupying.
So, my lord, if
it was correct on that,
no,
how
my
can
lord,
a vague injunction be passed? How
no, my lord, if they say that we are amicably, it has been partitioned. I am possessing.
They say amicably it's partitioned, but they do not specify as to which portion is in their possession and which portion yours.
My lord,
either does your application say that if an injunction is passed today, then you may tomorrow go and disturb their possession in respect
no,
of
my
their
lord.
cultivated land. So you have not specified which portion you are cultivating. You have not asked for a local inspection. Nothing.
My lord, kindly see that page 68 to the injunction application. Amicable separation. Only amicable separation.
Amicable separation is very fine to listen to.
My
But
lord,
we don't know which
my lord,
portion is in
if
your
your lordship kindly, my lord, if your lordship kindly comes to,
please show us something to indicate as to which portion you are cultivating. Any local inspection held? No, you did not pray. You have not indicated as to which exact portion you are cultivating. There cannot be a vague injunction regarding the entire property. Then you will cultivate the entire property and say that they are disturbing.
my lord, if you my lord, kindly come to page 42 once, my lord. Page 42. The initial order, my lord.
No, order, we are not interested in the orders. Ad interim order merges with the final order.
My lord.
Order does not bind anybody.
There was detailed
please
discussion.
show from your, we are not into that order. We want to see independently from your application or any document furnished by you as to which portion exactly you are cultivating. Show us that, get an injunction. Otherwise, no injunction. Court was correct in saying that you did not specify as to which portion you are cultivating.
For that matter, the Learned Court below was initially pleased to pass order of status quo.
Status quo order is what we deprecate every day.
My lord.
Status quo order without saying what is the status. Sorry. That will create more confusion than it resolves. If you pass an injunction today that they cannot disturb you from cultivating your portion without specifying what is your portion, that will create more problems than it will solve. Tomorrow you will say that they, whatever portion they are cultivating, will go there and say this is my portion and they're disturbing. How do we know? Your name is not written on the crops, nor is their name. So court quite correctly refused the cultivation part of the injunction.
But what I only play before your lordship,
transfer, yes, you are granting.
As because they are already saying that the amicably partition, which they might let them file an objection.
How can you rely on their objection? See, you can rely on their objection if there is an unequivocal, please, unequivocal, unambiguous admission. There is no admission. Why should we compel them to show, state as to which portion is your injunction, your plaint? You have to prove your burden. You show which portion you are in occupation of, get an injunction. They are not asking for injunction.
May I file one supplementary evidence, my lord?
Here filing, what will do? How will it help you?
Before the Learned Trial Court, my lord.
No, the injunction application has been disposed of. What is the question of your filing any supplementary evidence? No question.
But kindly protect my right, my lord, because there is 1/6 there, mine.
You don't have right to any particular portion of the property. It's settled that every questioner has right over every inch of the property. So therefore, both of you have rights. If you could have proved that you are cultivating a particular portion, we would have protected your right as the learned trial judge. We are sure he would have, she would have. But in this particular case, you have not produced anything to show. Learned trial judge is quite correct in saying that how can I pass an injunction? The plaintiff does not prove as to which portion he is cultivating. Transfer will immediately grant as rightly submitted by learned friend. Learned friend actually anticipated what we would say. So, transfer definitely, you are right. But this status quo as to possession without determining
the extent of 1/6 share, my lord, that is admitted, my lord. That
which portion? No,
my lord.
See, 1/6, fine. 1/6 over every inch of the property.
My lord.
They have 1/6 right over every inch of the property, as do you. But when you seek a specific injunction that pertains to physical possession and physical cultivation, it's a tangible thing. Physical cultivation over a particular portion of land. Are you clear to you?
My lord.
We cannot say you are cultivating 1/6 of your property.
But if, my lord, what was found from your lordship?
There on record to show which portion. Sorry.
What was found from your lordship, my lord? 1/6 share in the entire property. The 16 share has been.
How can you grant an injunction? Which 1/6? Which portion you are?
To that extent,
it is not done vaguely. It's not a platonic concept that you are cultivating 1/6 of the property. Cultivation is done in respect of a particular portion of a plot. Physically, it's a physical thing. It's not a vague legal concept. I'm cultivating over 1/6 share. What does it mean? It means nothing. Sorry. You can cultivate only in a particular specific demarcated portion of a land. If we were cultivating, then we could have understood, we might have granted injunction, because yes, although everybody has right over every portion, if you have cultivated, you are entitled to, you reap what you sow. The proverb. So you literally have the right to reap what you sow. But you have not proved anything to show that you are cultivating a particular portion of the land. So how can we grant an injunction to you regarding that? Today we'll grant an injunction, you'll go and disturb their cultivation. Who knows? We don't know. Court was justified, sorry. We are just modifying the order. We are granting injunction regarding both parties will be restrained from creating any third party interest.
And my lord, one thing, my lord, may I pray, my lord?
Yes.
The food may be disposed as early as possible within 1 year, my lord.
We can't dispose of a revisional application within 1 year and we'll direct the.
My lord, as efficiently as possible, my lord. Because I am in a discipline service, I cannot take any harsh step, any step whatsoever.
No, but
They
there
will-
are allegations of indiscipline against you as far as they are concerned.
My lord, they have complained against me before my
What is
authority.
the year of the suit? 2023.
2023, my
The
lord.
stage of the injunction has just been disposed. How can you direct the court?
As early as possible, my lord. And my lord, some protection, my lord, some protection.
Serious protection. They will
Some
not be able
protection.
to transfer, nor will you.
My lord, I will not. But
And
any
none of
protection
you.
regarding cultivation, my lord, any protection, my lord. As it
We are
may fall
taking up
from
the
the
appeal,
lordship.
disposing of the appeal along with the application on consent of the parties. We are taking up that portion only consent. The appeal along with the in view of arguable questions being involved, comma, we admit the appeal, full stop. Since the issues involved are brief, comma, on the consent of parties, comma, the appeal is taken up for disposal along with the application. Full stop. The present appeal arises out of a suit for partition filed by the appellants. Full stop. In the said suit, comma, an application for temporary and ad interim injunction was filed seeking to restrain the defendants stroke respondents from disturbing the harvesting of crops allegedly sown SOWN by the plaintiffs in a portion of the suit property and for restraining the respondents from transferring or creating third party interest in respect of the subject property. The next para, although an initial order of status quo was passed at the ad interim stage, comma, subsequently, comma, by the impugned order, comma, the said status quo was vacated and the injunction application was dismissed. Full stop. Learned counsel for the appellants argues that the learned trial judge proceeded on the premise that none of the documents submitted on behalf of the plaintiffs, including the police report, indicated that the defendant number 1 is trying to transfer the suit property or to create any third party interest. Full stop. It is submitted that it is not possible, not always possible, comma, by documented evidence, comma, to show such attempts. Full stop. It is submitted that if a transfer is already effected, comma, there would be no efficacy to a prayer for injunction. Full stop. Reasonable apprehension, comma.
I beg to pardon, my lord. In the injunction application, I have given the portion for which I am paying for partition, my lord. Page 36, my lord. If you also kindly cease. Page 36, my lord.
Is granted, comma, it is submitted, comma, on the basis of apprehension and not on the basis of actual transfer.
Page 36, my lord. Kindly cease, my lord. Out of the entire plot, my lord, this portion I am cultivating. Page 36, my lord. I beg to be pardoned, my lord.
Did you ask for a local inspection?
Well, I have given the DAG number.
No, my lord.
I have
No, you have not.
DAG number?
No, your prayer is 1 নম্বর বিবাদী যাহাতে নালিশি নিম্নের তপশিল বর্ণিত সম্পত্তি and give the entire তপশিল.
No, my lord. Subject to correction, my lord.
This is not the entire suit property. You include the entire suit property here.
No, my lord. Subject to correction, my lord. My lord, I am checking it.
Correct us. We are subject to that.
I'm taking it up, my lord.
We are waiting to be subjected to your correction.
My lord. My lord, the schedule is, the suit schedule is page 28. Page 28.
We'll have to compare the entire suit schedule. Yes.
No, my lord. It is very
what? Very
lesser amount, my lord. In the injunction application. 1/6, my lord. Page 36. Page 36, my lord. This is the injunction application. Very lesser amount, my lord.
This is the entire property.
My lord, page 28 is the entire property, my lord.
Where have you stated that you are cultivating these portions only? Let us see that paragraph.
1 নম্বর বিভাগ নারী সম্পত্তিতে যৌথ দখলের সৃষ্টি করে দিয়েছেন এবং নিম্নের তফসিল বর্ণিত সম্পত্তি চূড়ান্ত চিহ্নিত বিভাগ বন্টন না করিয়া তৃতীয় ব্যক্তি বিক্রয় করবার জন্য প্রচেষ্টা করে
Your
দিয়েছেন।
allegation is 1 নম্বর বিবাদী নালিশি নিম্নের তপশিল বর্ণিত সম্পত্তিতে. You write this in the injunction. যৌথ দখলে বাধার সৃষ্টি করিতেছেন. যৌথ দখলে বাধার সৃষ্টি করিতেছেন. So you admit যৌথ দখল.
যৌথ
joint possession.
Possession, my lord. Because it has not been partitioned in accordance with law.
এবং নালিশি নিম্নের তপশিল বর্ণিত সম্পত্তি চূড়ান্ত চিহ্নিত সুরত বিভাগ বন্টন
বন্টন
না
না
করিয়া
করিয়া তৃতীয় ব্যক্তিকে
তৃতীয়
বিক্রয়
ব্যক্তিকে
করিবার
বিক্রয়
প্রচেষ্টা
করিয়াছে।
করিতেছেন।
What is the allegation that you are cultivating on this particular
কোন
portion?
তৃতীয় ব্যক্তিকে বিক্রয় করিতে না পারেন, মানুষ সৃষ্টি না করিতে পারেন, তন্ময় বিয়াদি গ্রহণ করে
Thank you for pointing out. We'll rely on this application and
My lord, and নিষেধাজ্ঞার আদেশ প্রচার আবশ্যক এবং বাদীগণের প্রাইমা ফেসি কেস আছে, and my lord, this is the very lesser amount, my lord, the amount,
very well, you are
quantum I am
continue with our order. Learned counsel further submits that the schedule to the injunction application, in respect of which the prayer for temporary injunction was made, is lesser than the total suit property. First up, by placing reliance on the averments made in the injunction application, learned counsel for the appellant submits that the learned trial judge ought to have construed the schedule of the injunction application to indicate the exact portion in respect of which the plaintiff/appellants are cultivating, and to have granted injunction in respect of the said portion of the property. Full stop. Next para. Learned counsel for the defendant/respondent submits that in principle, the learned counsel appearing for the defendant/respondent number
1 and 2.
1 and 2 submits that the said defendants do not have any intention to transfer the property in favor of third parties. Full stop. However, learned counsel seriously opposes the allegation that the plaintiffs/appellants are cultivating a particular portion of the property. Full stop. Rather, as mentioned in the written objection filed by the respondents to the injunction application, it is argued that it is the appellants who are trying to disturb the cultivation of a portion of the property by the defendants. Full stop. It is also alleged that the plaintiff number 1 belongs to the armed forces, and as such, he used his influence to disturb not only the defendant number 1 but his mother as well. Full stop. Next para. Upon a perusal of the materials before us, we find substance in the contention of the appellants to the effect that during pendency of a partition suit, the endeavor of the court is to preserve the suit property till disposal of the suit. Full stop. Next para. Accordingly, the learned trial judge ought to have granted injunction restraining both parties to maintain status, restraining both parties from creating any third party interest or transferring the suit property during pendency of the suit. Full stop. However, we do not find any error, either of law or of fact, in the learned trial judge refusing to grant injunction in respect of alleged cultivation of a portion of the property by the plaintiffs, for the simple reason that there is nothing on record to show as to what exact portion of the property is being so cultivated by the plaintiffs. So next para. Although learned counsel for the plaintiffs/appellants vehemently relies on the injunction application and its pleadings, we find from the said application that the plaintiffs/appellants have categorically admitted that the defendant number 1 is disturbing the joint possession in respect of the suit property. Full stop. Thus, even the plaintiffs appellants, in their injunction application, admit joint possession of both the parties with regard to the suit property. Full stop. Next para. Although the schedule of the injunction application comprises of a truncated version, TRUNCA, truncated version of the entire suit property, we do not find any corresponding averment in the application as to the plaintiffs/appellants cultivating the particular plots mentioned in the schedule of the injunction application, nor do we find any effort being made on the part of the plaintiffs/appellants to prove by other corroborative material, including any local inspection/investigation as to what part of the suit property
exactly is being cultivated exclusively by the plaintiff stroke appellants. For sub next para, in the absence of such material or pleading, comma, it would be absurd for the court to grant an injunction. Full stop. The repeated arguments of the appellants regarding the appellant's share to 1/6 of the suit property does not automatically translate to the entitlement to grant injunction in respect of physical possession of the appellants and or cultivation in respect of a particular portion of the entire joint property. Full stop. Next para, in the absence of proof as indicated above, comma, there was no scope for the learned trial judge to grant injunction by coming to the specific conclusion that the plaintiff stroke appellants are cultivating a particular earmarked portion of the suit property. Full stop. Thus, comma, we do not find any illegality in that regard in the impugned judgment. Full stop. Next para, in such view of the matter, comma, FMA 26 of 2026 is partially allowed, comma, thereby modifying the impugned order bearing order number 20 dated November 11, 2025, passed by the learned civil judge, bracket senior division, second additional court at Bardwan. This is district Purva Bardhaman, district Purva Bardhaman, in title suit number 300 of 2023, to the extent that both parties shall remain restrained by an order of status quo, restrained by an order of injunction from selling, transferring, alienating, encumbering, and or creating any third-party interest in respect of the suit property till disposal of the suit. Full stop. Next para. However, comma, the rest of the impugned order is not interfered with. Full stop. Can 1 of 2025 is consequentially disposed of without full stop. Next para. We make it clear that it will be open to the learned trial judge to dispose of the suit on its own merits upon trial on evidence without being influenced in any manner by any of the observations made herein above or in the impugned order. No orders to cause such. Thank you.
Number 39.
Yes, Mr.
Plaintiff, no, Lord. My Lord, plaintiffs are the appellant before your lordship. This is relating to my Lord final decree passed in a suit for partition. My Lord, the title appeal has been dismissed on the ground that the certified copy of the judgment and decree passed by the trial court was not filed along with the memorandum of appeal, although I have filed it subsequently, and the same has been returned back to me. Challenging that, my Lord, this appeal has been on the last
appeal has been dismissed.
Yes.
No, leave petition has been filed. That's why.
What
without certified copy, my Lord, file a appeal.
Yes.
Thereafter, my Lord, praying time on the next date file a certified copy. But at the time of filing of appeal, no leave petition
was it within limitation?
No, my Lord, not within.
Then you had to file a section 5.
No limitation.
It was within limitation. That is
yes, within limitation.
The certified copy was filed within limitation.
Yes.
What, Mr. Chattopadhyay?
No, my Lord, it is appearing.
I have particular the dates.
Not appearing, my Lord, within limit. It is order passed by this.
I have given the dates.
Achha, let us see.
The court has not said that the suit is barred by
the appeal is not filed within the time limit.
Oh.
Order number 1 dated 19th April 2024. First order number.
My Lord, kindly come to page 7, paragraph 24.
Yes, first order says appeal is not within time limit.
Yes.
My Lord,
And
page
no
7
zero certificate copy of the
That
imputed.
you have seen, the rest you have seen, yes.
My Lord, page 7, paragraph 24.
Supplementary or main?
Main, only application. Application for stay.
There is a supplementary affidavit. Oh, an application for condonation of delay has been filed here.
Yes, that has been allowed.
Paragraph 7, Mr. Mata?
Page 7, paragraph 24.
Sorry.
In the memo.
Stay application. January 16, 2024.
Yes.
My Lord, the suit has been decreed in final form. Next paragraph, my lord, on January 22, I applied for certified copy.
So you lose 6 days there.
Yes.
March 27, Acha. Oh, March 27, it was notified.
March 27, it was notified. April 2, within 5-6 days, I have filed the I put in the requisites. I have got the certified copy. I have filed it.
Yes, 12 দিন চলে গেছে। 8 থেকে 18 দিন যাচ্ছে।
Since my lord, the order was
probably late by a day. So Mahato, because we say this because January 16, 2024 judgment was passed.
Yes.
We applied on January 22nd. You lost 6 days there.
6 days.
Acha. Then we the rest
notification
we start from
27th March.
Yes. March 27 and you deposited on April 2, 2024.
6 days.
6 days. 6 plus 6, 12.
12
18 left. 18 left. When did you get the certificate copy? You say April 2nd, 2024, your petitions put in the requisite stamp.
But
then you don't say when you obtained the certificate copy.
My lord, from the
But even then,
yes.
even then you are right. Even then, even if you got it on the same day, 2nd April, then it's 17. You file on the 17th day, just within time. Yes, Mr. Chattopadhyay. From these dates, it's
Well, my humble submission is, my lord, without leave, if the court dismiss, my lord, it is not a wrong order, but it may be, your lordship.
We are disposing of the appeal itself.
Yes, my lord, only, my lord, these are all, my lord, long pending case, my lord, only dispose of the appeal, my lord.
It is not yet started. It will be a cruelty on the learned trial judge.
My lord, executive
Learned first
proceeding-
appellate court.
Now, my lord, another thing.
Revision application file, my lord, thereafter, my lord. Against this.
Not thereafter. Prior to
Against
filing of
this
this
order.
appeal, revision application was filed.
That chapter is over because you have
erroneous.
condoned the delay, Mr. Chattopadhyay.
And my lord, one thing, my lord, the last occasion, my lord, directed me to file this decree of certified copy, the decree of the trial court with then date. My lord, I have filed on the next day.
Well, the belated filing
Lord,
of
I
the certified copy of the decree of the trial court is condoned and the same is accepted. Yes, Mr. Chattopadhyay, you are saying?
I am, my lord, appearing on paper 1, 2, 3. There is a 4. I don't know, my lord.
Then how can the appeal be disposed of?
Your lordship directed possibly earlier occasion.
I have served everybody.
No, but you have not served. We are disposing of the appeal. How can you do that?
That's in their absolute stand.
না না আমি তো 3 জনের হয়েছে আমি যাই না সেটা কোর্ট
In the trial court, you appeared for all.
Yes, Lord. No, my lord. I 1, 2, 3.
Then we are admitting and what can go?
ট্রায়াল করে অ্যাপিয়ার করেছিল জাজমেন্টটা দেখো না এখানে এই যে মেমোতে জাজমেন্টটা দেখো তাদের
Yeah, Mr. Chattopadhyay, to expedite the matter, you can ask your client whether you can appear on behalf of. We'll just take it on some other.
জাজমেন্টের প্রথমে দেখো না আমি থাকে
Tipradey is connected to you.
He is not, my lord, possibly not contesting. But I have no objection. Lord.
No, your objection, no non-objection won't do. She has to be served. She's not contesting in the trial court.
No. According to him, no. He's
only him only is check up.
No. Oh, his elder sister, Lord, not contesting.
Huh?
His sister, not contesting. Lord.
No, but we have to be satisfied from.
Lower court order is here, my lord.
Let us take up from there.
ট্রায়াল কোর্টের জাজমেন্টে তো ওখানে কিছু পাওয়া যায় না ওটাতে কিছু পাওয়া যায় না যা চাই
Contest করে তো বোঝা যাচ্ছে না। No,
I
not stated expertise.
Lord, this time, Lord, I will file a vocal number. I am able to file a vocal number. Lord, I am appearing.
Do that because once we admit, we lose jurisdiction. Division bench loses jurisdiction.
Yes, Lord, I am undertaking. Lord, I will.
No undertaking. You are undertaking.
Yes, Lord.
How soon can you file?
Lord, his sister, my lord, residing.
His sister does not mean
Within a
when.
week. Within a week.
Can you do that? Ask him specifically.
এক সপ্তাহের মধ্যে দিতে পারবেন না?
Very well.
That's why I am also wanting to discuss.
At this juncture, learned counsel for the respondent numbers 1 and 3. He is which respondent?
4.
He.
Anupam, 1.
1.
2.
Learned counsel appearing at this juncture, learned counsel appearing for the respondent numbers 1 and no, you are also not appearing for
1 to 3.
Learned counsel appearing for the respondent numbers 1 to 3 submits on instruction from respondent number 1, who is personally present in court, that learned counsel shall file Vakalatnama on behalf of the respondent number 4, who is the sister of the respondent number 1 within a week from date. Full stop. On the basis of such undertaking, the matter is taken up. Full stop. Next para. The appeal shall be heard on the following substantial question of law: whether the learned first appellate court substantially erred in law in dismissing the title appeal itself on the ground that the certified copy of the impugned judgment and decree was filed subsequent to the presentation of the memorandum of appeal, instead of construing the date of filing of the said certified copies as the date of filing of the appeal, particularly in view of the fact that the appeal was filed within time. Eta 1 holo. 2 হচ্ছে whether the learned first appellate court acted in a perverse manner in observing that the appeal was not filed within time limit, on a palpable miscalculation of the relevant dates. Next para. Immediately after admission, learned counsel for both parties consent to the appeal itself being disposed of in view of the extremely short point involved. Why do you disturb me every time?
Only that point, my lord, for not filing the leave application, my lord. Dismiss the appeal for
What
not
leave
filing.
application?
Yes,
Where will we consider?
on that ground, my lord,
Next para.
dismiss.
Concedes to the appeal being disposed of along with the appeal being disposed of at the admission stage. Full stop. Next para. From the impugned judgment dated May 10, 2024, as well as the previous order dated April 19, 2024, passed by the learned first appellate court, we find that initially the appeal was, the memorandum of the appeal was taken on record with the observation that it was not filed within time limit. Full stop. However, from the averments made on oath in paragraph numbers 24, 25 and 26 of can 3 of 2026, we find that the appeal was filed about 1 day prior to the expiry of the limitation period of 30 days. Full stop. The relevant dates in the context are as follows: colon দিয়ে নিচে বাঁ দিকে একটা হেডিং হবে ডেট আর ডান দিকে হচ্ছে ইভেন্ট। ডেটের আন্ডারে প্রথম ডেট হচ্ছে জানুয়ারি 16, 2024, ডান দিকে ট্রায়াল কোর্টস ডিক্রি পাস্ট। নেক্সট বাঁ দিকে জানুয়ারি 22, 2024, ডান দিকে appellants applied for certified copy of judgment and decree of the trial court. Next date, March 27, 2024, right hand side, requisite number of stamps and folios were notified. Left hand side, date, next row, April 2, 2024, right hand side, the appellants put in the requisite stamps and folios. Full stop. Tarpor next date, April 19, 2024, right hand column, appellants filed title appeal number 30 of 2024. So next para. From the aforesaid turn of events, it is evident that even construing that the certified copies were handed over to the appellants on the date when they put in the requisite stamps and folios, that is April 2, 2024, and deducting the time lost in between for the fault of the appellant, in applying for the certified copies and in depositing the requisites, we find that from the date of deposit of the requisites, that is April 2, 2024, 18 days were left in the limitation period for preferring the appeal, which was due to end on April 20, 2024. Full stop. The appeal was filed on April 19, 2024, that is within the limitation period. Full stop. Thus, the observation of the learned first appellate court to the effect that the appeal was not filed within time limit is erroneous. Full stop. Next para. Since the judgment and decree, certified copies of the judgment and decree were filed later, we deem the same to be a technical defect, as the memorandum had already been filed and was taken on record. Full stop. Although strictly speaking, the date of filing of the appeal ought to have been considered to be the date of filing of the judgment in view of the requirement under Order 41 of the Code of Civil Procedure to file certified copy of the impugned judgment along with the appeal, in view of the registration of the appeal on April 19, 2024 by the first appellate court itself, the filing of the date of filing of the judgment and decree should be construed to relate back to the date of filing of the memorandum, and as such, the appeal was to be construed to have been filed within time. Full stop. Next para. Moreover, the appeal ought not to have been dismissed merely because no specific leave was granted to the appellant to prefer the appeal without the copy of the judgment. Full stop. The appropriate course of action to be taken by the learned first appellate court was to construe the judgment, certified copies of the judgment and decree to be a part of the memorandum of appeal, once filed, thereby rectifying the defect in the appeal. Full stop. Next para. The hyper-technical approach taken by the learned first appellate court cannot be approved of. Full stop. In such view of the matter, SAT 38 of 2026 is allowed on contest, thereby setting aside the impugned judgment
10th May.
And decree we have to say, because there no decree was dated May 10, 2024, passed by the learned district judge Paschim Medinipur in title appeal number 30 of 2024, and remanding the appeal to the learned district judge for adjudication on merits. Full stop. In view of the long time spent in the litigation, it is expected that the learned first appellate court, be it the learned district judge himself or to any other competent court allocated by him, as expeditiously as possible, preferably within 1 year from the date of communication of this order to the learned first appellate court. Which can is pending? Only can 3. Can 3 of 2026 is disposed of accordingly. No as to cost. Urgent certificate copy hobe na.
My lord, may I pray one thing, my lord, to expedite the appeal?
We said 1 year.
My lord, to expedite the appeal, I am also praying, my lord, to expedite. My difficulty is, my lord, I have filed the certified copy of judgment and decree of the trial court before your lordship's court. But if I again apply, it will take time. If your lordship kindly permit me to take back the certified copy by replacing the Xerox copy, then, my lord, I can file it by 1 day. Otherwise, well, again, it will take time.
Leave is granted to the learned, for the ends of justice, leave is granted to the learned advocate on record for the appellants to take back the certified copies of the judgment and decree of the trial court for the purpose of presentation, along with the presentation before the first appellate court, upon furnishing photocopies thereof for the records.
I'm good. No,
yes.
I am for the appellant, my lord.
Yes, please. What is the matter?
What declaration and consequence of relief of permanent injunction was filed?
Impossible. Come back on Monday.
Grateful, my lord.
You have sufficiently convinced us. In view of the what should you say? Hoarse voice of the advocate. In view of the now, since learned counsel for the appellant is inconvenienced due to hoarseness of his voice, let the matter stand adjourned till August 3, 2026. Come back on Monday.
Yes.
Give your name. Yes.
I am appearing on behalf of
Yes.
For the respondent.
At this stage, you don't have a right of hearing. Let us hear your Honor. Yes.
decision case. But prior to that, my lord, before going into the merit, there is a report of the stamp reporter. The first one is I have rectified.
20 rupees.
Yes, I have rectified.
Name
The
of
second was I have nothing to do because the 4 to 7 they are coming after expiry of the mother. They added.
Mother expired after
Mother
the passing of the first appellate
Mother
court's
of
degree.
the mother means they
Whoever died, she died after the passing of the first appellate court's judgment.
no.
Then
23/9/2020, after the passing of the judgment of the suit, they have expired. But she has expired.
They were not impleaded as parties in the appeal.
No. She after expiry of the dependent number 1, opposite party number 2, Srimati Mamata Mondal, she had expired first on 23/9/2020.
When did she expire on the second time? She expired first on that date.
No, after during pendency of the appeal. During pendency of the appeal, she expired.
Are were not substituted?
Yes, substituted. That's why 4 to 7 has come.
They were not substituted in the title appeal.
Title appeal, they have substituted. That's why 4 to 7 has come.
Achha. So the report is that their names are not appearing in the title.
Yes. That is there. The order sheet has not been disclosed in the degree.
In
the order sheet.
We'll just check up in the appeal court's decree. Their names are appearing 4 to 7.
Yes.
All right.
Thereafter, the opposite party number 1 has been expired. Vishnupada Mondal has been expired.
Yes.
After expiry, his name has been expunged because the legal years already included in the after expiry of the mother. All the legal years has been included after expiry of the mother.
Yes.
So father's name has been expunged.
Just expunged because they are already on record.
Yes.
Who is respondent number 3?
Who
is respondent number 3? Satyeshwar Mondal. There is another report that the name of respondent number 3 in the certified copy of decree does not tally with certified copy in trial court. Oh, see, that is
yes. After
no respondent number 3 in the title appeal, his name was not there in the trial court. Name does not tally, it is saying. সেটা তো ডিগ্রিটা কারেকশনের জন্য চলে যায়। এটা
son of the Vishnupada Mondal.
আচ্ছা।
It's not 3, 2, 1. All of the
4 to 7 are the son and daughters of Vishnupada Mondal.
Oh, the spelling is different in the trial court. What is his name?
Spelling is different in Ananta Maiti. Only
we are now speaking about Ananta Maiti. Ananta Maiti's name, only an extra M has been. So that goes down to the trial court, appeal court for correction. We'll send it down. And regarding this, very well. So we'll record that and then take up the matter for hearing immediately. Insofar as the name of the respondent numbers 4 to 7, not 4 to 7 in the certified copy of the appellate degree, not finding place in the certified copy of the trial court's degree, learned counsel for the appellants submits that such respondents were impleaded as were substituted as heirs and legal representatives of their mother, who had died during pendency of the appeal. As such, their names do not find place in the certified copy of the trial court's degree, although during pendency of the appeal they were impleaded they were substituted in the appeal, and as such find place in the appellate court's degree. Next para, insofar as the name of respondent number 3 in the certified copy of the appellate decree not tallying with that of the trial court's decree, comma, the matter is to be resolved by sending the records down for correction. Full stop. Next
But
para.
if the record has been down to the correction,
After hearing you-
enough time will be taken up.
After hearing, we will send that. Accordingly, the records be sent down. Full stop. However, comma, due to the urgency involved, comma, prior to sending down the records, we take up the appeal for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Move it. You are hearing it. Admission here.
That
you lost in
first
both
point
courts.
is my first.
No, you lost in both courts or one in?
Yes, but I have served upon.
You lost in both the courts or?
Yes. I have annexed. I have annexed in both the courts. I have lost in both the courts.
You filed the suit?
Yes. I have.
You are the
not filed
defendant.
suit.
You are
File has been suit has been filed by
naturally, yes.
By the Vishwada Mandal.
Well, what was the suit for?
The suit for declaration of permanent injunction and recovery of possession.
On the ground that you are a trespasser?
No, I have not trespasser.
What was their ground that you were a trespasser?
Yes, they have said so. I am the trespasser. But what I am saying, there are property. One property has been divided two sons. One Madhav Maiti, another one is Ananta Maiti. Madhav Maiti property, there is no dispute because Madhav Maiti property has been sold to Vishwada Mandal. There is no dispute. There is no dispute. But regarding Ananta Maiti, share of Ananta Maiti, I was the tenant of Ananta Maiti. That has been subsequently, Milord, by a lower valuation, some thing has been done. That has been, they have said, the Ananta Maiti has said that it's a mortgage property and that fight between the original plaintiff and the Ananta Maiti was going on. That said suit has been finalized in the year 2001 by this Honorable High Court. Suit lost, then appeal, lost, then...
Who lost? Ananta or Madhav?
Yes.
Who lost? Ananta or Madhav?
Ananta was... Madhav, there is no dispute.
Suit was between Ananta and whom?
Suit between Vishwada Mandal and the Ananta Maiti.
Very good.
I was the tenant of Ananta Maiti. That's why the suit was between Ananta Maiti and the Vishwada Mandal, who claiming
that suit was for what? Declaration of I mean, what was the release?
No, money lending. That's a below money.
Money claim.
Money claim.
Vishnupada claimed money from Ananta.
Ananta. Ananta has been took loan from Vishnupada Mandal.
So Ananta suffered a decree before this court, preferred an appeal.
Yes.
Went up to the Supreme Court.
No, not Supreme Court. So after passing the order from the Honorable High Court by the Honorable Justice Naran Chandra Sil, as his lordship then was, my lord, the matter was disposed of and Ananta Maiti was lost.
So Ananta was
that's why.
Pay that
That's why.
Yes.
That's why Vishwada Mandal come to the owner.
Property was attached.
Attached property.
Property was attached.
No, not attached.
Money decree, how was it executed?
Money, no. They have
Vishnupada got a money decree against Ananta.
Not money degree.
Loan.
They have been, they claimed, the Ananta Maiti claimed that below money, by a below consideration of money, the property has been
transferred.
Out and out sale. They have said that out and out sale.
Transaction versus out and out sale.
Yes. Transaction was the out and out sale.
So it was ultimately held to be an out and out sale.
That is ultimately finalized, that is out and out sale.
What was out and out? So Ananta had then, it was held that Ananta had sold this property, his share also to Vishnupada.
Yes, to Vishnupada Mandal.
So the portion which you are tenanted in, that portion was ultimately held by the court to have been sold by Ananta to Vishnu.
Yes.
But you say that sale is subject to your tenancy. You remain a tenant.
I was a tenant,
So
but
have you-
my first condition is
Yes.
that ownership of Vishnupada Mandal came to the picture in the year 2001.
You were already a tenant. He buys subject to your tenancy. We agree with you. Did you produce any rent receipt?
Yes, I have deposited the rent to the court.
Did you produce any rent receipt given by
Yes,
Ananta to you?
I was a rent receipt of Ananta Maiti.
Did you produce before the trial court in this litigation any rent receipt issued by Ananta to you?
Before the trial court?
Any of the courts in this present matter?
Before the High Court, we have shown.
In this suit, have you produced any rent receipt before
In
either
this suit?
Yes.
No, not in this suit.
If you have not produced any rent receipt, why shouldn't the court hold you to be a trespasser? What is the proof of your tenancy?
But tenancy, I have deposited the rent till today.
That's your own deposit. Unilaterally, you are depositing. I can deposit a rent in respect of the Calcutta High Court in the name of Calcutta High Court. That will not be constituted to be a tenancy of me under the Calcutta High Court.
No, the rent I have deposited. On
Your
the,
unilateral deposit does not prove a tenancy, sir. Sorry. Let us see what has been found.
tenant.
What is your substantial question of law?
No, question is, my lord.
Don't even find a substantial question of fact in
My question of law, my lord, there are two ways. The ownership has been given to the Vishnupada Mandal in the year 2001. How he claimed that 1991. They have filed a suit in the year 1991 and saying me that I am the trespasser.
This suit was filed in 1991.
1991. Original suit was filed in the year 1991. See title suit number 309 of 1991. Subsequently, that has been converted as 45 of 1991.
So at the time when the suit was filed, he was not even an owner.
No, Vishnupada Mandal was not the owner.
Who had filed the suit? Vishnupada has filed the suit.
Vishnupada Mandal filed the suit.
What is the second question?
Second question is, my lord, that first of all, my lord, he was not the owner. Secondly, my lord, before the appellate court, there are both parties made an agreement, not written, but verbal agreement was there, and that has been submitted before the court. That only I have captured only 175 square feet, pursuant to the report of this inspection held by the my lord, surveyor come.
So inspection report shows that you are in occupation of a part of the suit property.
Yeah, part of this portion, part of this total area is not 1,000.
The suit property is how much?
Yes, my lord.
What is the suit property? What is the extent of the suit property?
So 175 only.
So how is that a question of law?
Yes, question of law is 175 only. I am occupying 175. I am
You said this is the second question you are arguing. First question we understand. Vishnupada was not the owner when the suit was filed. Second question, what is the second question? You are in occupation of 175. Yes.
175.
So
Out of 1,000, 175 is occupying by me. I was the tenant of Ananta Maiti.
Yes,
and
yes.
the remaining land was there. Ananta Maiti.
What is the question? I mean, what is the law point?
Law point is not 170. That is the transfer property. That has been not the inherited property. That is the transfer property.
Yes, so what?
On transfer property cannot be when the rebuilding or they are going to build or rebuild. Then transfer property, if the transfer property is there, my lord, then under section 6, my lord, they can't. Told me as a trespasser.
Transfer property, there is a bar of instituting a suit under section 6 of the Premises Code Act 97 within a particular period. There's a moratorium period under the statute that applies to a tenant, not to a trespasser.
Under section 6(2). May I permit you read it, my lord?
Yes.
Where a landlord has acquired his interest in the premises by transfer.
There's a moratorium period for that, 3 years.
No suit for recovery of possession
Sorry, 1 year.
of the premises on the ground or of requirement for building or rebuilding or addition or alteration or requirement for own occupation shall be instituted by the landlord.
Before the expiration of 1 year. Read the entire thing.
So that is limitation.
Moratorium period, 1 year after the purchase, he cannot institute a suit.
No.
After 1 year, he
They
can
have
institute.
filed a suit earlier, 1991.
What is the finding of the court regarding your tenancy? Let us see.
Yes, I was the tenant.
How do you know that? They did not file the suit. They filed the suit under this act. You said as a trespasser?
West Bengal Premises Tenancy Act.
1956 Act. The suit was filed under which act? 1956 Act.
1956, possibly 1956 Act. Because I have.
We asked you at the
deposited
reception,
the rent.
you said that it is filed as a, on the premise that you were a trespasser? No, no. Suit was filed under 13(6) of Premises Tenancy Act. Previous Premises Tenancy Act. Those proceedings were saved. It is to be governed by the said act. So did you raise this point that they filed at a point of time when it was not transferred to them?
Yes, I have raised the.
How is it dealt? How is it dealt
in the trial court?
How is it dealt with by the courts? Let us see. Where has the court dealt with that?
No, they haven't. The London Appellate Court as well as this suit court. Avoid London Appellate Court. Avoid not make any consideration regarding the agreement between us. That verbal agreement that 175 they may rebuild, but 175 square feet for my business purpose, they will give me 175. That is only 175 square feet. Out of 1,000 square feet, only 175 square feet I have occupied for my business purpose. Only 175. I have nothing to say. What I am saying, my lord, 175, let them rebuild for their own occupation. I have no objection. But according to the report of the my lord surveyor, that there is a big hole over the roof. That's why my business, pesticide and the fertilizer business has been lost, are going to be lost. Because now the rainy season has come. Rainy season is still continuing. So my business will be.
Building the building was.
They are claiming building and rebuilding.
They are claiming building the building. For that, they will record the entire tenanted property.
Entire property with Anandamaiti property.
Then you cannot consider a question of partial eviction.
I am saying 175 each. I am occupying only 175.
That 175 comes within the larger portion which they want for building rebuilding.
Yes, sir.
That 175 comes within the entire suit property. I mean entire property.
Yes.
So therefore, if they want to rebuild, they have to take your property also.
They have to take my property also.
Yes.
My humble submission is 175 square feet remaining for my business purpose.
How can
let them rebuild? Let them rebuild.
Without that, how can they rebuild? They need the entire thing for rebuilding.
No, there is a pillar. There is a system of pillar. By cutting the wall, there is a system of pillar.
Can we go into that in a suit of this nature? Let us see. What order for Rule 27 you filed? What did you want to bring?
I have 1 minute.
Local inspection.
I may not be.
No, you filed an order for Rule 27 for local inspection.
I may not be disposed of from that portion, from the from my business portion.
Before the appellate court, you filed an order for 227 application for bringing production of additional evidence.
Yes, yes, yes. I have
Page 9. We are on page 9 of the appellate court judgment.
No, my lord. I am submitting some more additional grounds. You will also kindly leave me granted, my lord, to file additional grounds.
We'll formulate grounds if you feel there is a question. Keep it with you. No difficulty. But first satisfy us. We are asking you, we find from page 9 of the appeal court trial, first appellate court judgment, that you had filed an order for 227 application for production of additional evidence by way of a local inspection commissioner.
My lord,
that was for what purpose?
I have several documents are there.
No,
which
you
has
wanted
been
local...
holding by the which has been holding by the appellant number 2. Appellant number 2, he has expired. That's why several documents has been going, my lord.
Please show us from the trial court judgment where this point was raised by you, that they have purchased before they became the owner. They have filed the suit before they became the owner.
But
at that point of time, they were co-owners. Were they co-owners?
Yes, my lord.
At that point of time, when the suit was filed, were they co-owners?
No, Anantakumar Maiti,
Ananta?
they have 2001.
No, in 1991 when the suit was filed.
Anantakumar Maiti was there?
No, this Vishnupada, he was not even a co-owner.
Yes, Vishnupada Mandal is the not Vishnupada Mandal purchased property from Madhav Maiti.
Vishnupada was a stranger to the property before purchase.
He was the tenant also. He was under the tenant of Madhav Maiti.
Vishnupada purchased from Ananta when? In which year?
That is sometimes in the year 1985, 86.
That is before 1991, before filing the suit.
Yes, before filing the suit. Before filing the suit, they have purchased their share, his share, from Madhav Maiti. But Ananta Maiti, that property has been finalized.
So in 1985, Vishnupada was already a co-owner of the property.
Co-owner of the property. Right.
Co-owner can maintain a suit for eviction.
Regarding against me, against Ananta Maiti, filed a suit. Vishnupada Mandal filed a suit against Ananta Maiti.
That was on a different context. That was challenging the sale. Rather, asking that was a declaration that it is an outright sale. Out and out sale, not a loan transaction.
Yes, that has been decided as an out and out sale.
So therefore, it's a sale. That sale was effected in which year?
Yes.
The sale which was challenged was executed. The sale deed was executed in which year? Sale by Ananta to Vishnupada.
Sale deed.
Sale deed.
Sale deed in the year 2000. That is, your lordship, kindly see my stay application. In the stay application, I have annexed the judgment of the 2001 judgment passed by the Honorable High Court. That is page 21, Annex P3. 30th December 2001, the judgment was delivered by the Honorable High Court.
When was the transaction entered into? Judgment was delivered by the High Court, but when was the transaction entered into?
Transaction.
What was the date of the transaction?
1998. That from the judgment itself, it appears that 1991, 98, the decree was passed.
The decree was passed in 98. When was the deed executed? In respect of which the decree was passed? Must have been earlier than 91.
Yes.
Plaint. Have you annexed the plaint, sir? Have you annexed the plaint? Have you annexed the plaint? Have you got a copy of the plaint? Please give us a copy of the plaint.
There is a big file. I can't brought it. only I am submitting.
Acha, very good.
Only I am submitting that kindly give me some protection so that from the rainy season my business will not be hampered.
It was Ananto's father's property, not our father's property. We cannot give
Ananto's father's property.
right. Relief even if we want to. If it was my father's property, I could have considered.
No,
I would have had a talk with
not my father's property.
Eighty-two, ওইটাই তো রিটটা তো 82 এগুলো রিলিফ দেবো আচ্ছা কোন পাতায় 34 রেজিগনেশন করতে হতো কত ইন্টারনেট ফিস 11 Deed was of 1982.
Yes.
1982 deed.
Deed.
Transfer was effected.
Transfer was made by Anantamaiti
in favor of Vishnu.
Vishnu.
In 1982.
1982.
Yes, page 11 of the appeal court judgment. And 82 to 80, 1982 to 1985, there were several transactions. And that issue has been dealt with by the trial court also. If you please come to page 11 of the trial court judgment. Have you got the trial court judgment with you?
Yes.
Please come to page 11. The pagination is at the top.
11.
11. Please come to the third line from the top.
Yes.
The judgment and degree passed by competent court and even by learned appellate court.
Degree passed by the competent court and even by the learned appellate court in a dispute regarding one impugned dated executed impugned deed executed in the year 1982.
Acha, please stop there 82 and please come to the last 4 lines of that page. Last 4 lines of
there
that.
was already executed the deeds in regard to the suit premises in favor of the plaintiffs in the year 1982 and 85. So it can be clearly gathered that the plaintiffs who had served notice to the defendant in the year 1991 for the eviction of the defendant from the
Therefore, eviction notice was given to you in 1991. Suit was filed in 1991.
1991 eviction notice was
and
issued.
they acquired title in the property in 1982 and 1985.
Yes.
Before filing of the suit, they had already title in the property. They obtained title, acquired title in 1982 and 1985, 2 deeds, and they filed, give you a notice and filed the suit in 1991. So at that point of time when the suit was filed, they had title in the property. So the first ground which you raised before us is a non-issue. They had title when they filed the suit.
But that has been challenged by Vishnu Mandal himself.
That challenge ultimately failed. He did not challenge that. His challenge failed ultimately.
Your Lordship kindly see the order of the Honorable High Court.
Ultimately, it has been held that it was an out and out sale.
Yes.
So that sale, the transfer relates back to the date of the sale deed. No, it was a sale. That's not an issue. Court has found that he has got reasonable requirement, finding of fact by both the courts,
Yes,
concurrent finding of fact by both the courts as to their reasonable requirement. First. Secondly, purchased by the plaintiff in 1982-85, irrespective of whether there was a suit or not. Ultimately, it was held that it was a sale.
Yes.
So the sale is of 1982-85. They issue an eviction notice and file the
1982 or maybe 1991 or whatever.
No, whatever will not do. 1982 and 85, that is the finding.
Yes.
And they issued their eviction notice and filed the suit in 1991. So they had title when they filed the suit in 1991. They proved reasonable requirement before both the courts, trial court and first appellate court, and an eviction decree has been passed against you.
That's
How
why
can we upset this?
That's why my thing, that's why the Honorable High Court had passed that order in the year 2001.
The suit was filed by Vishnupada himself.
Yes.
for a declaration that the transaction was a loan in substance and not a sale. How could Vishnupada file it? Ananta could have filed it.
Ananta Maiti should file it. Ananta Maiti should be filed by against Vishnupada Maiti.
Ananta Maiti was filed by the suit.
No.
Or the suit was filed by Ananta Maiti.
Suit was not filed by the Ananta Maiti. Filed by Vishnupada Mandal himself.
What was it? Have you got a copy of that plaint?
That earlier plaint.
Vishnupada's suit.
No, I don't have.
Then how do you know what the suit was for? How do you know what the suit was for?
I don't have any.
No, how do you come to know the suit was for what purpose? I mean, what relief?
No,
You have
you
made
know
submissions?
that come to the from the
yes
plaint. I came to know.
But you don't have a copy of the plaint. Oh,
No,
that's in the big bag.
Copy of the plaint is not here.
Very good. Let us see the narrative of the trial court. The court must have discussed the plaint case. Plaintiffs are spouses. They obtained by two deeds, 1980 to 85. Yes, your landlord Ananta filed the suit. How can Vishnupada file? Ananta, your case is before the trial court is that original landlord. Your landlord Ananta filed the suit challenging one of the deeds.
Challenging the deed.
Ananta filed the suit against Vishnupada, seeking a declaration that that was not an outright sale, it was a loan in substance. He lost up to this court. He lost up to this court. It was held by the courts that no, it was a sale, outright sale. So therefore, title of Vishnupada was settled by this court.
In the year 1982, 82 a sale deed was made. According to the court, my lord, I can understand the 1982, the sale was made.
Yes. So what are your grounds before us? One is that at the time of when these deeds were executed, he did not have title. You say this because the title was challenged in a suit subsequently. What is your other ground? Any other ground? No.
The section 6.2 has been said. This is the transfer property.
Achha. So section 6.2 that they have filed before the suit. This says that they cannot file within 1 year from acquiring the property. Section 6.2 says they cannot file. Oh, the 56 Act. नहीं तो 56 একটা ছিল তো আগের দিন 3 বছর ছিল ভুলে গেছি
And the other point is, my lord, when both parties has agreed.
Section 6.2 does not apply. My learned brother correctly reminded me. This was under the 56 Act. Come to section 13 of the 56 Act.
Of the old Act.
This suit was under the old Act. এটা বোধহয় প্রথম বইটা এটা বোধহয় এনঅ্যাক্টমেন্টটা হওয়ার পরে প্রথম লেডিস বাস
PA, এটা 13 CA, এটা কোন section? CA. হ্যাঁ, এখানে নেই অ্যামেন্ডমেন্ট না, এটা না বলবেন যে একটা কোনো ইয়েতে করে গরুর গাড়ি ফুল গাড়িতে করে গঙ্গায় ফেলে দিয়ে আসছে, এটাতে 56 অ্যাক্টের অ্যামেন্ডমেন্ট গুলো নেই। এটা বলবেন একটা গঙ্গায় ফেলে দিয়ে আসতে আমার নাম করে বলবেন, আমি দায়িত্ব নেব। এটা যেন কোনো জজ সাহেবকে না দেওয়া হয় চাইলেও, কেউ যদি চায় এটা তাহলেও যেন না দেয়। কতদিন? Yes, it was 3 years previous. So these are your two grounds.
Lord, another ground is, my lord, when we are both are agreed that 175 square feet, both party agreed that 175 square feet will give to me, and they may rebuild the total premises out of 1,000. They may rebuild.
Both parties agree. They are also agreeing.
Yes, my lord.
They are not agreeing.
My lord,
If they agreed, they wouldn't have obtained a decree against you.
yes, they are agree with in the appeal court.
They agreed in the appeal court. Then why was the decree passed
They were
against you?
agreeing in the appeal court.
That must not have reached a final form. If there was a final agreement, then the appeal would be decided on compromise.
My lord, what I am saying, my lord,
What are you saying? What are you relying on? What is that? We don't find any reflection of any agreement between the
my lord,
parties. Please,
no, this is the ground of appeal. This is the ground of appeal.
you are saying they agree that they will leave.
No, they agree. Both of them are agreed.
If they
Before
agreed, then
the-
why would the decree be passed against you?
Both of them are agreed that 175 will be
That is the
accommodated
agreement.
by me.
Show us the agreement.
No, the verbal agreement. The submission was made by the before the court. Submission was made before the appellate court that out of 1,175 square feet will be accommodated by the tenant, and the other portion, and they may rebuild.
Total area is 1,000 square feet.
1,000 square feet.
We don't find any such agreement or submission from the appeal court judgment.
No, they have. I've seen that.
Sorry, sir. We are dismissing your appeal. The present appeal has been preferred against a judgment of affirmance whereby both the trial court and the first appellate court decreed a suit for eviction filed by the respondents against the appellants on the ground of reasonable requirement for the purpose of rebuilding under section 13 of the West Bengal Premises Tenancy Act 1956. Full next para. Learned counsel for the tenants stroke appellants argues that although two deeds were executed in favor of the plaintiff stroke respondents in the year 1982 and 1985 respectively in respect of transfer of the suit property by the landlord of the present appellants, comma, the original owner, comma, subsequently there was a litigation in respect of the said deeds, and much subsequent to the institution of the present suit in the year 1991, comma, the issue was settled in favor of the present plaintiff stroke respondents. Full stop next para.
May I pointed out only one thing. You will also kindly see paragraph 19.
What does it say? What is that?
Amendment of the plaint. paragraph 19.
This is not plaint. This is your memorandum of the first appeal.
Yes, Hussain. Maybe. There is a suit filed by the Vishnupada Mandal, and that suit was dismissed for default, but that suit was not restored. Thereafter, they filed another suit in the year 1991.
তারপর থেকে যেখানে বললাম, Learned Counsel submits that since the transactions, since the character of the transactions in question by the original landlord of the appellants in favor of the present plaintiff stroke respondents being finally settled post filing of the suit, comma, it cannot be construed that at the time of filing of the suit, comma, the plaintiff stroke respondents had title in the property. Full stop. Thus, comma, the suit was bad from the inception, comma, in view of the plaintiff stroke respondents lacking title in the said property. Full stop. As such, comma, such defect cannot be cured subsequently. So next para, secondly, comma, Learned Counsel places reliance on section 6 within bracket 2 of the West Bengal Premises Tenancy Act 1997 and argues that in terms of the same, comma, if a suit is filed by a subsequent transferee on the ground of building rebuilding, comma, the same cannot be instituted before the expiration of a period of 1 year from the date of acquisition of the interest. Possibly in the present case, comma, the interest in the property was acquired by the plaintiffs much prior to the filing of the suit. Thus, comma, the suit is bad on such ground as well. Next para, thirdly, comma, Learned Counsel argues that a concession was made on behalf of both parties that the possession of the appellants would be retained in respect of 175 square feet out of the total suit property, and the building rebuilding would be done by the plaintiff's respondents in the rest of the property. Thus, comma, it is argued that the appeal or the present appeal ought to be admitted on the above questions. For the next para, however, comma, we are unable to agree, we are unable to accept any of the above contentions. For the next para, insofar as the transfer of the property was concerned, comma, the appellate court, first appellate court elaborately discussed the same. Full stop. As per the said observations, comma, by two deeds respectively of the year 1982 and 1985, comma, the original landlord of the present appellants transferred the suit property in favor of the plaintiff stroke respondents, comma, being spouses. Full stop. Next para. Subsequently, comma, a suit was instituted by Ananto, comma, the original landlord stroke transferor, for a declaration that the sale by him in favor of the present plaintiff stroke respondents was a loan in substance and not an out and out sale, hyphenated, out and out sale. For the next para, however, comma, the said suit ultimately culminated in dismissal, comma, thereby affirming the character of the transfer as an outright sale. Full stop. Next para, irrespective of the pendency of a litigation, comma, it was ultimately held that the transfer deeds of 1982 and 1985 conveyed the suit property in favor of the present plaintiff stroke respondents by way of a sale. Full stop. Thus, comma, as on the date of the filing of the suit, that is in the year 1991, comma, the plaintiffs already had title in the suit property by dint of the two transfer deeds dated 1982 and 1985. Full stop. The ascertainment of the character of the transfer by subsequent disposal of an appeal in respect thereof
does not automatically mean that the transfer itself was postponed till the final adjudication of the appeal. Full stop. What was decided in the litigation was only the character of the transfer, comma, the same having been effected contemporaneously with the transfer deeds themselves, that is in the year 1982 and 1985, comma, which was much prior to the institution of the suit. Full stop. Next para, thus, comma, the first contention of the appellant to the effect that the plaintiff's respondents did not have title at the relevant point of time cannot be is not tenable in the eye of law. So next para, insofar as section 6 within bracket 2 is concerned, you can take your seat. Insofar as section 6 within bracket 2 of the West Bengal Premises Tenancy Act 1997 is concerned, comma, the same is not attracted in the present case, comma, for the simple reason that the suit itself was instituted under the predecessor statute, that is the West Bengal Premises Tenancy Act, comma, 1956. Full stop. Next para, section 45 within bracket 1 of the 1997 Act repealed the 1956 Act. Full stop. However, comma, under subsection 2 of the said section, comma, all suits and proceedings under the 1956 Act pending at the commencement of the 1997 Act were saved from the purview of the 1997 Act. Full stop. Thus, comma, it is the provisions of the 1956 Act which are applicable in the present context. Full stop. Even as per section 13 within bracket 3 capital A of the 1956 Act, comma, there is a moratorium of 3 years from acquisition of a property by a transferee landlord for instituting a suit for eviction. Full stop. Next para. However, comma, in the present case, comma, the transfers were effected in favor of the plaintiff's respondents in the years 1982 and 1985 respectively, whereas the suit was instituted in the year 1991, comma, that is much beyond the moratorium period of 3 years. Full stop. Hence, comma, the said contention of the appellants also cannot be accepted. Full stop. Next para, insofar as a supposed concession on the part of the respondents' landlords regarding the appellants retaining a portion of the property, comma, we do not find any mention whatsoever in the impugned judgment of the appellate court to that effect. Full stop. Learned counsel for the appellants fails to produce any such document evidencing any such concession being given by the plaintiff stroke respondents. Full stop. Thus, comma, we are unable to accede to the said proposition as well. Full stop. Next para, in such view of the matter, comma, we do not find any arguable question of law, comma, let alone a substantial question of law, comma, involved in the present appeal. Accordingly, SAT 85 of 2026 is dismissed under Order 14 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2026 is also dismissed. No orders to cause urgency report. Sorry, you tried your level best. Next. এইটা ফেরত দিন। ওই বইটা কিন্তু বলবেন ওদের ফেলে দিন। সিরিয়াসলি ওই বইটা যেন না কাউকে দেওয়া হয়। Yes.
For the respondent, your lordship.
Yes, yes.
Section 5 was there, your lordship. For that reason, they have served the copy upon us.
Oh, you are the
respondent, your lordship.
Who is for the appellant?
Vijit Ganguly.
None appears goes out of the list. Although the respondent is represented through counsel, comma, none appears to move the application. Push up accordingly. Let the matter go out of the list. Respondent, you are for the respondent.
Yes, madam.
Yes.
One is
Take
your
a seat, respondent.
earlier directed to
file a supplementary affidavit explaining the delay.
Delay, yes.
Delay regarding, my lord, for date of the judgment.
My matter, my,
Out of the list.
and I just am outside. My lord.
Mr. Mukherjee, let us call the for that. Yes. 42 call for. Out of list করতে হবে। ওটা কেটে দাও। 42 5. Yes, 47.
There is a defective, my lord, out of time.
You were saved because you were there for the substantial part of the day.
Yes.
Yes.
There is a section 5, my lord.
What is the delay?
390 days.
390. Reason?
My lord, they have filed another suit, my lord, in the when they dismiss the earlier suit, my lord. As per instruction of the learned court, my lord, that's why the delay occurred.
Don't understand.
Paragraph 4. Wrongly that was filed, my lord. That
Instead of an appeal, you filed a suit.
it is, my lord, learned court, my lord.
Which court? Nodia?
Yes, my lord.
Filed a suit challenging the degree. On the ground of what? Fraud?
No, my lord, there is a dispute between the parties, my lord.
Yes, what do you say?
Regarding the days, means they have stated 390 days, but actually, your lordship find it is more than that. It is about more than 2 years, because your lordship, the impugned judgment was passed on 28th February 2024. And they have filed, your lordship, they have filed this memo on 17th of April.
More than 2 years. More than 2 years.
But they have stated about 380 days only.
But if they have explained the entire period, then the number.
And lordship, the entire period has not been explained. From the paragraph, lordship, the day-to-day limitation has not been explained. Only they have stated that
Day-to-day it is not required,
No,
but they have
not
to.
exactly day-to-day, lordship.
But they have to explain the period, entire period.
They have only stated that they have wrongly filed, and thereafter they have filed this appeal. But your lordship, regarding this appeal, they have filed a fresh suit previously, your lordship.
No, they have also not stated when they filed the suit.
Yes, your lordship. Nothing they have just no details. Have
And
been
they filed the suit in 2025. 511 means somewhere in the middle of the year.
2025. And it was passed in 2024
Yes, yes.
February.
Yes. No explanation for
my-
these
that-
two
that is
periods.
true, my
28th February 24 to 25 when you filed the suit.
My lord, this
First, secondly,
this is
you just say that without any delay file the second appeal.
This is transfer brief, my lord. I have not the learned.
Transfer the blame on the advocate when you dismiss previous advocate. We are dismissing it. Sorry.
For that reason only, my lord.
No, not for transfer brief. No explanation given at all.
That is a
This is, I mean, some rights have accrued in their favor also. Sorry, no.
এটা কি তোমাদেরকে ক্যাভিয়ার ফাইল করেছিল?
কপি স্যার সেকশন কপি দিয়েছো
কখন এটা কখন সার্ভিস হয়েছে? কিন্তু ফার্স্ট টাইম অ্যাপিয়ারিং। দিস ইজ ফার্স্ট টাইম
কপি দিয়েছো তো বাড়িতে দুবার গেছে কপি।
Otherwise, how did they point out para 4?
Yes, my lord. I don't know, my lord, how they have received the copy of the.
They might have stolen from the department also.
No, my lord, that is not.
But still the result remains the same. Result remains the same. No. The Can 1 of 2026 is an application for condonation of delay in filing the appeal. Full stop. Although it has been mentioned in the application that the delay is of about 390 days, learned counsel for the respondents rightly points out that the delay is of more than respondent that the delay is of more than 2 years. Full stop. Next para. Yes, even from the report of the additional stamp reporter, we find that the delay is of about 688 days. Full stop. Next para. From the application, however, we find long gaps in the chain of explanations. Full stop. Next para. For example, it has been stated that the impugned judgment and decree of the first appellate court was passed on February 28, 2024, whereas a title suit was wrongly filed challenging the same in the year 2025. Full stop. The number of the title suit has been given as 511 of 2025, which indicates that it was quite into the year that the said appeal was filed.
comma, without even disclosing the exact date of such filing. Full stop. Even proceeding on the premise that the suit was filed sometime in 2025, comma, there is a delay of almost 1 year in presentation of the suit itself, comma, which remains completely unexplained in the condonation application. Full stop. Even thereafter, comma, the said suit was allegedly disposed of on January 15, 2026. Full stop. The present appeal was presented on or about July 13, 2026. Full stop. Next para. The delay in between has also not been properly explained. Full stop. Next para. In any event, comma, it does not appear to be bona fide on the part of the appellants, comma, irrespective of the quality of legal advice obtained by the appellants, comma, that a suit was construed to be an alternative remedy of a second appeal. We could still have understood if the suit was filed challenging the decree of the trial court before a collateral forum on the ground of fraud or some other ground akin thereto. However, comma, filing of a suit challenging an appellate decree passed by a higher forum is not acceptable as a bona fide ground. Next para, in view of the above, comma, we do not find any plausible explanation for the delay in preferring the appeal after 688 days. Accordingly, can 1 of 2026 is dismissed on contest, thereby refusing to condone the delay in preferring the appeal. Consequentially, SAT 99 of 2026 is dismissed, stands dismissed as time barred. Can 2 of 2026 and Can 3 of 2026 are also dismissed consequentially. No orders to cause urgency report. Sorry. ফালতু ফালতু আজকে করতে হবে একই হতো Yes, Mr. Mukherjee.
Your lordship will have directed me to file a supplementary affidavit explaining.
Similar condemnation application?
No, no. Well, in the date of filing revisional application and my lord to before the then passing of the judge order of the court below. My lord, this is a delay of 62 days. My lord, kindly see my lord, this.
The revisional application was filed after
on my lord 4/12/2025. And my lord, 62 days delay for preferring this revisional application.
So, what is the nature of the impugned order?
Nature 26, my lord, custody of appellant is the father. My lord, custody of his daughter. My lord, regarding landed court, my lord, only allow to
And this appeal was filed when?
Appeal filed, my lord, on
24th of March 26. The revisional application was withdrawn or what?
Withdrawn, my lord.
When?
That section February, my lord. This is a section 5 application, my lord.
In the main section 5, we'll find
main
it.
section 5.
Section 5 is the appropriate order application, is the section 5 application?
No, no, no. The separate section 5 application.
Section 5, what is the appropriate order? We don't understand this practice.
To allowing my lord to the
allowing the appeal.
No, my lord. Allowing the father to my lord to.
Which paragraph of section 5, Mr. Mukherjee?
My lord, page 6, my lord. This is the order, my lord.
No. The order.
Page 6, my lord.
So you withdrew on 25th of June. Then you drafted and preferred the appeal on 24th of March. Reasonable. But the revision was also filed, but it was under 227.
227.
Yes, what do you say?
My name. This is a matter under family court.
No.
not Hindu Marriage Act. Hindu Marriage Act, my lord, there is a time limitation is 90 days.
60, brother.
Yes, my lord. My
Family code 60.
Yes.
60 days, family code.
90 days, my lord.
30 days, my lord. Family code is specifically 30 days, my lord. And there is a specifically Delhi court orders, my lord, that Hindu Marriage Act, there is a limitation of appeal is 90
No,
days.
family code sects. Family.
19 subsection 3, my lord. And my learned colleague, my lord, counting from for Hindu Marriage Act, my lord. The revisional application, the main order, my lord, for visitation, which was disposed on 11th June 2025. After that, the revisional application filed 4th December 2025. As per family courts act, there is a 144 days delays, my lord. And after when the revisional application dismissed, there is another 2-3 months delay, my lord. That's why now that is a more than 1 year. Now, my lord, I came to their explanation. My lord, I should not object on that matter, but for
Mother's illness.
illness, my lord, I do not have a single medical papers, my lord.
Advocate's mother illness. Advocate's mother is equivalent to
Yes,
advocate.
my lord, I accept.
We don't
that.
require a paper for that.
Yes, my lord, I accept that. But my lord, that date of delay is there another 67 days, my lord. That is totally mistakenly submitted.
Very good. We are allowing it. We are giving our reasons. We'll deal with your arguments. Can I শুরু করো? যে নাম ইয়েতে আছে তার নামই দিন। হ্যাঁ। The present, the application, no, sorry, this is CAN 1, CAN 2. CAN 2 of 2026 is an application for condonation of delay in preferring the appeal. First of the appeal has been preferred against an order passed under section 26, a final order passed under section 26 of the Hindu Marriage Act. First of next para, learned counsel for the appellant files a supplementary affidavit, which is kept on record. First up, relying on the supplementary affidavit and the averments made in the condonation application, it is submitted that initially a revisional application was preferred, bearing CO number 4230 of 2025, on December 4, 2025 against the present impugned order dated June 11, 2025. First up, it is submitted that the delay in filing the same was of about 62 days. First up, thereafter, upon growing wiser, the revisional application was withdrawn, since the petitioner was advised properly that an appeal would be maintainable, as opposed to a revision against the present impugned order. First up, next para. Thus, the revisional application was withdrawn on February 25, 2026, and thereafter the memorandum of the appeal was drafted and subsequently filed. Push up, next para. It is also submitted that in the interregnum, before filing of the revisional application, there was some delay on account of the illness of the mother of the learned advocate on record for the petitioner, who had to be hospitalized but subsequently recovered. Push up, next para. Counsel appearing for the respondent opposes the prayer for condonation and submits that contrary to the submissions of the petitioner, the delay of the appellant, the delay in preferring the revisional application has to be counted from the expiry of 30 days, which is the period of appeal under the Family Courts Act 1984, as stipulated in section 19 within bracket 3 thereof, and not 90 days as stipulated in the Hindu Marriage Act. First of next para. Secondly, thus, it is argued that the delay has not been properly explained on such count. First of next para. Secondly, it is contended that although the petitioner, the appellant has pleaded illness of the mother of the learned advocate on record, no documents in that regard has been furnished. First of next para. Thirdly, it is submitted that the delay in the interregnum in doing paperworks and preparing the appeal has not been properly explained.
So next para, upon a consideration of the averments made in the condonation application and the supplementary affidavit, comma, we find that initially an application under Article 227 of the Constitution, comma, numbered as CO number 4230 of 2025, comma, was filed against the impugned order. Full stop. Such mistake, comma, in our opinion, comma, cannot be ruled out as malafide, comma, since there may be some confusion as to whether the impugned order was to be construed as a final order under Section 26 of the Hindu Marriage Act, comma, as such, rendering the same appellable. Full stop. Next para. Although there was a delay in filing the revisional application of about 6 months between the date of the impugned order, that is June 11, 2025, and the date of presentation of the revision, that is December 4, 2025, comma, we take note of the fact that the limitation period stipulated for a revision under Section 115 of the Civil Code of Civil Procedure is not strictly applicable to constitutional application under Article 227 of the Constitution. Full stop. Next para. Although it has been construed by courts that such an application has to be filed within a reasonable period, comma, the said period has been construed differently at different points of time, comma, on some occasions to be 3 years within the contemplation of Article 137 of the Limitation Act, and on certain occasions to be a reasonable period in the assessment of the court. Full stop. Thus, comma, it cannot be strictly said that the application under 227 of the Constitution was itself time barred at the relevant point of time. Full stop. We have to consider that while filing a revisional application, comma, the revisionist petitioner does not proceed on the premise of the limitation for preferring an appeal, but on the premise of the limitation stipulated for filing such revisional application. Full stop. Next para. Thus, comma, the limitation period stipulated in either the Family Courts Act or the Hindu Marriage Act for preferring an appeal cannot be the determinant for assessing the bona fides of the appellant in preferring the revisional application under Article 227 of the Constitution of India. Full stop. Next para. Since the application was filed within 6 months, comma, we cannot say that in the form of an application under Article 227 of the Constitution, comma, the application was time barred. Full stop. Next para. Insofar as the illness of the mother of the learned advocate on record for the appellant during the interregnum is concerned, comma, in any event, comma, in view of our above observations, comma, the same is rendered irrelevant. Full stop. Even otherwise, comma, since it has been stated on oath that the mother of the learned advocate was ill, comma, we would have accepted the same as true on the strength of the affidavit supporting the said averment. Full stop. Next para. The delay in between withdrawal of the revisional application on February 25, 2026 and presenting the memorandum of the present appeal on or about March 24, 2026 is understandable, comma, in view of 1 month being a reasonable period for drafting and finalizing a memorandum of appeal and connected applications. Full stop. Thus, comma, we find sufficient explanation having been furnished for the delay in preferring the appeal. Full stop. Accordingly, Can 2 of 2026 is allowed on contest, comma, thereby condoning the delay in preferring FMAT 107 of 2026. The appeal is now taken up for hearing under Order 41 Rule 11 of the Court of Civil. Move it.
Only the point, this the trial court directed to only calling each day from 9 p.m. to 9.
You are the father, right?
Father.
Is there any divorce suit between you?
Divorce suit, wife, filed twice, 498.
No, that is a ground in the divorce suit. That's not a ground in custody. Divorce suit is pending.
Pending.
Who filed the suit? You have filed the suit.
The husband filed.
You have filed the suit that is pending.
This application in that connection, you have filed a section 26. What has been passed? You asked for outright custody and visitation.
No, custody, in weekend day, my contention is as per the law laid down by guideline framed by this Honorable High Court, that family
See,
court
that
should
is
have
not
considered-
binding. That is
No,
not
that
binding.
should have been considered. But this is not but we considered, that the our contention is.
As per that, what is the provision? What should be done?
Done, the weekend day, this is allowed, because
That cannot be an absolute mandate. It is entirely in the discretion of the court.
the court, but
What did you ask for? Every weekend or what?
every weekend.
Your
this-
fare is at page 20 of the appropriate order.
application, I annex the petition.
Yes, page 20 is the prayer.
Yes.
What is the age of the daughter?
The 7 years.
7 years.
7 years.
How long are you separated?
In
Can you say?
2-3 years.
2-3 years. Child has been with you all along. We'll come back to him. Yes.
allowing the petitioner to keep his daughter with him as her parental grandparents a few days during the Kali Puja and Devapali.
It was filed before a Kali Puja.
Before Kali Puja.
So that is over.
Allowing the
Visitation at least twice a week. Twice a week.
Twice a week at a place and time as very determined by the learned court.
Video calling every night. Child will.
Only
night if the father calls, it's very difficult.
Allowing the petitioner to keep minor child of the parties with the weekends and every holiday.
When did you file this application?
2024, this is a file
and you are separate from?
In 2023.
What are you doing for this 1 year? You did not ask for any visitation, you did not file any application.
Because the 498 case, and
what does that have to do with the custody application?
No, because that bail, obtaining a bail, the business
that was given by the trial. Let us see the implement order.
Trial court, page 7,
copy Family court gives certified copies on both sides of the paper.
Family court, this is a plain copy. Thereafter,
no, this is a certified copy.
Certified copy, already thereafter, I obtain and file.
This is not a certified copy.
Initially, this is not a certified copy. Initially, this is a
yes.
copy, then thereafter, certified.
Understood.
The petitioners, order,
the petitioner and his parents can exercise their visitation rights of the child by video calling each day from 9 to 9:30 each day, as well as by bringing the child to the court on the dates fixed for hearing. They should have preferred an appeal.
That is impossible to present a court the whole day.
Exactly, you understand. You are a reasonable. You must be a reasonable father also. What does your client do?
My client is a service.
Serviceman means he's in service or he's in the armed forces?
No. This is not.
Very well. Whatever. Every day 9 to 9:30 will be a pain for the child.
This is not allowing the mother or whole most of the day. This is a.
You are trying to give a lesson to the mother by.
No. But my prayer only holidays. The holidays. But holidays.
Every holiday the child can't be with you. And she has been without you for the last 3 years. Before that, she was with you also. So, what is the composition of your family? You have your parents are there.
Yes.
And who else? You, your parents, and
grandparents also.
Your grandparents are also there. What is your approximate age? Your clients?
My age is 45, 46.
Very well. What should be a reasonable? Some visitation has to be given.
Yes, but some visitation has to be given. First,
child to the court for hearing days.
Yes,
obviously.
Each and every day bring the child in court premises.
Court premises is not a congenial place.
Previous order, my lord. kindly give a look to page number 6, my lord. There is a order of 5th May 2025. The order in courts of hearing, it is appeared to this court that when the petitioner and the parents went to respondent residence for exercise their visitation rights of the child in view of
Understood. There is some acrimony.
yes, some
Understood. Understood. Not your home, not his home, but somewhere. Where do you reside with the child?
my lord, Barupur.
Baripur. You reside where?
In
Salt Lake.
Salt Lake.
Salt Lake. So you go to Baripur and some public place near their residence. That we are thinking of the child, not of the mother only. The child particularly. Child cannot travel all the way. So you go there. You can agree to a common place. You can agree to a common place. And what should be the visitation frequency? Tell us.
Twice in a month or
But twice in a month.
Twice in a month is very reasonable. Twice in a month, say.
my lord, the child has hyperactivity, which is nearly autism, but not
Is she
properly
being treated
autism.
for that? Is she being treated for that?
Yes, ma'am. And the father never ever called the child even on a video calling.
Mr. Mukherjee, we are telling you, he has not been video calling.
Not video calling.
No,
but
he has got a right. He has got the right from the court. That was what he was after.
but he
No,
has
Mr. Mukherjee is reasonable. Mr. Mukherjee is not insisting on it.
medical.
Very well. We can
duties of
occasionally permit you to have video calls also. Say once a week you can have a video call. Once a week we'll permit them to have a video call. The period of the video call will be decided only by the child. We are making this thing first twice a month, every alternative Saturdays. So alternate
Saturdays must be better.
Huh?
Saturday,
Sundays,
maybe-
whatever suits the child. Alternative Sundays, say between 3 and 5 p.m. Obviously. Acha, one. Secondly, video call duration decided by child once a week. Visitation where? Common place, Barupur, public place.
Lani Advocate's chamber. His her chamber.
Has she done some?
Not my chamber. My chamber isn't done.
Has she offended you in any way or done some wrong to you? No. Where is your residence, Mr. Mukherjee?
City.
City. No, your residence is near Barupur.
No, my lord, Dalla, Boranogo.
So City is a better place.
No.
So public place at Barupur, it has to be congenial to a child. We are putting it in our order today. We are admitting the appeal. We are putting it for passing final orders on a given date. You take instruction, both of you. Please try to agree to a common place in Barupur, which is congenial to a child. We are indicating this in our order. So that you can use this order to get instruction from your client. In view of questions of law and fact being involved, we admit the appeal. Which of next para? The bone of contention between the parties, comma, who are spouses with a strained relationship and a divorce suit between them, comma, is custody stroke visitation of the minor daughter of the parties, comma, who is aged about 7 years. Which of next para? By the impugned order, comma, the learned trial judge permitted the appellant father and his parents to exercise their visitation rights by video calling each day from 9 to 9:30 p.m. as well as by the child being brought to the trial court on the dates fixed for hearing from 11 a.m. to 2 p.m. Puts up next para. Learned counsel for the appellant submits that the hours and days of visitation are not commensurate with the prayer of the appellant. Puts up from the application for custody made in the custody stroke visitation made in the trial court, comma, we find that the appellant father sought to retain his daughter with him during the Kali Pujo stroke Deepavali vacation and thereafter, comma, to visit the child at least twice a week at a place and time as determined by the trial court, comma, to contact the child over
video conferencing every night at least for 15 minutes, and for keeping the child on weekends and every holidays, and at least for 1 week during long vacations. Full stop. Next para. Learned counsel for the respondent mother submits that the appellant father, in any event, does not exercise the right given to him by way of having video conference calls with the child. Full stop. Moreover, it is submitted that the child is being brought regularly to the trial court as per the direction of the trial court. Full stop. Upon hearing learned counsel for the parties, we find that the direction on the parties that the appellant father would call the child every night between 9 and 9:30 p.m. is not only arbitrary but a bother to the child herself. Full stop. Being compelled to talk with her father between fixed hours every night can be detrimental to the well-being of the child, and as such, we do not approve of such direction. Full stop. Video conferencing calls, if any, and the timings thereof can only be decided by the child and not by the concerned parent. Full stop. Next para. Secondly, in our opinion, upon a consideration of the arguments of the parties, a visitation right for the father of the child every alternate Sunday between 3 and 5 p.m. would be a viable option. Full stop. Learned counsel for the parties, in their usual fairness, do not principally oppose such proposition. Full stop. Next para. Hence, we request learned counsel for the parties to take instruction from their clients in the light of the following broad bullet points of our proposed order. Roman 1. The appellant father shall visit the minor daughter of the parties between 3 and 5 p.m. every alternate Sunday at a public place congenial to the well-being of the minor child near about the residence of the respondent mother, with whom the child is now residing. Roman 2. The appellant father, the appellant father and his parents. His parents will also be able to. Next, Roman 2. The appellant father and his family, including his parents, will be entitled to video call the minor daughter of the parties once a week for on the appointed date and during the duration, both of which shall be decided by the child beforehand. Full stop. Roman 3. That apart, the appellant will be at liberty to make appropriate application on occasions before the trial court seeking custody of the child for a limited period during the long vacations of the child. Full stop. However, if such application is made, the same will be decided by the learned trial judge on merits upon hearing both sides and taking into consideration the outcome of the visitations which appear in the interregnum prior to such disposal. Full stop. Prior to such disposal and the impact of such visitation on the child. Full stop. The above arrangement is proposed to continue during pendency of the matrimonial suit between the parties. Full stop. Next para. In order to ascertain the venue of visitation by the appellant father on every alternate Sunday, learned counsel for the parties are requested to attempt an agreement between the parties to the venue and submit the said agreed venue before us on the returnable date. Full stop. In the alternative, both parties shall suggest their venues of choice subject to the decision of this court. The matter shall next be listed on when should you keep it, what will be a reasonable time for you to think.
Your clients will only require a day or two to ascertain which is
Next Monday,
next Monday. Very well. The matter shall next be listed on August 3, 2026.
Monthly listed date.
Some other day.
Day of monthly list.
Month is not difficult. It will appears to be mentioned. Under the heading to be mentioned for passing final orders. আচ্ছা আরেকটা লাইন অ্যাড করি the parties and all concerned shall act on the server copy of this order without insisting upon prior production of a certified copy. You use the certified copies, server copies with your clients. Next.
Number 4. Lord, is the appellant before your lordship? There are some defects. Yes.
What are the
There are some defects. Lord, the defect is with respect to the mismatch of the names, Lord, in the trial court's decree with the appeal court's decree. Lord, those can be explained because subsequent transfer has been done.
You cannot cure those.
I have, Lord, I will have to cure only one defect.
What is that?
Lord, some of the names, Lord, have been incorrectly, Lord, basically typographical error.
So we'll give you leave.
Yes, 45.
Have you checked up the other defects?
Lord, other defects, Lord, I'm told
regarding
এটাই তো ছিল আগে আছে
first defect is it continues over 3 pages. Certified copy. Appellant numbers 1, 3, 6, 7, 13 and 14 are not parties in the learned appellate court. What about that?
In the decree, Lord,
you have to reconcile those issues.
Yes, Lord, kindly comes to the decree of the appeal. Lord, the first name is Alam Hussain. That's one ko. But what I understood is not only the mismatch with the trial court record with the appellate court records.
Achha, let us see. Your 1, 3, 6, 7 and 13 and 14.
One is Alam Hussain.
Wait a minute. Alam Hussain.
Yes. Now, Lord, one go there is Goel Sheikh. So, Lord, that is appearing as item number, respondent number 3 here.
So 1 tallies.
Yes.
3 is Sohel. Sohel also tallies.
Yes.
Exactly same spelling, no difficulty. 6.
This your lordship will find one gho, Lord.
Yes. People. Mr. Kormakar, it's difficult to, will seek a revised report and will ask the stamp reporter to give a notice to you and hear your advocate on record. It's better. We'll direct the matter to appear on a particular date because it's not your fault. We find.
And Lord, kindly also grants me liberty, Lord, to make that typographical error correct.
Yes. On the prayer of learned counsel for the appellant, leave is granted to the appellants. Leave is granted to the learned advocate on record for the appellant to rectify the memorandum of appeal to cure the defects which are curable at the instance of the said learned advocate. Who is of next para? However, from the report of the additional stamp reporter dated May 21, 2026, we find several infirmities therein. For example, the first point of the said defect list indicates that the names of the appellant numbers 1, 3, 6, 7, 13 and 14 do not appear in the first appellate court, whereas we find the converse to be true, at least in respect of some of the said appellants. The stamp reporter is directed to write a revised report on a careful scrutiny of the records. In the event of any doubt on the part of the stamp reporter, he will give a prior intimation to the learned advocate on record for the appellant to seek clarification in that regard. Such intimation may also be given informally over the
mobile number of the said learned advocate on record as given in the memorandum of appeal. Such exercise shall be completed by the additional stamp reporter within a week from date. The matter shall next be listed along with such revised report under the same heading on August 5, 2026, 5th August.
5th August. Not 5th August, not perhaps your lordship does not take up. Not
No, we have changed that because we are already we have 7 CAVs in 3 days. So we are hearing finishing the hearing of the appeals more quickly than we anticipated.
From tomorrow onwards, not the regular order
Yes, we have
41
indicated that in the
application
list
will
today
continue.
Today itself we have indicated. Wednesday is removed from the hearing day.
Very.
Number 45.
Yes. And your erstwhile senior also pointed out that the application should be devoted more time.
Why asked by him? Not he's my senior. He
No,
remains
you
my
are now
senior.
his senior. Mr. Ghosh will vouch safe for that. Yes, Mr. Ghosh. Dafun, 45. Yes, Mr.
There
Section
is
5.
delay, my lord, of 29 days.
You are appealing for the other side?
Lordship, may it please your lordship. Lordship, I am appearing on behalf of the respondent, lordship.
Yes, you are there. Yes, what about the delay? What is the ground, Mr. Ghosh?
Lord, this property belongs to a charitable trust.
Difficulty in the family?
No, my lord, property belongs to a charitable trust.
Yes.
And my lord, after the decree was passed, my lord, after the impugned order was passed, my lord, the entire body of my lord, trustee, my lord, met together, and in doing so, my lord, some days, my lord, elapsed.
Yes, in para 12 you say difficulty in the family of the trustee whose absence was, that's why you say difficult. Mr. Sharma could not take any decision in the absence of other trustee, Mr. Karia, who at that point of time was in difficulty in the family. Yes, what do you say to the 29 days delay?
Lordship, may I just humbly pray, Lordship, that today the matter comes under the heading for correction. So I was under that impression that there are certain. Yes, Lordship. Defect and correction. That was.
No, the heading is Order 41, Rule 11.
Order 41 rule in the heading, Lordship.
Along with the application.
Along with the application, Lordship, that
what
tag
for
is
correction?
showing.
For the first time,
Defective out of 45 is 45.
Yes.
Defective out of time is the nature of the application, nothing else. It's appearing under the Order 41 Rule 11 hearing.
Yes, Lordship. That was
what are you
my
saying?
mistake, Lordship.
No.
Lordship, only one intelligence.
No, we can't grant you time. 29 days delay, you have been
only
served.
one day, Lordship. Only one day.
No
only
question
one
of
day.
one.
Lordship, kindly, Lordship.
Mr. Ghosh is sitting from the morning. You should have mentioned that in the morning.
Lordship,
This is a ridiculous excuse you are making.
No, Lordship.
Correction word is
my...
not written anywhere. It's appearing under the Order 41 Rule 11 heading. Everybody knows it's Order 41 Rule 11.
What I have been instructed by the on-record advocate, Lordship, that's what I'm
you are so senior, Mr. Das, that you are relying on an advocate on record to follow the list.
No, sorry.
Wait for a few more years, Mr. Das. You have to wait for a few more years for that.
I am sorry. I'm extremely sorry. I'm
the
tending
Ghosh is there from the morning. He's a little bit senior than you.
Lordship, I'm tending sincere apology, Lordship.
We are
kindly one day accommodation.
I mean,
Lordship, kindly only one day.
No, 29 days delay. We won't grant you time on that. Sorry.
Lordship, if
on the ground which you made out before us, if you are truthful, you are not prepared in the matter, we could have granted
He is much more interested because most of third party is occupying the property.
No, one this time maybe. What do you do, Mr. Ghosh? What is the appeal against?
Appeal against Order 21 Rule 101.
Oh.
I got a degree, my lord. Put the same into execution. Make a prayer for police help.
There is no scope of interim order here?
My lord?
No scope of interim order even if you admit the appeal?
No. But I will pray, my lord, for expeditious order for hearing. Now, this is very
informal
short matter, my lord.
Informal paperbooks and all. We'll direct you to prepare informal paperbooks, including all the papers.
Because, my lord, they filed an application under Order 21 Rule 101. And, my lord, claiming, my lord, that they are in adverse possession of the property.
That has been allowed. You are the decree holder.
And, my lord, 101, my lord, requires, my lord, the entire claim of the register should be decided in the same proceeding.
Yes.
But without entering into that, my lord, they have diverted me to the earlier suit in which I got the degree.
You are the decree holder.
I am the degree holder.
No time. We are admitting the appeal. Allowing-
Lordship, kindly, Lordship. Only
No.
one day, Lordship.
An adjournment is
Otherwise-
sought on behalf of the respondent numbers 1 and 2. Full stop. However, comma, since advance notice was given to the contesting respondents 1 and 2 of the pendency of the matter, and copies of the applications has also been served on him, comma, such prayer is refused. Full stop. Can 2 of 2026 is for condonation of the delay of about 29 days in preferring the appeal. Full stop. On a perusal of the amendments made in the application, comma, we find that there were issues in the family of one of the trustees, comma, whose presence was essential for taking a decision as to preferring the appeal. Full stop. Upon a perusal, upon a consideration of the said averments, comma, we are satisfied that sufficient explanation for the delay has been furnished. Accordingly, can 2 of 2026 is allowed, thereby condoning the delay in preferring FMAT 123 of 2026. Full stop. In view of the appeal being preferred against the decree holders against an order passed under Order 21 Rules 97 to 101 of the Code of Civil Procedure, comma, questions of both fact and law are involved in the appeal. Full stop. Accordingly, the appeal is admitted to be heard on the grounds taken in the memorandum. Full stop. In view of the appearance of the respondent numbers 1 and 2, you are appearing. Respondent numbers 1 and 2, comma, who had the primary contesting respondents, comma, service of notice on the said service of notice of the appeal on the said respondents is dispensed with. Full stop. Since the reliefs defendant pro forma opposite party did contested that. Since the dispute in the present appeal is between the decree holders and the third party judgment obstructors, comma, the pro forma respondent number 3 does not have any role to play as a judgment debtor in the appeal. Full stop. Accordingly, service of notice of the appeal on the pro forma respondent number 3 is dispensed with. Full stop. The appeal be treated to be ready as regards service. Full stop. Next para. The application, what is the appropriate order for early hearing? Oh no, occupation charges. We'll fix this along with the appeal.
Is there application? Interim application? Yes.
You asked for occupation charge. But it's the reverse. It's your appeal.
Occupation.
Trial court records will be necessary.
Not necessarily, my lord.
Evidence was laid.
No.
Achha. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks from date, and circulate advance copies of the same on the learned advocate for the respondent numbers 1 and 2. Full stop. Since limited questions are involved and no evidence was laid in the executing court, comma, trial court records need not be called for. Full stop. However, comma, the appellant shall incorporate all the relevant documents which were before the executing court while passing the impugned judgment in the informal paper books. Full stop. The appeal be listed for hearing in the monthly list of September 2026. Along with can 1 of 2026.
Grateful, Lordship. And so sorry for such inconvenience, Lordship.
Yes. Next. Yes.
My appeal, second appeal, my lord, the first, I am the tenant. The first appellate court dismissed the landlord suit. Sorry, the trial court dismissed the landlord suit. My lord, the landlord took it in appeal. And then, my lord, the first appellate court reversed. I am the tenant.
Landlord suit was?
Landlord suit was filed against me.
Dismissed.
Dismissed. First appellate court reversed their decision and has, my lord, directed my eviction.
Suit on the ground of?
Suit, my lord, was on numerous grounds. Like, for instance, my lord, structural changes.
Premises tenancy.
Yes, premises tenancy.
What ground was ultimately accepted by the first?
Subletting. So, my lord, I'll just summarize. My lord, there were numerous grounds, almost all grounds under Section 6. On all grounds, my lord.
Forget those grounds. Only we are interested in the ground which was accepted by the appeal.
Dismissed. Now subletting.
Satisfy us on only that.
Yes. Now, my lord, on subletting, my lord, the trial court, my lord, held that there is no subletting. The subletting has been, my lord, decreed on account of, my lord, a merger. A merger.
You have a knack of coming at the last few minutes of the day. on other day also same thing happened.
No, that time your lordship was rising, my lord, for the noon break.
Oh no.
That was a noon break.
We don't know whether it will be over. 1 minute is
At
left.
least, my lord, my sleep wasn't ruined that day because of the gap. Today,
কালকে এই ম্যাটারগুলো তো থাকছে। We'll not take up hearing matters Wednesdays now. We'll continue with these matters. So we'll take it up in normal course tomorrow.
No difficulty, my lord.
Due to paucity of time, we are recording one order.
I'm so grateful.
Due to paucity of time, the matter cannot be concluded today. Full stop. Accordingly, let the matter be listed tomorrow under the same head. Ash. Taken. In 1 minute, you can't dispose of any order for turn. Come back to.